Permission, madam.
If I may submit.
No hearing on my memos, please give it. And we are also noticing sometimes you move the memo, you will not be present. In such cases, we say that despite moving any memo, they shall not be listed on the other than the given date. Okay. Give the memos, they will list it.
My lords, if I could make a request. My lords,
List number 2, serial number.
List after 2 weeks anta ಮಾಡಿ ಹಾಗೆ.
if I make a request. This RFP have come to a compromise.
Madam,
My lords, the respondent is a 91-year-old lady and she wants to come to court specifically tomorrow. But the matter may be listed.
My lord,
There is an urgency in this matter, my lord.
Settlement.
This is family court matter. The husband has obtained ex parte decree suppressing the facts, my lord. Now he is trying to remarry, my lord. My rights will be defeated if.
When the decree was passed? One second.
My lord, in the year 23, my lord.
Huh?
I got to know very late, my lord. I have filed a restitution in Bangalore. Husband has obtained a divorce in.
Correct. We are asking you when that decree was passed.
My lord, in the year 2023, in the month of November, my lord.
ನೀವು ಡೇಟ್ ಹೇಳ್ಬೇಕು ನಮ್ಗೆ ಅಷ್ಟೆಲ್ಲ ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ we will not list the matter.
I
You
apologize.
will not bring the file in your hand. We will not be. There will be no seriousness, and you start
My humble apologies,
spending
my
5
lord.
minutes to 10 minutes in memos.
My humble apologies, my lord. If I may request for tomorrow, my lord, I will come prepared.
Already ಬರುತ್ತೆ memo.
Wait for me.
ಮೆನ್ಷನ್ ಮಾಡಿ
ನಾಳೆ.
ಕೊಟ್ಟಿರಿ.
my lord, similar thing happened, my lord.
ಹೋಗ್ಬೇಕು.
My lord, similar thing happened, my lord. 28 was given date, my lord.
ತಗೊಂಡ್ ಕಳಿಸ್ಕೊಡಿ.
My lord, 2:30 AM, my lord. The authorities have come up for taking possession, my lord. That is the extreme urgency, my lord.
ಅಲ್ಲೇ ಆ ಕೋರ್ಟ್ ಮುಂದೆ ಮೆನ್ಷನ್ ಮಾಡಬೇಕಿತ್ತು ಅರ್ಜೆಂಟ್ ಇದೆ ಇಂಥ ದಿವಸ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ
My
ಹೇಳಿ.
lord,
Next.
when there's urgent,
Your lordship,
my lord.
adjournment. Lordship, I make a mention, your lordship. It's an RFA matter, your lordship. It's a fresh matter, your lordship. Our property has been stuck due to the order of the lower court, your lordship. If your lordship may have it tomorrow, your lordship.
Which is that case we are mentioning? Is it now we'll go by page wise?
Adjournments,
My lords,
page wise.
I can make one more request, my lords. This is regarding the matter where the 91-year-old lady has to court tomorrow.
You said tomorrow, no?
Please, my lords, if a time can be fixed,
At 2:30 minutes.
grateful, my lords.
The settlement.
Mention ಮಾಡಿ
Lordship.
See, the matter will be listed. You can seek a passover till she comes. Yes,
Please, my lords.
right?
Lordship,
Great.
submission, Lordship. MFA 8752, Lordship, I have given to court officer. Memo, Lordship, the great urgency is there. Attach the property, Lordship. Sir.
Next.
Kindly have it on tomorrow.
Adjournments, page wise. Page 1, seal number 1. Page 2, seal number 2 and 3.
1 week time.
Page 3, seal number 4 and 5. Page 4, seal number 6. Page 5, seal number 7 and 8.
44 serial number, part.
Page 6, seal number 9 to 13. Page 7, seal number 14 to 16. Page 8, seal number 17 to 21. Page 9, seal number 22 to 25. Page 10, seal number 26 to 28.
My lord, 28, my lord. I'm for appealing. Pray for 1 week. Senior. 28.
Respondents, you are for the respondent.
No, I'm for appealing.
Appellant. You
28.
represent respondent. Have you informed them?
I'm for the
ಆಯ್ತಾ ಕೊಡ್ಬೋದಾ? Which respondent you represent?
1 and 3.
You are contesting
1 and 3.
respondent or
Contesting.
contesting respondent. 2019 ಇನ್ನು admission ಅಲ್ಲಿ connected cases ಅಲ್ಲಿ ಏನೋ compliance ಇದೆ ಅಲ್ಲ? 19, there is some compliance in the connected matter. We'll list it after seeing that Shivaram Bhatt. No, ಅದ್ರಲ್ಲಿ ಏನೋ compliance ಇದೆ. Yes.
Page 11, seal number 29 to 34.
1 second. Court ಹೇಳಿ ಈಗ connected cases ಇದ್ರೆ ಯಾವ್ದಾದ್ರಲ್ಲೂ ಒಂದ್ರಲ್ಲಿ ಈ ತರ compliance ಇದ್ರೆ it should come in the orders matters, not admission matter. Yes.
Serial number 31st.
Vacating status quo. Somebody has moved this matter. Who has moved it? Then we'll not adjourn it. Our absence will be, yes.
Page 12, seal number 35 to 39.
Your Lordship 39, serial number 39, Your Lordship.
39.
Lordship, serial number 39, appear for the appellant, Your Lordship. Lordship, I seek one-day accommodation, Lordship. Kindly have it on tomorrow,
39.
Lordship.
39 further hearing.
Further hearing, Lordship.
You were
Senior,
only pressing this matter.
Your Lordship,
Appearance
actually,
counsel.
senior, Lordship, senior went to his daughter admission, Your Lordship, today.
You are very
So kindly have it on tomorrow,
You are
Lordship.
pressing this matter.
Yes, Lordship, kindly have it on tomorrow, Lordship.
Why don't you mention in the previous hearing date only, you make us to read and again seek adjournment.
Your Lordship, actually, senior or daughter admission goskara ಆಚೆ ಹೋಗಿದ್ದಾರೆ,
You could
Lordship.
have moved a memo for adjournment or not to list ಅಂತ ಮಾಡ್ತಿರ್ತೀರಲ್ಲ, ಅದ್ ಮಾಡ್ಬೇಕು.
Your Lordship, kindly have it on tomorrow, Lordship, at the request. Kindly tomorrow, Lordship. I won't take any adjournment tomorrow.
Arbitration, either the Pandapura. ಇವ್ರು ಮಾಡಿ. ಆಯ್ತು, ಅದ್ರ ಹಾಕ್ಕೊಳ್ಳಿ. As requested by Appellant's counsel, list tomorrow. Is it a-
Great, much obliged, Lordship.
30? ಅದ್ರಲ್ಲಿ ಏನಿರುತ್ತೆ ನೀವ್ ನೋಡಿ
ಇಲ್ಲ ಸರ್,
will issue notice
ಅದ್ರಲ್ಲಿ
ಅಷ್ಟೇ.
ಪಾರ್ಟಿಗೆ ಹುಷಾರಿಲ್ಲ ಸರ್, ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಬೇಕಾಗಿತ್ತು, ಈ 3 ಲಕ್ಷ ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀಸ್ ಕಟ್ಬೇಕು.
ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ 38.
ಅಲ್ಲಲ್ಲ, ಇದು
38 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
ಪ್ರಾಪರ್ಟಿ
38 ಅಂತ ಹೇಳ್ತಾ ಇದೀರಿ. ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ ಅದು.
ಇಲ್ಲ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅನ್ಸುತ್ತೆ. ಕೇಸ್ ನಂಬರ್ ಏನು?
ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Page 13, seal number 40 to 42.
This is first this matter.
Page 14, seal number 43 to 45.
My lord, serial number 43, my lord. 43, my lord. Appear for the appellant, I have informed Mr. Sunil, refer a 2 weeks accommodation. My lord. 2 appeals are there.
IA1 for additional documents, senior. When do you want it?
But after 2 weeks, my lord,
You-
both the matters.
You were the plaintiff. or-
Yeah, I was the defendant. He also filed an appeal. I also filed an appeal, my lord. I have informed Mr. Sunil, my lord.
ಯಾಕೆ?
I have to get ready some more documents, my lord.
ವೆಲ್ ಅಪೀಲ್ 2019 ಸೂಟ್ ಯಾವ ಇಯರ್ದು?
So to,
ವರ್ಷ ಆದ್ಮೇಲೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಐ ಹ್ಯಾವ್ ಟು ಫೈಂಡ್.
ಇಲ್ಲ, one
ಫೈನಲ್
one-
ಇಯರ್
First
Ah.
ಅಷ್ಟೇ ಕೊಡ್ಬೇಕಿತ್ತು.
finally rang matter.
ಆಸ್ ರಿಕ್ವೆಸ್ಟೆಡ್ 2 weeks ಇಲ್ಲ ನೋಡಿ ಹಾಕೊಳ್ಳಿ. Because other side is also not.
I have informed, my lord.
34-9.
Please.
24. Yes.
44, my lord. 44. Ashwatthana is not feeling well, 1 week will be granted. Other side we informed to the.
Adjourned for request of appellant's counsel. Yes.
Page 15, seal number 46 to 49.
Appearing for serial number 46, my lord. Appearing for the respondent, 1.
Appellant, last time also they've sought for time, repeatedly they're seeking time.
They are for the appellant. Yes.
I'm for the appellant.
I'm for the R2.
Who is seeking adjournment?
This time R1 is seeking adjournment, my lord. Senior isn't feeling well. He has viral fever. So if a week's time may be
Hospital
granted.
senior can't come ಅಂತ.
ಅಲ್ಲ.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ they said some other, every time they've been seeking adjournments, your lordship.
What is that matter?
It's a suit where the arbitrator had decided in favor of the appellants, decreeing, awarding the.
For reverse by under section 34.
34, yes, 34 only on beyond the scope
Of
prescribed.
which year the arbitration?
2006 ಇದು sale agreement ಇದೆ.
ಇನ್ನ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. As requested by the counsel for respondent number 1 as a final chance, list on.
My lord,
Next week,
kindly
if it can be taken at
request
2:30.
19, 19-9.
I'm appearing for the R2 and requesting for 2 weeks' time because we've engaged a senior counsel.
Cases 2006 to 2024. And what is the fun in that?
Two
Date.
weeks' time.
Sorry,
12-9.
you can argue.
This 2:30.
Date ಹೇಳು.
12-9.
12-9.
2:30, your lordship, if it can-
ಅಲ್ವಾ? 2:30 ಅಂತ? 2:30.
Page 16, seal number 50 to 53. Page 17, seal number 54 to 58.
Serial number 56, my lord. I am appearing for the appellant. Press time for 1 week for the respond.
ಆಗ್ಬೋದಾ?
Please.
Then at the request of the
Wait,
appellant's
wait,
counsel, 2022 all right. Yes. ಏನ್ ಎಕ್ಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
Dismiss ಆಗಿದೆ. List after 2 weeks ಆಯ್ತು. As requested list by the appellant's counsel, list after 2 weeks.
Yes, page 18, cell number 59. Page 19, cell number 60. List number 2 for non-compliance, first time, cell number 1 and 2.
Item number 8, number 8, I am seeking 3 weeks time to comply the office objections.
3 weeks. ಯಾಕೆ?
Item number 8, cause list number 2,
Why 3 weeks? What is
item
the
number
purpose?
2 weeks at least to
2
comply the
weeks
office.
ಕೊಡ್ತೀವಿ. ಇದ್ರಲ್ಲಿ 1 and 2.
ಐಟಮ್ ನಂಬರ್ 2
Item 8,
ಟೋಟಲ್ 74 ಸಾಹೇಬ್ ರಜಾ ಇದ್ರು ಸರ್. ಟೋಟಲ್ 20 74 ಸಾಹೇಬ್ರ ಇನ್ಚಾರ್ಜ್ ಅದನ್ನ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಬರ್ದಿದ್ದೀನಿ ಸರ್. ಎರಡು ಸೇರಿ ಬರ್ದಿದ್ದೀನಿ ಸರ್. ಅದು ಆಫೀಸರ್
ಕಂಪ್ಲೈನ್ಸ್ ಅಂತಾನೆ ಇದೆ ನೋಡಿ ಎಲ್ಲಿ ಹೋಗಿ ವೆರಿಫೈ ಮಾಡಿ.
ಪ್ಲೀಸ್.
item 8, my lord.
ಫಸ್ಟ್ ಆಯ್ತು 1 2 1 2
Item 8,
ಆಯ್ತು 2 weeks ಕೊಡ್ತೀವಿ. ಎಷ್ಟು ಸರಿ ಹೇಳ್ತೀರಾ?
oblate.
1 to 12 ಎಲ್ಲದರಲ್ಲೂ 1 to 12 2 weeks time is granted to the need.
Seal number 1, I pay for the appellant, my lords. I pay for 2 weeks time to comply with the offer.
But we said 1 to 12 2 weeks.
I'm sorry, ma'am.
Third time, non-compliance, cell number 13 to 26.
Seal
Third
number
time
14, my lords.
13 to 26.
13, my lords, for the appellant.
Serial number 18.
Do the needful.
To 26.
Serial number 19, my lord, appear for appellant.
ಸೀರಿಯಲ್ ನಂಬರ್ 20.
2 weeks time is 10 days.
Serial number 17 and 18, my lord.
ಇಲ್ಲ 2023. Finally 2 weeks time is granted to do the needful, failing which the appeal shall stand dismissed. 13 to 26.
My lord, serial number
Needful
13 and
is not
14, my
done
lord.
within-
13 and 14.
What we said, only judge has a duty of hearing, lawyers have no duty of hearing.
Sorry,
We
my lord.
said 13 to 26.
List
Yeah.
number 2,
Weeks time
sir.
is granted to do the needful, failing
Oh,
which the
I'm
appeal
sorry,
shall stand
sorry.
dismissed.
I was under the impression first list is calling.
27,
sorry.
fourth time.
Fourth
27
times.
to 27 to 33, fourth time. Nobody in those cases.
30.
Wait, ಮಾಡಿ ಅವ್ರು ಹೇಳ್ತಾವ್ರೆ ಯಾಕೆ ರೀ ಮಾಡ್ತೀರಾ?
Okay. Serial number 27 to 33. Finally, 1 week time is granted to do the needful, failing which the appeal shall stand dismissed.
Your lordship, 30, serial number 32, 10 days time is granted. In this case, my lord, one of the respondent died. We make a note that the respondent one is dead. ಅದರಲ್ಲಿ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ರಿ ಅಂತ. It was not registered. ಅಂತ ಇದರಲ್ಲಿ
ಅದನ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ನಮ್ಮ ಮುಂದೆ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರಲ್ಲ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಮೇಲೆ.
ನಾನು ನೋಟು ಕೂಡ ಹಾಕಿದೆ.
ನೋಟ್ ಹಾಕಿದೀರಾ?
Note
ಅದು ಒಂದು ತೆಗೆದಿರಿ ನೋಡೋಣ ಅದು ಯಾವ್ದು 31 ಅಂತ ಇದೆ. ಒಂದ್ ಮಾಡಿ.
ಇದೊಂದು ಬಿಟ್ಟು ಇನ್ನೆಲ್ಲ ನನಗೆ ಒಂದು
27 to 30, 32 to 33. ಹಾಗಿದ್ರೆ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅಂತ ಬರೀತಿರ್ತಾರೆ ನೋಡೋಣ ವಿಲ್ಸಿ.
32 ಅಲ್ಲ sir.
32 ಅದು ಒಂದು ತೆಗೆದಿರಿ.
32.
Fifth time 34 and 35. Anybody is there? Dismiss ಮಾಡ್ಬೋದಾ? 34, 35 despite granting sufficient time. 35 ನಿಮ್ದಲ್ವಲ್ಲ ನಾವು ಈಗ we are doing it lot. Despite doing needful, despite granting sufficient opportunities, needful is not done, therefore appeal dismissed. Sixth time 36 to 39. 39 minutes. 1 week time minutes. ಎಲ್ಲ ಬೌಂಡ್ರಿ 6 ಎಲ್ಲ ಮುಗಿದು ಹೋಗ್ಬಿಟ್ಟಿದೆ.
ಇಲ್ಲ ರೆಡಿ ಇದೆ ಇಲ್ಲ ಮಾಡ್ತೀನಿ ಇವತ್ತು ಫಾಸ್ಟ್ ಹಾಕಿ ಇದು ಮಾಡಿದ್ರು.
ನಿನ್ನೆ ಆಲ್ರೆಡಿ ನಾವು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ವಿ ಆದ್ರೆ ನಿನ್ನೆ ನಮ್ಮ ಆಫೀಸರ್ ಒಂದು ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ರು. ನಿಮ್ ಕೇಸ್ ಬದಲು 2024 ಲಿಸ್ಟ್ ಮಾಡಿದ್ರು ಸೇಮ್ ನಂಬರ್ ಅದು 36 to 39. ಯಾವ ಫೈಲ್ಡ್ ಮೆಮೋ ಮತ್ತೆ ನಾವ್ ಹೇಗ್ ಮಾಡೋದು ಆಮೇಲೆ ಕೋರ್ಟ್ನವ್ರು ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. ಹಾಗಾದ್ರೆ 34. You file counsel for the appellant submits memo for dismissal of the appeal as withdrawn. 34 ಅಲ್ಲಿ recording the memo appeal is dismissed as withdrawn. 35 ನಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು let it be there. 36 to 39 despite granting sufficient opportunities needful is not done, therefore appeal dismissed. Madam 39 madam. Sorry we can't
dismiss ಮಾಡಿಲ್ಲ.
times.
Dismiss ಮಾಡಿಲ್ಲ.
There should be some.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ
How ನಿಮ್ಗೇನು hesitation ಅನ್ಸಲ್ವಾ ಕೇಳೋದಕ್ಕೆ? 40.
Cell number 40, Prakash T. Hebbar, 7th time.
7th
For
time.
appellant.
Huh.
Lords, I have partly complied the office objection. Only 2 is remaining.
ಮಾಡಿಲ್ಲ.
We have served it, my lords, but acknowledgement will file it.
Then therefore appeal is dismissed. Okay. 41, that is hearing, no? 41. Okay.
My lord,
38, my
one
lord.
fresh matter.
38, second list. 2 weeks time if granted, my lord. Party ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ. Court fees ಕಟ್ಟಬೇಕಾಗಿತ್ತು, hospital ಅಲ್ಲಿ admit ಆಗಿದ್ದೀನಿ.
32.
Lord, one fresh matter, my lord, MFA MC matter. The appellant is the
10:50 ಮೆಮೊ ಮೂವ್ ಮಾಡೋದಾ?
No,
Sorry, rejected. Yes.
waiting
Next.
for the adjournment, my lord.
You didn't wait because others all moved. Only you were not here. You do not come on time. Yes, next case.
The non-compliance.
Ha, 30.
Cell number 32, list number 2.
ಯಾವ್ದು ನಾವು ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ
ನಾಗರಾಜ್.
ಅವರು ಬಿಪಿನ್ ಹೆಗಡೆ
Nagraj RC,
ಏನು ಐ ಹ್ಯಾವ್ ಮೇಡ್ ಆಫೀಸ್ ನೋಟ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Nagraj RC ಅಲ್ವಾ sir?
ಹೌದು.
2566 ಅಲ್ವಾ?
38.
ಹೌದೌದು.
38.
ನೋಟ್ ಅದ್ರಲ್ಲಿ ನೋಟ್ ಹಾಕಿದೀನಿ. 19/11/2023.
ಬಿಪಿನ್ ಹೆಗಡೆ ಅನ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಸೆಕೆಂಡ್ ಸೆಟ್ ನಾಟ್ ಫೈಲ್.
ಮಾಡ್ತೀರಾ ಅದೆಲ್ಲ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ರೆಡಿ. ಅದೊಂದು
ಒಂದೇ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ಅಲ್ಲ ಅದೊಂದು ಅಬ್ಜೆಕ್ಷನ್ಗೆ ನನ್ ಕೈಲಿ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅದೊಂದು ಬಿಟ್ಬಿಟ್ಟು ನಾವು
ಸಾರಿ, ಯಾವುದು ಫೋರ್ತ್ ಟೈಮ್ ಅಂತ ಬಂದಿದ್ದಲ್ಲ.
Finally 1 week.
ನಾವೇನು 1 week time is granted, failing which the appeal shall stand dismissed ಅಂತ ಹೇಳಿದೀವಿ.
ಅದೊಂದು ಅಬ್ಜೆಕ್ಷನ್ ಮೇ ಬಿ.
ಒಂದಲ್ಲ ಅದ್ರಲ್ಲಿ
ಅದು ಮಾಡ್ತೀನಿ ಬಾ. 1 week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು.
ನಾನು 2 days ಅಲ್ಲಿ ಟೈಮ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
23 ಅಲ್ಲಿ ಅಪೀಲ್ ಹಾಕಿದ್ರಿ, ನೀವೇ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಅಥವಾ ಬೇರೆ ಯಾರು?
ಹೌದು, ನಾನೇ ಫೈಲ್ ಮಾಡಿದ್ದೆ. ಅದೊಂದು ಅಬ್ಜೆಕ್ಷನ್ ಮೇ ಬಿ ಓವರ್ ಆಲ್. ಮಕ್ಕಿದ್ದೆಲ್ಲ ನಾನು 1 week.
Any objection? There is no submission. No submission is put up here.
ನೋಟು ಹಾಕಿದ್ದೀನಿ.
ಅದು ಒಂದೇ ಇಲ್ವಲ್ಲ, ಬೇರೆ ಇತ್ತು.
Kind permission. Paper book is ready, madam. Counter file ಮಾಡ್ತೀನಿ.
ಯಾವುದು?
Serial number 2 first list.
1 week, madam.
Serial number 2. We are not in serial number 1 now.
1 week.
Second set appeal papers to be
List
filed.
number 1 for orders, cell number 1, K Suresh. CT Parmeshwarappa.
I appear for respondent.
Single bench in the why paper second set is not 2016. Single judge ಇಂದ ಏನಾದ್ರು ಬಂದಿದ್ ಮ್ಯಾಟ್ರಸ್ ಇವು?
ಸಿಂಗಲ್ ಬೆಂಚ್ ಮುಂದೆ ಇದೆ. K Suresh.
ಹೌದು,
appear for the appellant, my lord. 1 week may be granted. ಇದು LOC ಬಂದಿದ್ದು ಸ್ವಾಮಿ
2022 ನಲ್ಲಿ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಇಂದ ಬಂದಿವೆ. ಇಲ್ಲಿಗೆ ಬಂದು ಕಾಲ್ ಫಾರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇರೆ ಬಟ್ ಅಲ್ಲಿ ಫೋರಂ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಒಳ್ಳೆ ವೇಟ್ 2024. At request, finally 1 week time is granted to do the 1.1. 1.2, who represents in 1.2? There is no.
Parmeshwarappa CT.
I appear for appellant in this. 1.2, 1.3. Only 2 weeks time may be granted.
Finally, for 10 days time is granted to the failing which the appeal shall stand dismissed. 1.2 nalli, finally 10 days time is granted to the
Like 2 weeks time may be granted.
appeal against R1 shall stand dismissed. R3 ಗೂ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅವರು ವಕಾಲತ್ತು ಹಾಕಿಲ್ವಲ್ಲ. Which insurance company is there?
Appear for the appellant Mr. K Suresh ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ NOC ಬಂದಿತ್ತು ಸ್ವಾಮಿ R ರಾಜಗೋಪಾಲನ್ ಅವರಿಂದ ನಮಗೆ.
Oriental Insurance.
ಮಾಡ್ತಿರೋದು
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಗೆ
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಮುಗೀತಲ್ಲ ಅದು. ನಿಮಿಷ 1.2 ಕೊಡು.
1.3.
1.2 ಹೆಗ್ಡೆ ಮಾಡ್ಕೊಂಡ್ರೆ ಅಂದ್ರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾವ್ದು?
Oriental Insurance Company.
ಓರಿಯಂಟ್ ಅಲ್ಲ, ಹಾಗಾದ್ರೆ ಹಾಕ್ಬೋದು. ಅವ್ರ ಕಾಪಿ
Please.
Yes, Suresh.
1.3 ಅಲ್ಲಿ R1
against R1.
1.3 ಅಲ್ಲಿ finally 10 days time is granted to the full failing which appeal against R1 shall stand dismissed. Yes.
Cell number 2, Gangadhar Aital.
My lord, I appear for Sri Gangadhar Aital, my lord. We apologize for having not complied the order of this honorable court dated 14/8. We undertake to do it in the course of the day, my lord. Today we shall comply, my lord. We shall file the paper books.
The order was passed on 14/8.
14/8, my lord.
2 weeks ಮುಗಿದೋಗಿದೆಯಲ್ಲ 2 weeks.
ಇವತ್ತೇ file
For the
ಮಾಡಿ.
appellant, my lord, paper book is ready. We'll file it today without fail.
ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ.
Yes.
They should come here before 2:30.
Okay.
Now they have to verify the paper books. It takes some time.
Okay.
You go and submit it.
Yes, ma'am.
Afternoon, 2:30 it will be called. Yes.
Passed over. Seal number 3, Ramesh Chandra.
I appear for the appellant, madam. ಅದು single judge ಇಂದ ಅವರು in connected matter ಅದು 5-6 matter ಇದೆ. He has
I am
indicated.
the contesting respondent in all the cases. My lord,
ಅವ್ರು ಹೇಳಿ ಈ
my-
ಕಡೆ ಬಂದ್ಬಿಟ್ಟಿದೆ.
yes, at my instance, all these 5 appeals have been directed before your lordship because the matter relates to division bench. My 2 other matters are before
Common judgment.
ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
common judgment.
You file the second.
ಆಯ್ತಾಯ್ತು.
RFA 122 and 187, my lord.
10 days ಕೊಡಿ.
Per matter, Ramesh Chandra.
ನಂದ್ರಲ್ಲಿ ಅದ್ರ ಸೆಕೆಂಡ್ ಸೆಟ್ ಒಂದು 10 days ಕೊಡ್ಸಮ್ ಬಿಕಾಸ್ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಹಾಲಿಡೇಸ್ ನಲ್ಲಿ
ಸರ್ವಿಸ್ ಆಗಿಲ್ವಲ್ಲ ಇನ್ನು ಕೆಲಸ.
ಸರ್ವಿಸ್ ಅದು ಕೊಡ್ತೀನಿ, ಪ್ರೋಸೆಸ್ ಕೊಡ್ತೀನಿ. ಎಲ್ಲ ಇದ್ದಾರೆ, ಇಲ್ಲೇ ಇದ್ದಾರೆ ಅವರು. ಅದನ್ನ ನಾನು ನೋಡಿ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ ಯಾರ್ಯಾರಿಗೆ. ಇವರು ಈ ಅಪಿಯರ್ಸ್ ಫಾರ್ ಸರ್ಟನ್ ಪರ್ಸನ್ಸ್.
ಒಬ್ಬರದ್ದು ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತ ಬಂದಿದೆ.
3.3.
R5, 9, 10, 11. Not claimed.
ಇನ್ನ ಎರಡು ಇದಾಗ್ಬೇಕು. ಅದು 2 ಅಡ್ಮಿಟ್ ಆಗಿದೆ. RFA 122.
ಎರಡು ಮ್ಯಾಟರ್ ಇದೆ, ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್.
ಅನ್ಕ್ಲೇಮ್ಡ್ ಇರೋದನ್ನ ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಬಹುದಲ್ವಾ?
ಅದು ಮಾಡ್ಬೋದು, ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ಬೇಕಂತ.
RFA ಎಲ್ಲರೂ ಹಾಕಿದ್ದಾರೆ ಅಪೀಲು.
They are all family members, my lord, except that Prakash Reddy.
ಯಾರಿಗೆ ಅನ್ಕ್ಲೇಮ್ಡ್ ಅಂತಿದೆ?
Yes, ಅದು.
They are represented in other
Yes,
cases.
yes.
ಹೌದು ಅದರ
Then you can file ವಕಾಲತ್ for them, no? Suppose ಈಗ 3.2 ಕೊಡಿ.
Please.
1575, my lord, may take it to lordship. That 1575 there, my lord.
ಈಗ ನೋಡಿ ಇಲ್ಲಿ ಈಗ ಅವರು R146 3.1 ನಲ್ಲಿ 544 ನಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1467 ಅಂತ ಇದೆ. ಅವ್ರು ಇಫ್ ದೇ ಹ್ಯಾವ್ ಅಪಿಯರ್ಡ್ ಥ್ರೂ ಸಮ್ ಕೌನ್ಸಿಲ್ ಇನ್ ಅನದರ್ ಕೇಸ್, ಯು ಕ್ಯಾನ್ ಅಂಡರ್ಟೇಕ್ ದೇರ್ ಫಾರ್ ದೆಮ್. 1, 4, 6 and 7.
ಅಲ್ಲ ಅದು
ಶೋಭಾ
544.
ಶೋಭಾ
ರಿಪೀಟ್ ಆಗಿ ಯಾರೋ
ನಾಗೇಂದ್ರ ಪ್ರಸಾದ್ 1, 4, 6 and 7. ವಿಜಯಲಕ್ಷ್ಮಿ ಅಂಡ್ ವಸಂತ ಇವ್ರು ಬೇರೆ ಕೇಸಲ್ಲಿ ಯಾರು ನೀವು ಅಪಿಯರ್ ಆಗಿ
ಕಾಮನ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಎಲ್ಲೋ ಕೇಸ್ಗಳು ಕಾಮನ್ ಆಗಿದ್ದಾರೆ.
ಬೇರೆಯವ್ರಿಗೆ ಅಪೇರ್ ಆಗ್ತಾ ಇದೀವಿ.
9 ಇವರು
9 ಗೆ ನಾನು ಅಪೇರ್ ಆಗ್ತೀನಿ.
9 ಇವರು
1, 5 ಕರೆಕ್ಟ್ ಅದೇನು ಅನ್ಕ್ಲೇಮ್ಡ್ ಅದಲ್ಲ. ಈಗ ಇದ್ರಲ್ಲೇನು ಅದೇ ಸೇಮ್ ಪಾರ್ಟೀಸ್ ಅವರು 4, 6, 7 and 8 ಇದ್ರಲ್ಲೇನು.
In many cases, they're all common parties, except
ಕರೆಕ್ಟ್. ಸೊ ಈ ಪ್ರೊಸೆಸ್ ಬರೆಯೋದು ಅದೆಲ್ಲ ಯಾಕೆ ಆಗ್ಬೇಕು? ನೀವು ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ರೆ ನೋಟಿಸ್ ತಗೋಬಹುದಲ್ವಾ ಅಂತ ಕೇಳ್ತಾರೆ.
ಅದ್ ನಾನು ಮೆಮೊ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. ಅದು ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕಂಪೇರ್ ಮಾಡಿ ಮೆಮೊ ಹಾಕ್ತೀನಿ ಸ್ವಾಮಿ. ಈ ಬೇರೆ ಎಲ್ಲ ಅಪೀಲ್ ನಲ್ಲಿ ಕಂಪೇರ್ ಮಾಡಿ ಮೆಮೊ ಹಾಕ್ತೀನಿ. 10 days ಟೈಮ್ ಕೊಟ್ಟು.
ಸಫಿಶಿಯಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡ್ತೀನಿ.
ಆಯ್ತು, 10 days ಕೊಟ್ರೆ ನಾನು ಅದ್ರ ಎಲ್ಲ ಕಂಪೇರ್ ಮಾಡಿ ಯಾರ್ಯಾರು ಅಪಿಯರ್.
2 weeks time is granted to do the needful ಅಂತ ಬರೀರಿ. 3.1 ನಲ್ಲಿ ಸರ್ವಿಸ್ ಆನ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 to 4 ಅದು 1, 4 ಅದು
1, 4
or 1 to 4
1 to 4.
1 to 4
1 to 4 ಎಲ್ಲರದನ್ನು ನಾಟ್ ಕ್ಲೇಮ್ಡ್ ಅಂತ ಬಂದಿದೆ. ಅದು
ಅಲ್ಲ 544 ಅಲ್ಲಿ ಇಲ್ಲ ಮೇಡಮ್, ಹತ್ರ ಬಂದಿಲ್ಲ.
ಇಲ್ಲ ನಮ್ಮ 1575 ಅಲ್ಲಿ
3.2 ನಲ್ಲಿ ಮಾತ್ರ.
3.1 ಅಲ್ಲಿ finally 10 days time is granted to do the needful in respect of unserved respondents.
Okay.
3.2 ನಲ್ಲಿ
5, 9, 10 and 11 unclaimed.
Service on respondents 5, 9, 10 and 11 held sufficient. Represented. 10 days time is granted to do the needful in respect of other unserved respondents.
Same order, in
3.3 ನಲ್ಲಿ 1576.
Yes.
ಇದರಲ್ಲಿ service on response 2 and 5
These held
held sufficient.
Yes. Rest of
10 days time is
I will
granted
take
to do the needful in respect of
other respondents.
6 ಮಾತ್ರ ಇದರಲ್ಲಿ.
Yes, 6. Second time I will take.
Respect of respond number 6.
Yes. Next matter.
ಇದರಲ್ಲಿ ಯಾರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ.
ಅದು ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ, ಅದರಿಂದ ನೆಕ್ಸ್ಟ್ ಸೆಕೆಂಡ್ ಟೈಮ್ ಎಲ್ಲ
ನಾನು ವಕಾಲತ್ ಹಾಕ್ತೀನಿ. ಅದು ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ ಅಂತ ಬಂದಿದೆ. ನನ್ನ ಹೆಸರು ತೋರಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ. R3 R2
ಟೆಲಿಂಗ್ ಯಾರು ಇದಾರೆ ಅವ್ರಿಗೆ
ನಾನು ಅದನ್ನ ಇದ್ ಮಾಡ್ಕೊಡ್ತೀನಿ. in another 2 matters are there, madam.
ಇದೇ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
it is submitted that these matters are
RFA 127
F number so and so list all the matters together after 2 weeks.
Shivram.
122 and 187. Yes.
Next, number 4, Andanappa Gurappa.
Non-payment of
I am for the respondent, my lord.
Appellant's counsel.
My lords, the appellants have come up with a number of for settlement. They have accepted our settlement, my lord.
Accepted, but nobody is here. They have to pay
My
the
lord?
court fee. Nobody is representing the appellant here.
That's what, my lord, I don't know. And the advocate for the appellant also promised to share the draft of the compromise petition. But he didn't share anything. That's the reason I'm up. And I kindly apologize for appearing through VC, my lord. My matters are
You
struck
can
in.
appear through EC, but the thing is, this was a suit for recovery of money.
My lord?
So where the defense? All right. Fine, no representation for the appellant. Finally, time is granted to do the needful, failing which the appeal shall stand dismissed. 2019, till then, court fee is not paid. Yes.
Till number 5, Anupama MB.
Appearing for the appellant in this case, my lord.
Connected matter.
In connected matter, I am for appellant, Your Honor, my lord.
Registry shall verify the status of service of notice and the answer respondent. And list on up to 2 weeks are needed.
19-8.
1980. 1999. Yes.
Much obliged, my lord.
Connected list on. Connected, same.
Cell number 6. Prakash T. Hebbar.
I appear to the appellate.
PR for defend number 17.
Dispensation of notice.
I appear in RFA number 652 of
No,
2000.
2170, they are seeking dispensation of notice to R2 to 4, R2 4 to 9 and 14.
Lord, insofar as the first aspect is concerned, Lord, the earlier the memo was filed. At that time, I'm not pressing it. Fresh memo is filed. So there was some confusion.
This, which memo you are not pressing and filed on which date?
Memo, Lord.
ಯಾವತ್ತು ಹಾಕಿರೋದು 31/5 31/5/2024.
Yes, yes. Fresh memo
Proceed for the appellant submits that he doesn't press the memo dated 31/24. And is seeking dispensation of notice to respondents 4 to 7 and 14.
Lord, you have that memo, Lord. Fresh
For the
memo is moved.
said memo is disposed of as not pressed. Again, registry has placed, we have filed several application also.
For R2.
IA number 2 to 5. These IAs are filed for bringing who sellers?
Lord, by bringing the legal acts of this is the R2.
2 to 5. Filed for bringing the LRs of this is for number 2. And memo filed by the appellant seeking dispensation of notice.
And someone's order ಮಾಡಿದ್ರಿ then is because of the urgency.
ಮತ್ತೆ ನೀವು dispensation ಕೇಳ್ತಾ ಇದೀರಲ್ಲ ಇದರಲ್ಲಿ why did you not press that memo? In this memo also you are seeking dispensation of
Dispensation in respect of
4 to 7 and 14.
ಹೌದು ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ they were my lord the
8 and 9, who represents 8 and 9 in the connected
they
matter?
appeared in the connected appeal ಅದಕ್ಕೋಸ್ಕರ.
Who appears that?
BS Radhanandan for R9.
ಹೇಳಿ.
PR for the respondent number 9, my lords.
9 ಇಬ್ಬರು ಕೇಳ್ತಾ ಇದ್ರಲ್ಲ ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ 8 and 9 ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ 8 ಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ?
8 and 9 in
Okay,
their appeal,
dispensation
I am
of-
appearing for the
You are-
appellant in the connected matter.
You undertake to appear
Please,
collect for them?
Please.
Dispensation notice to
Sorry, I'm
4 to 7 and 14. Expert ಇದ್ರ ಅವರು?
ಹೌದು.
4 to 7 and 14 were defendants? Defendants 5 to 8, 5 to 8, 5 to 8 and 15. 5 to 8 ಕೇಳ್ತಾ ಇದ್ದಾರೆ dispensation. 4 to 7, sorry, 4 to 7 and 14. It shows from the judgment where they were, it shows that they were placed ex parte. Three, 5 to 9 and 13 and 15, no? Since response 4 to 7 and 14, I had not contested the matter before the trial court, notice to them is disposed to as a court. Okay. Or his, please give your name.
K. Srihari. K. Srihari.
K. Srihari, no? K. Srihari, level counsel, undertakes to appear for respondent number 8 and 9.
8 and 9.
8 and 9.
89.
He is permitted to find the wakalat in the registry. Appellant's counsel shall serve the copies on him.
Please.
Sir, what your copies? Registry shall show his name in the copies recording. Idella clear aita. There are some complaints. Steps in respect of deceased respondent number 5. Substituted service for 15 and 16. Production of additional documents. ಈಗ ಇದ್ರದೆಲ್ಲ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಲ್ವಾ?
Substituted service by paper publication.
ಇಲ್ಲಿ you have filed LR application for respondent number 2 ಕೊಟ್ಟಿದ್ದೀರಾ. ಇನ್ನೊಬ್ರು ನಾವು respondent number 5 ನು ತೀರೋಗಿದ್ದಾರೆ ಅಂತ ಇದೆ.
In so far as respondent number 5 is concerned, was placed ex parte in the court below.
ಅದಕ್ಕೆ ನೀವು ಬೇಕು ಅಂದ್ರೆ ಮತ್ತೆ ಮೆಮೊ ಹಾಕ್ಬೇಕು, ಇಲ್ಲ ಅಂತಂದ್ರೆ
They have not received the.
ಅಬೇಟೆಡ್ ಅಂತ ಬರೀತೀವಿ ಅಷ್ಟೇನೆ. ಇದು ಬರ್ಕೊ. Steps against respondent, this is respondent number 5 is not, therefore appeal against ಯಾರ ಸಿದ್ದಪ್ಪನವರ 96 years appeal ಮೆಮೊದಲ್ಲಿ ತೋರಿಸಿದ್ದಾರೆ. Appeal against respondent number 6 stood abated. Okay. Issue notice of IA number 3 to 5 of 2024 to the proposed LRs of deceased respondent respondent number 2. Emergent ಮಾಡ್ತೀವಿ ಇಲ್ಲ ಅಂದ್ರೆ.
I request for summons because in view of the urgency.
Lord, I am for respondent number 17. The only urgency is there is a limited interim order granted by this honorable court saying FDP proceedings can continue, but final decree may not be drawn up. In the FDP proceedings also, interlocutory applications are being filed for interim orders. When there is an interim order already granted by
Interim order they are seeking in FDP.
Lords, in the FDP, there is an interim order now that there will be no alienation of property. Although appeal is pending here, any interim order then must be sought here. For that reason, my lords, if hand summons can be issued, I am sealing with the appellant. If service can be.
Both of you are saying, no, it is not safe, we will not give hand summons. Emergent notice, if you want to issue emergent notice, you take by speed post. If you want to, will order that, issue emergent notice of IA so and so to the proposed LRs. ಯಾವ ಊರಲ್ಲಿ ಇರ್ತಾರೆ? ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಫೆಸಿಲಿಟಿ ಇದೆ ಅಲ್ಲಿ?
Why we are insisting is because the interim order is every day, my lord, is coming in the way of.
Correct. You only interim order is granted by this court.
This honorable court only earlier, my lord.
It is your appeal. Probably it is granted at your instance only.
Lord, the interim order at the instant, at the first instance, my lord, there was an interim order of stay of the decree. Lord, thereafter it was modified. That the final decree proceedings may go on, but drawing of the decree was stayed. Lord, when the entire matter, whether the trial court judgment is right or wrong, is under scrutiny by this honorable. But when the matter is received with this honorable court, Lord, an application was moved before the honorable trial court in the FDP proceeding, seeking
by the decree holders.
No, by the decree holder.
Not to alienate them.
Not to alienate. Then
that order is here also.
No, this honorable court was pleased to stay the decree.
One second.
Lord, this honorable court, at the time.
Correct. What is the error? See, section 52, you cannot transfer of property act, you cannot alienate without the leave of the court.
Yes.
And now in this case, at your instance only that interim order is granted.
I'm making the submission in so far as the interlocutory application filed and an ex parte interim order granted before the trial court.
Correct. What is the error in the trial court's order also? We have stayed only drawing up of the final decree. It can proceed. The trial court's hands are not totally tied.
Lord, when the entire matter is seized with this honorable court.
All right, if you are aggrieved, challenge that order also. Why are you bringing up those orders here again without filing any appeal?
Only thing is that except the final decree.
ಅವ್ರು ನಾವು ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳಿದ್ವಿ ಅವರೆಲ್ಲ ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಇರೋಲ್ಲ ಇದಾರ ಅಂತ ಇದ್ರೆ ಸ್ಪೀಡ್ ಪೋಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. Why do you want to take hand summons? ಎಮರ್ಜೆನ್ಸಿ ನೋಟಿಸ್ ಅಂತ ಅಷ್ಟೇ ಮಾಡಿ ಅವ್ರು ಹೇಳಕ್ ರೆಡಿ ಇಲ್ಲ.
That's a connected
List
matter.
on
Connected matter.
ಅದೇ ನಮ್ಮ ಲಿಸ್ಟ್ ಹೋಯ್ತಲ್ಲ ಇದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್
Please, my lord. Respondent
ಅದೊಂದಿದೆ.
number.
ಇದಕ್ಕೆ ಹಾಕಿದ್ವಿ ಸಬ್ಸ್ಟಿಟ್ಯೂಟೆಡ್ ಸರ್ವಿಸ್ ಫಾರ್ R15 and 16 ಅದರೊಂದ್ ಮೇಲೆ ಆರ್ಡರ್ಸ್ ಅನ್ ಐ ನಂಬರ್ ಎಷ್ಟದು 2 of 2024 ಅದನ್ನೇ ಮೊದಲು ಬರ್ಕೊಂಡು ಆಮೇಲೆ ಐ ಮೇಲಿಂದ ಬರ್ಕೊಳ್ಳಿ. You have kept so many things pending.
No, that is pending, Lord, because the defendants, respondents are the.
Paper publication.
Numbers.
ಏನಂತ ಬಂದಿತ್ತು ಇವ್ರದ್ದು ನೋಟಿಸ್?
15 and 16.
15 and 16. Appeal is of the year 2019.
At
ಏನಂತ
least he
ಬಂದಿತ್ತು?
left without instructions. And the.
15 and
remarks,
16,
personal remarks.
they are the purchasers, huh? Or family members?
Hello, they are all purchasers.
Purchasers. Satisfied by the service of notice and respond of 15 and 16 in the ordinary process is not probable in the near future. Therefore, appellants are permitted to take notice to response 15 and 16 by paper by publication in Kannada Prabha, Kannada Daily Newspaper, Bangalore edition. Notice shall be published on or before
24/9. No.
24/9. Fixing the hearing, notifying the hearing date as
15/10. Entered
15.
into a compromise.
It's done 15. Okay.
Lord,
Connected.
immediate within this, Lord, we will expedite the process.
No, is paper publication? Paper publication ಕೇಳಿದಿರಲ್ಲ ಅದು ಮುಗಿಬೇಕಲ್ಲ.
I requested for handsome and Lord.
And summons will not be. Yes, sir. No, sorry.
In the connected appeal, Millers, respondent.
You keep the matters pending since 2019. Now you start saying that matter is urgent.
We have taken steps several times.
So next
But
question.
the
Next
respondents.
6.1 ಅಲ್ಲಿ ಏನಾಗ್ಬೇಕು?
6.1
Issue
ಅಲ್ಲಿ
notice to R1 14.
R1 is unclaimed, Millers. The postal share is unclaimed. As per serial number 4. 4 ಅಲ್ಲಿ unclaimed ಅಂತ ಇದೆ.
R1 unclaimed. Service and respondent 1 is.
Any of us are already represented here. If learned counsel says which, because I don't have a copy, I am ready to accept notice for the.
ನೋಡಿ ಯಾವ್ದಂತ ಕೊಡಿ 14, 15 you know the names of the parties?
R Krishnamurthy is R1, Millers.
It's easier. He can take notice.
Let him take
ಇದರಲ್ಲಿ
notice, Millers.
it is not served on 14 and 15 ಅವ್ರ ಹೆಸರು ಏನು ಅಂದ್ರೆ
14 and 15 again, Millers, they are the purchaser.
ಭಾಸ್ಕರ್
They are the ones to for
ಯಾರು ಹೆಬ್ಬಾರ್ ಅವ್ರ represent
substituted service ತಕೊಂಡಿದಾರಲ್ಲ ಅವರೇ.
ತಗೊಂಡಿದ್ದಾರೆ ಹೌದು.
So ಅವರೇ ಸ್ವಾಮಿ ಅವರೇ ಇಲ್ಲಿ ಸಹ 14 and 15.
ಆಗುತ್ತಲ್ಲ
Please,
ಹಾಗಿದ್ರೆ.
Millers, I think 3 times is not.
In our case, if they appear, then they.
ಅವ್ರ ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ ಯಾಕಂದ್ರೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಹೋದ್ರೆ ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ನೋಟಿಸ್ ಟು R 5 to 8. 5 to 8 ಯಾಕೆ 5 to 8 are not contested? 5 to 8 is Krishnaveni, Viddappa, Gauramma and Srinivas. Defendant number 5 to
The persons who are placed expert.
8. Srinivas ಅಲ್ಲ ಇಲ್ಲ ಹೆಸರು ಡಿಫೆನ್ಸ್ 5 to 8 ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತ ಇದೆ ನೋಡಿ.
Mr. Abbar, I've already told the
Defendants 5 to 9 expert. Then even 13, 15 were also expert. But
11 and 13.
the records show that respondents 5 to 8 had not contested the matter before the trial court. ಅಲ್ಲ 13, 11 and 13 ಗೂ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
R 5 and 8 and 11 and 13.
11 and 13. ಅವರೇ ಅವ್ರು ಇನ್ನಿಬ್ರು ಇದ್ರೆ ಹೇಳೋದಲ್ಲ ನಾವು ಅವರೇ.
ನಮ್ ಸರ್ವ R3 ಅಷ್ಟೇ.
11 ಸಂಜಯ್ 11 and 13. ಕಲ್ಪನಾ ಜಗದೀಶ್ 13 and 15. 15. 15. Correct. Or 5 to 8, 11 and 13 have not contested the matter before the trial court, therefore notice to them is dispensed with as paid for. ಆಯ್ತಲ್ಲ
14 and 15 I shall take.
11 and 13 ಗೂ dispensation ಆಯ್ತಲ್ಲ ಈಗ.
ಹೌದು.
Steps to be taken R1 ಆಯ್ತು. ಇನ್ಯಾರು ತಗೋಬೇಕು?
On 14 and 15 millards.
14 and 15 dispensation ಮಾಡಿಸ್ಕೊಂಡ್ರಲ್ಲ ಈಗ.
ಅಲ್ಲ 14 and 15 ಆಗಿಲ್ಲ ಸ್ವಾಮಿ. 11 and 13 ಆಗಿರೋದು.
11 and 13. 5 to 8 and 11 and 13.
ಹೌದು. 14 and 15 I shall pay the process millards.
Today time is granted to do the needful, failing which appeal against them shall stand dismissed.
My lords, there is one small correction. My lords, I have actually filed wakalat for R4, my lords. I think by oversight it in the things R4 I appear, my lords. R3, my lords, is dead, and in fact the appellants have taken R3 Sundarama. Appellants have in fact taken
No, which appeal you are submitting?
second appeal, my lord, 6.1
ಅಜಯ್ ನಂದಳಿಕೆ ಅಂತ ತೋರಿಸಿ.
for R3 ಅಂತಿದೆಲ್ಲ ಸ್ವಾಮಿ. Actually R4 ಗೆ.
ನಿಮ್ಮ ವಕಾಲತ್ ಹಾಗೆ ಇತ್ತ ನೋಡಿ.
I mean, I think ನನ್ನ ಕಡೆಯಿಂದ ತಪ್ಪಾಗಿದೆ. 100% ನನ್ನ ಕಡೆಯಿಂದ ತಪ್ಪಾಗಿದೆ.
ಮತ್ತೆ
ಇಲ್ಲ, but I have filed for Shantama because we didn't get a copy of the appeal memo.
R4 is ಶಾಂತಮ್ಮ, R3 is ಸುಂದರಮ್ಮ.
Swami, we appear for Shantama, not for Sundarama.
ಶಾಂತಮ್ಮ ವಕಾಲತ್ತಲ್ಲಿ ಹೆಸರು ಕರೆಕ್ಟ್ ಬರೆದು ರ್ಯಾಂಕ್ ತಪ್ಪು ಬರ್ದಿದ್ದೀರಾ?
ಶ್ರೀಮತಿ ಬಿ ಕೆ ಸುಧಾ ಅಲಿಯಾಸ್ ಶಾಂತಮ್ಮ ಅಂತ
Shantama, ಹೌದು.
ಅವ್ರಿಗೆ ಹಾಕಿದೀರ.
ಅವ್ರಿಗೆ.
ಅಲಿಯಾಸ್ ಶಾಂತ.
ಅಲ್ಲೇ ರ್ಯಾಂಕ್ ಏನ್ ಬರ್ದಿದ್ದಾರೆ?
R3.
Swami, because I didn't have a copy. ಇದ್ರಲ್ಲಿ R3 ಇದೆಲ್ಲ.
ಕರೆಕ್ಟ್ ಮಾಡಿಸ್ಕೊಳಕ್ ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀವಿ.
ಅದಕ್ಕೆ ಒಂದು ಪರ್ಮಿಷನ್ ಕೊಟ್ಬಿಟ್ರೆ.
Ajay Nandalke, Learned Council submits that he has filed wakalat for Shantamma, who is respondent number 4, but in the wakalat by accidental error, her rank is shown as R3 and seeks permission to correct the rank. In the wakalat, permission is granted. Registry shall show. ಈ ಕರ ಕರೆಕ್ಟ್ ಇದೆ ಅದು, ಮತ್ತೆ ಇನ್ನೊಂದು ಮಿಸ್ಟೇಕ್ ಆಗೋದು ಬೇಡ. The registry shall show his name for respondent number 4. ಮತ್ತೆ ವಾಟ್ ಅಬೌಟ್ R3 ಈಗ? ನೀವು ವಕಾಲತ್ ಹಾಕಿದೀರಾ ಅಂತ ಅವರು ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. Who is R3? ಸುಂದರಮ್ಮ. She is dead ಅಂತ.
R3 is the one who's dead.
R3 is the one who's dead.
Then appellate.
I shall.
It is submitted that respondent number 3 Sundaramma is dead.
I shall file a letter.
Council shall do the needful.
Legal application ನಾವು ಇನ್ನೊಂದು ನಮ್ಮ ಕನೆಕ್ಟ್.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಹಾಕಿದ ಅಪ್ಲಿಕೇಶನ್
I
ಕಾಪಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅನ್ನ.
Obliged.
Number 7, Mantesh Shettar. Jaikirti MC.
Correct address R2 and R3. These are appellants council.
For the appellate, R2 and R3 are not necessary parties. They are the only tenants in that particular shell property.
Yeah, that is the case. You have to file a memo.
And in fact, I have served the copy to them.
Did the matter before the trial court or not? What was their ranks?
No,
So suit for partition, even though they were served, they remained ex parte.
ಅವಾಗ್ಲೇ ಮಾಡ್ಕೋಬೇಕಲ್ಲ. This is 2000.
I appeal for the first
You
respondent.
all. You are the appellant in the first appeal.
No, no.
You are the respondent. ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇದೀವಿ ನಾವು.
I have served the copy personally. I have served them a copy also.
ಅದೆಲ್ಲ ನಾವು ಮಾಡೋದಿಲ್ಲ. If you want, otherwise ಬಿಡಿ. At request finally 2 weeks time is granted to do the needful in respect of R2 entry, failing which appeal against them shall stand dismissed.
My lordship,
Go ahead.
the urgency is that the FTP proceedings are going on. There are
ಮಾಡ್ಬೇಕಲ್ಲ ಅದನ್ನ.
right, this ex parte judgment and degree. The notice was served on son-in-law.
Council. Now the notice was issued to respond number 2 and 3. You now even after we telling you are not ready to file a memo for dispensation.
I'll file it.
ಎಷ್ಟು ಸರಿ ಪಾಸ್ ಅವ್ರು ಮಾಡ್ಬೇಕು ನಾವು?
I'll file now. Kindly pass on.
ಫೈಲ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ at least.
I'll file the memo.
Rank whether
Two
it is before the trial court or
Defendant 2 and 3.
2 and 3. They were defense 2 and 3. Judgment is at page number?
Page number 633, your lordship, the judgment,
Page 33, no?
3 of the judgment.
33. R3 is shown ex parte. What about R4? R2?
R2 also ex parte.
Judgment alle R2, R3 ಗೆ ಮಾತ್ರ ex parte. ಒಂದು ಮೆಮೊ ಬರ್ಕೊಂಡು ಬಂದು ಕೊಟ್ರೆ ಆಗೋದಿಲ್ವಾ? ಅದಕ್ಕೆ ಇಷ್ಟು ಟೈಮ್ ತಗೊಳ್ತೀರಿ?
In fact, I have served them copy also. They are tenants in the same property.
After filing the suit, summons was issued to the, in spite of issuance of suit summons, defendants failed to appear. None of the defendants appeared before the trial court.
Please.
Clerk counsel for the appellant.
They had also filed a miscellaneous petition which has also been dismissed on the grounds of delay. Thereafter, this appeal has been filed.
Respondents 2 and 3. no?
3.
2 and 3. Since those respondents have not contested the matter before the trial court, the notice to them is dispensed with as paid for. You are for respond number 1.
Please, plaintiff.
You also did not contest.
No, I'm the
You
plaintiff.
are for the plaintiff.
Plaintiff.
He is for defend number 1.
Please, my brother,
ಏನಾಗ್ಬೇಕೀಗ ಅದ್ರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಆಯ್ತು
admission post.
ಅಡ್ಮಿಟ್ ಆಗಿರ್ಲಿಲ್ಲ
Delay.
Admit ಆಗಿಲ್ಲ. There delay ಇದೆ.
ಡಿಲೇ ಬೇರೆ ಇದೆ
Delay ಇದೆ.
ಎಷ್ಟು ದಿವಸ ಡಿಲೇ ಇದೆ
1147 days.
ವಾಟ್ ಡೂ ಯು ಸೇ
I'll file my objections because that filed earlier.
The MA was filed.
Miscellaneous petition was filed after a period of 6 years. After the dismissal of that miscellaneous petition, they will now come up with this.
Oh. Now counsel for the first respondent seeks time to file counter to IA 1 of 2022. No?
Please, ma'am.
1 of 2022. List
Lordship,
after 1 week.
the final 19th is the date for the
You know,
filed an application.
that will be subject to result of this appeal. Yes, yes.
Please.
Cell number 8, P. Sheshgiri Rao.
My lords, kindly, Lord, that in, my lord, one thing I would like to mention, my lord. In the earlier matter, my lord, this honorable court, my
We will
lord,
take up after finishing all these things. ಅದ್ರಲ್ಲಿ ಟೈಪ್ ಮಾಡಬೇಡಿ ಅಷ್ಟೇ ಇಟ್ಬಿಡಿ ಅವ್ರೇನ ಕೇಳ್ತಾರಂತ ಅದ್ರಲ್ಲಿ.
great, sorry for.
No signal jumping. Yes.
My lord.
Cell number 8.
The appellant in this matter. Appears that
Yes,
the legal heirs
Non-compliance of
party
office
number 2.
objections raised on IA 1 of 2024 for delay, abatement, etc.
Lordship, kindly see, respondent number 2 appears to have been passed away in 2023. And their LRs have made the application to come on.
They themselves have file application.
22-4 application has been made by them.
Who represent them? R3 to 5. Applicants are represented by which council?
The legal heirs of respondent number 2 has made the application.
Correct. ಯಾರು advocate ಯಾರು ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ತಿರೋರು ಇಲ್ಲಿ ಭವ್ಯ ರೆಡ್ಡಿ ಫಾರ್ R1 ಅಂತ ಇದೆ, ಭರತ್ ಕೆ ಫಾರ್ R3 to 5 ಅಂತ ಇದೆ. Legal heirs of respondent number 2.
Already, if I am subject to correction.
ವಕಾಲತ್ ಸಿಗ್ತಾ ಇದೆ ಇಲ್ಲಿ.
For not mentioned their name in the application, it appears that the already has.
ವಕಾಲತ್ತರ ಹಾಕ್ಬೇಕಲ್ಲ, they should file ವಕಾಲತ್ for that, no? And they file application.
Otherwise, I will make the LR application. Because I came to know only after service of copy, I will make necessary application.
No, what is that office objection is delay and abatement application. ಒಂದೇ ಕಾಮನ್ ಅಪ್ಲಿಕೇಶನ್ ಸಾಕಾಗುತ್ತೆ ಅಂತ ನಮ್ದೇ ರಿಜಿಸ್ಟ್ರಿ ಇದೆಯಲ್ಲ.
Lakshmi,
And they are-
kindly treat this application as 1 Rule 10 and allow it. Let them come on record. They should have made the application under 1 Rule 10.
32 Rule 4 correct है, but council for the appellate submits that. Why they are sailing with you? Are they sailing with you? LR's respond number 2 was
Nam jateli illa. They are not with us.
appeal is filed by whom?
Defendant, the plaintiff appeal. I lost the suit, which is a suit for special performance on the ground of readiness and willingness, the court has.
Refund order ಮಾಡಿದ್ರ? Respondent number 2 was defend number
Defendant number
3.
defendant
Defend number 3.
defendant number 3.
Contest ಮಾಡಿದ್ರ ಅವರು? ಅಲ್ಲ, counsel for the appellant submits that he has no objection to allow IA number 1 of 2024. ಅದ್ಯಾವುದೋ ಒಂದು ನಮ್ಮ ಸರ್ಕ್ಯುಲರ್ ಇತ್ತಲ್ಲ ಕೊಡಿ. Since the appellants did not file application to bring the LRs of deceased respondent, the LRs themselves have filed IA 1 of 2024 to come on record. As per RJ notification, as per this is as per the circular of this court in RJ number 81 of 2021, dated 4/8/2021, filing of 3 separate applications. for condonation of delay and setting aside the abatement. And to come on record. Is not necessary. No. You do not dispute their heirship, no?
It's
The
not under
applicant to the
dispute.
Legal representatives of deceased respondent is not in dispute. Therefore, the application is allowed. The applicants are permitted to come on record as respondents 2A and B. No?
Respondents,
2 and 3 ಅಂತ ಬರ್ದಂಗಿಲ್ಲ, 1 and
2A and 2B.
Then appellant's counsel shall amend the constitutional of the appeal memo and furnish the copy of the amended appeal memo. List on. Date.
Millard, shall I make one more submission?
Yes.
On 7/11/2023, we have made an application with the permission of the court to deposit the balance sale consideration amount of rupees 1 crore and that. That is IA number 1 of 2023. IA number 1 of 2023. That application has been made on 7/11/2023. And I may be permitted to deposit the balance sale consideration amount before this honorable court.
22 ಆದ್ಮೇಲೆ 1 of 2024 ಇದೆಯಲ್ಲ.
23 ಅದು 7/11/2023.
ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಇನ್ನು. ಇದೆ
By mistake, office has not listed it.
ಸಬ್ಸ್ಕ್ರಿಪ್ಷನ್ ಇಲ್ವಲ್ಲ ಲಿಸ್ಟ್ ಅದು ಆಗ ಲಿಸ್ಟ್ ಮಾಡಿ ನೋಡೋಣ. Counsel for the appellant submits that on 7/11/2023 has filed an interim application. Registry shall verify and list down.
A date may be given.
13/9.
13.
Still number 9, Abhinay YT, Srinath BK.
For the appellant. Of R1 has passed away, my lord.
ಏನಿದು? Correct.
Appearing for R11 and R12, my lord.
R5 to 10.
R1, my lord, this, my lords may see the second note, my lord.
R1?
R1 has passed away.
R1.
Steps to be taken in respect of R1.
ನೋಟಿಸ್ ಹೋಗಿರ್ಲಿಲ್ವಾ ಅವ್ರಿಗೆ?
The notice ಹೋಗಿತ್ತು, dead ಅಂತ ಬಂದಿದೆ.
ಹ್ಮ್.
R1,
ಟೋಟಲ್ ಮೂಡ್ ಅಂತ ಇದೆಯಲ್ಲ.
I moved it.
ಯಾಕೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ದೇನೆ?
No, my lord, for steps, I'm filing a memo that R2, R4 to 10 are the legal heirs of R1. So they may be treated as legal heirs.
Yes, sir. R2 and 4
R4 to 10.
R1 is Kunjappa, son of Venkatramappa. R2 and 4 to 10.
4 to 10.
Counsel for the appellant submits memo reporting that respondents number 2 and 4 to 10. No?
Yes, yes, ma'am.
Are
Except
the only surviving heirs of respondent, deceased respondent. He shall amend the constitutional of the appeal memo accordingly and furnish the amended appeal memo. What about R5 to 10?
take my lord steps a week's time because I have to furnish.
At request 1 week time is granted to the needful in respect of answered respondents.
I may permitted to carry out the amendment now.
Madi.
Grateful. Grateful.
Number 10, Nataraj Ballan.
Based on PF. Yes. Yenadu. Two addresses mentioned in cover, correct address to issue notice to be verified. If on one cover you write two address, how do they send it? At request 1 week time is granted to the. Yes. Correct Madi, office alone.
Still number 11, Paniraj Kashyap.
Let's appear for appellant. I see 2 days time to.
Correct address for respondent number 2. You have moved this.
Yes, madam.
Why do you move without complying the office objection?
My lord, son, first time I have already taken PF, I had paid PF, my lord, son.
Correct acknowledgement, postal cover acknowledgement ella kodbekalla PF anna.
This is the second time, my lord, son.
But what happened to the service? You have to examine that, then you have to move it. At request 1 week time is granted to the report. Yes.
Still number 12, Shripad V. Shastri, Krishna Kishore.
I appear for the respondent number 1 claimant in this case, my lords. In appeal number 580 of 2024,
Correct.
filed an application for return of the TCR, my
The
lords.
first appeal is by the claimant on.
Yes, my lords.
But-
1968 is by the claimant for enhancement of the
Who is
compensation.
respondent number 2 and 2B?
To owner of the vehicle, and since the owner of the vehicle had died, the daughter of the owner of the vehicle was made a party as a legal heir.
Yes.
And it is only for enhancement of the compensation on quantum, my lords. So it may kindly be dispensed with.
It is passed to whom?
On the insurance company, my lords.
You are only on quantum.
In 580, I filed an application for return of TCR, my lords.
Since the insurer's liability not under dispute, notice to respond number 2B na?
Yes, my lords.
ಅಲ್ಲ 2 is dead ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Yes, my lords. Since
SRS Travels.
yes, my lords. The owner of the SRS Travels had died.
ಅಲ್ಲ 2 is a firm.
Yes, my lords.
So notice to
And now it is
respond
headed by Srimati Meghana, the daughter of the
2B is
deceased.
dispensed with as paid for. Yes, connected matter ಏನಾಗಿದೆ
In
return.
580 of 24, my lords,
Hmm.
I filed an application for return of the TCR.
ಮಾಡ್ಲಿ ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಇದು ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ ಇನ್ನು ಫಸ್ಟ್ ಮ್ಯಾಟ್ರು
First matter.
1968 is
No,
not
no, no,
admitted.
my lords.
IA 1/24 is still pending ಅಂತ.
What is IA 1/24?
Delay ಏನೋ ಇರ್ಬೇಕು.
There is delay of 62 days. Appellant applicant. Who has filed this?
My lord, serial number 12, my lord, sorry, extremely sorry, my lord, extremely sorry. I was on leg in other court.
Who was this Divya before the tribunal? She was the claimant.
She is the claimant, my lords.
But delay condone ಮಾಡಬಹುದಲ್ಲ 62 days. Heard accepting the reasons assigned to explain the delay. Delay of 62 days in filing the appeal is condoned in the interest of justice. IA 1/2024 is disposed of accordingly. Admit, post for final hearing, connected matterly. Registrar shall return the TCRs to the tribunal to facilitate the claimant to withdraw the amount in deposit. Soon thereafter, the tribunal shall resubmit the records. List after resubmission of TCRs.
Much obliged, my lords.
Seal number 13, D. Vijay Kumar, Srinivasa DC.
My lord, I am for the appellant, my lord. The appeal by the KSRTC, my lord. My lord, I have received the copy of the stay order, my lord, only about 20 days back. I have forwarded it. They have to deposit the amount before the MSCT Mysore. I'll get the information and my lord, I'll submit, my lord, where amount is deposited. Produce the acknowledgement also. Kindly stay may kindly be extended, my lord.
R1 to R3, my lord.
Correct deposit ಏನ್ರ
They
ಮಾಡಿದ್ರು.
have deposited, I think we have also 50% has been
ಈ
deposited.
ಪ್ರಕಾರ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ಲ ನಮ್ಮ ಮುಂದೆ ಪ್ರೂಫ್ ಕೊಟ್ಟಿಲ್ಲ ನಿಮಗೆ ಏನಾದ್ರು ಗೊತ್ತಿದೆ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್
Kindly, my lord, let them provide.
My lord, stay may kindly be extended, my lord.
2 weeks time.
Interim order of stay may kindly be extended.
Is extended to next hearing date. Yes.
Much obliged.
Next.
Seal
Stay is
14,
extended,
D.
my lord.
Vijay Kumar.
My lord, in this matter, my lord, we have deposited a sum of rupees 12,96,369.
But you have not filed the proof of that.
My
You
lord,
have to pay
today,
the process fee
my lord,
also.
today I got the information, my lord. I am going to file it, my lord. It is before me, my lord. Kindly see, my lord. I am going to file it, my lord.
List after weeks interim order granted earlier is extended till.
Stay may kindly be extended, my lord.
Till next hearing date. Yes.
Seal number 15, Nagaraja, yes.
Shanta Kumari, Shambhala and Shantam is the same name. In the trial court, at the time of filing Wakalat, he signed as a Shantamma. That's the objection.
ಶಂಬಾಲ
ಹಾ.
ಇಲ್ಲೇನ್ ಬರ್ದಿದ್ದೀರಿ ನೀವು
ಈ ಶಾಂತಮ್ಮ ಅಂತ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ ವಕಾಲತ್ತಲ್ಲಿ ಮತ್ತು ಐಎನ್.
ಸಂಪಾಲ ವಕಾಲತ್ತಲ್ಲಿ ಸರಿ ಇಲ್ವಾ ಅದು
ಹಾ, ವಕಾಲತ್ ಅಂಡ್ ಐಎ ಸೈನ್ಡ್ ಆಸ್ ಶಾಂತಮ್ಮ.
ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇಲ್ಲ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಆಫ್ ದ ಅಪೀಲ್ ಮೆಮೋ ಅಂತ ಬರ್ದಿದಾರಲ್ಲ ಸೈನ್ಡ್ ಆಸ್ ಶಾಂತಮ್ಮ ಇಂದ ವಕಾಲತ್
The name was one and the same. The Aadhaar card reflecting the same name, Shantamma.
ಕರೆಕ್ಟ್ ಎರಡು ಹೆಸರು ಬರಿಬಹುದಲ್ಲ ನೀವು ಹಾಗಿದ್ರೆ ವಕಾಲತ್ತಲ್ಲಿ ಯು ಕುಡ್ ಹ್ಯಾವ್ ಮೆನ್ಷನ್ ಬೋತ್ ದ ನೇಮ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅದನ್ನ ಸಬ್ಮಿಟ್ಸ್ ದಟ್ ಶಾಂತಮ್ಮ ಶಾಂತಲಕ್ಷ್ಮಿ ಅಂಡ್ ಶಂಬಾಲ ಆರ್ ಒನ್ ಅಂಡ್ ದ ಸೇಮ್ he shall correct the name in the wakalat accordingly, name and the IA accordingly, list after 1 week.
Seal number hearing on IA, seal number 16, NR Rangegoda.
I appear appellant on behalf of the Rangegoda. I have filed the applications for your lordships because there is a delay in filing the objections. That's why I filed up.
8/2000.
Yeah, for permission to your lordship.
14, you know, I recall.
Because your lordship has granted 10 days time, that has been expired. That's why a permission has been granted by this court to accept the objections. And also I have filed a paper publication to the owner of the vehicle.
And to do the needful in respect of.
And release of the amount, there is also filed, objections also filed.
This order to be recalled.
Lordship, because your lordship has given the time for 10 days to file the objections. That has been expired. That's why your lordship filed an application for your lordship to extend the time.
Shall stand dismissed ಅಂತ ಆಗಿದೆ.
ಅದಕ್ಕೋಸ್ಕರ.
Number 4. Which is your IA 2 of 2024.
Yes, your lordship. Copy also served. ಬಂದಿದೆ ಭಟ್ರೆ copy.
My application is for release of the amount. May be considered. Because there is a deposit of.
Correct. ಇನ್ನೂ ಮಾಡಿಲ್ವಲ್ಲ. You file application, then we'll consider that.
ಅಲ್ಲ ಈಗ ನೀವು ಕೊಟ್ಟಿದ್ದೀರ ಅದು ನೋಡಿರ್ಲಿಲ್ಲಂತೆ ಅದಕ್ಕೋಸ್ಕರ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ಬಿಟ್ಟು ದಟ್ಸ್ ವೈ ಮೇಡ್ ಇದು ಅಂಡ್ ಆಲ್ಸೋ
To take by sub service.
ಸಬ್ ಸರ್ವಿಸ್ ಒಂದು ಹಾಕಿದ್ದೀನಿ ಆಮೇಲೆ ಲರ್ಶಿಪ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಲ್ಲ ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ ಓನರ್ ಅಂಡ್ ಆಲ್ಸೋ RC ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್
Our application for release of the amount ಏನು ಹೇಳ್ತೀರಾ?
ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡ್ತೀನಿ along with citations.
What is the liabilities in this?
Liability against the driver.
He is the driver.
Oh.
Appellant is the driver.
Otherwise,
so what they contend is because there is a driving license, they are not responsible. It is very strange.
Next time ಇದು ನಮ್ಗೆ ಹೇಳಿದ್ರು. It is driver liability ಬಂದ್ರೆ owner ಗೆ ಬರುತ್ತೆ. It's only vicarious liability.
It is very strange.
Say that I am exonerated, you go against the owner only.
So you are.
This is the basic
correct. I am not.
ನಾನು ಹೊಸದಾಗಿ ಪಾಠ ಕಲಿಬೇಕು.
Last time it was submitted.
ಅಲ್ಲ ಸಬ್ಮಿಷನ್ ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದೀನಿ.
Now it is in writing.
Vacating
it was oral submission.
ಹಾಕಿನಿ.
Deposited.
25% of the award only.
3 lakhs.
So your honor may kindly release this entire amount.
Release
next
time ಮಾಡ್ರಂತೆ I will go on with this one.
ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡೋಣ. How can he say that?
ಅಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ ಸರ್ ಲಾಶಿಪ್ ಏನ್ ಬೇಕಾದ್ರೂ ಲಾಶಿಪ್ ಬರೀರಿ I'm not coming your lordship way.
Recover it from my owner ಅಂತ ಹೇಳಕ್ ಹೆಂಗಾಗುತ್ತೆ?
ಅಲ್ಲ ಓನರ್ ಅಲ್ಲ ಅದಕ್ಕೆ ರಿಕವರಿ ಮಾಡಕ್ಕೆ ನಿಮ್ ಡ್ರೈವರ್ ಇಂದ ಸಾಧ್ಯನಾ ಓನರ್ ಮೇಲೆ?
ಮಾಡಿದಾರಂತಲ್ಲ 3
ಅಲ್ಲ
lakhs.
ಬಿಕಾಸ್ ಈ ಸ್ಟೇ ಇತ್ತು ನನ್ನ ಮೇಲೆ ನಮ್ಮ ಮನೆ ಅಟ್ಯಾಚ್ ಆಯ್ತು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ.
ರಿಲೀಸ್ ಮಾಡ್ಲಿ.
ಡಿಪಾಸಿಟ್ ಮಾಡದಲ್ಲೇ ಇದ್ರೆ ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡ್ರಂತೆ ದಯವಿಟ್ಟು.
ಅದರ ಅರ್ಥ ಈ ಸೌಂಡ್ ಅಂತ ಆಯ್ತಲ್ಲ ಮನೆ ಬಿಡಿಸ್ಕೊಳ್ಳೋದಕ್ಕೆ ದುಡ್ಡು ಕಟ್ಟಿದ್ದಾನೆ ಅಂದ್ರೆ.
ಅಲ್ಲ ಅವ್ನು ಇಲ್ದಿದ್ರೆ ಅಲ್ಲಿ ಹರಾಜಾಕ ಅದಕ್ಕೆ ಲಾಶಿಪ್ ಅದು IA ಮಾತ್ರ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಪ್ಲೀಸ್.
No.
ಅಲ್ಲ
Consider that application also.
ಅಲ್ಲ ಫಸ್ಟ್ ಐ ವಿಲ್ ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಲ್ಸೋ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಅದಕ್ಕೋಸ್ಕರ ನೆಕ್ಸ್ಟ್ ಟೈಮ್
ಮಾಡ್ತೀವಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಿಯರ್ ಮಾಡ್ಕೊಂಡೆ
ಅದು ಹಿಯರ್ ಮಾಡ್ರಂತೆ ನಾನು ಲಾಶಿಪ್ ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಹಾಕಿ ಐ ವಿಲ್ ಗೋ ಆನ್ ವಿತ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ದಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
Respondent number 4 here.
ಓನರ್
4 is the owner.
R4 is the owner.
ಅದಕ್ಕೆ ಪೇಪರ್ ಬುಕ್ ತಂದೀನಿ.
He is aged 26 and this man is aged 45.
ಅಲ್ಲ ಡ್ರೈವರ್ ನೇಮಕ ಮಾಡ್ಕೊಂಡೇನು ಅದೇನ್
ಇದು ವೆಹಿಕಲ್ ಯಾವುದು?
Motorcycle.
Motorcycle.
The DC.
ಅದಕ್ಕೆ ಲಾಶಿಪ್
vehicle has hit from behind.
3 and 4. ಅಲ್ಲ 1 of 2020.
ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ಗೆ
Recalling ಎರಡು
ರಿಕಾಲಿಂಗ್ ಫಾರ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ವಿತ್ ಇನ್ 10 days ಆಗ್ತಾರೆ ಡಿಸಿಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
Claim against R4 is the appeal is dismissed.
ಅವನ ಮೇಲೆ ಹೋಗ್ಬಿಟ್ರೆ
Recall ಮಾಡಿ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು.
ಕನ್ಸಿಡರ್ ನಿಮ್ಗಿರಲ್ಲ ಏನು ಹುಡುಕೊಳ್ಳೋದೇ ಕಷ್ಟ ಆಗುತ್ತೆ. IA 1 is for stay ಅದು.
ಆಮೇಲೆ ಇದು ಸೆಕೆಂಡ್ ಸೆಟ್ ಇದು ಮಾಡಿದ್ದೀನಿ ಅದನ್ನು ಹಾಕಿದ್ದೀನಿ.
Memorandum of facts. Affidavit ಇಲ್ಲ.
ಎಲ್ಲಿ ಅಲ್ಲಿ ಬರೋಕೆ ವಿಜಯಕ್ ಬರುತ್ತೆ.
I am not able to comply the considering the reasons assigned to for the lapses. The order dated 14/8/2024 dismissing the appeal against respondent number 4 is hereby recalled. Appellant is permitted to take notice to respondent number 4 by publication in
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ.
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ.
Mangalore edition.
ಪೇಪರ್ ಇದು ಮಂಗಳೂರಿಂದ.
Mangalore.
ಕನ್ನಡ ಡೈಲಿ ನ್ಯೂಸ್ ಪೇಪರ್ ಮಂಗಳೂರು ಎಡಿಷನ್. As paper, notice shall be published.
Bangalore ಅಲ್ಲ sir.
25/9.
ಚಿಕ್ಕಮಂಗ್ಳೂರ್ edition.
ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ.
ಚಿಕ್ಕಮಗಳೂರು ಎಡಿಷನ್ ಇಲ್ಲ ಸರ್,
daily news
ಅದಕ್ಕೆ ಮಂಗಳೂರು ಎಡಿಷನ್ ಕೊಟ್ಟಿರೋದು.
ಮಂಗಳೂರು ಚಿಕ್ಕಮಗಳೂರು.
ಚಿಕ್ಕಮಗಳೂರು ಎಡಿಷನ್ ಇಲ್ಲ.
Circulation ಅಲ್ಲಿ ಬರುತ್ತಾ?
ಮಂಗಳೂರು ಎಡಿಷನ್ ಅಲ್ಲೇ ಚಿಕ್ಕಮಗಳೂರು ಸರ್ಕ್ಯುಲೇಟ್ ಆಗುತ್ತೆ. ಅದಕ್ಕೆ
Whatever, I have no objection.
ಈಗ ಒಂದು ಏರಿಯಾದ್ದು ಒಂದ್ 4 ಡಿಸ್ಟ್ರಿಕ್ಟ್ಸ್
ಅದಕ್ಕೆ ನಾನು ಕೊಟ್ಟಿರೋದು.
ಮಂಗಳೂರು ಕವರ್ ಆಗುತ್ತಾ?
ಹೌದು, ಕವರ್ ಆಗೋದಕ್ಕೆ ನಾನು ಕೇಳ್ಕೊಂಬಿಟ್ಟೆ ಮಾಡಿರೋದು.
ಮಾಡ್ಬೋದು.
ಉಡುಪಿ ಚಿಕ್ಕಮಗಳೂರು ಮಂಗಳೂರು ಒಂದ್ ಕಡೆ ಬರ್ತದೆ.
ಹೌದು, ಅಲ್ಲಿ ವಿತಿನ್ 80 kilometers ಫ್ರಮ್ ಚಿಕ್ಕಮಗಳೂರು ಟು ಮಂಗಳೂರು.
ಡೇಟ್ ಹೇಳಿ ನೋಟಿಸ್.
My IA for.
ಮಾಡ್ತೀವಿ.
ಆಯ್ತು.
15/10 notifying the hearing date as
15/10 ಅದು 25/9.
25/9. All right. Orders on I number ಎಷ್ಟು?
Objections.
1 of 2024. Heard. Under the above application, the claimant respondent ಎಷ್ಟವರು?
4.
1 to 3.
Response 1 to 3 are seeking. ಎಷ್ಟದ IA number?
1 of 24.
Release.
1 of
1 to
24.
3 are seeking withdrawal of the amount deposited by the appellant in compliance with the order of this court. In compliance with the condition imposed by this court for granting interim stay. Okay. Lower counsel for the appellant submits that appellant is only a driver.
Right.
And the owner, respond number 4, is liable to pay the compensation. Therefore, the amount shall not be released. Okay. It's hard to accept that driver is not at all liable for his tortious acts, and only the recovery should be against the owner. Okay. Death case alva?
That.
The claimants are ಯಾರು mother and father. Who was that? 26 years.
One is husband. 2 and 3 are children.
Oh, husband, woman died. Whether they were related to each other?
Yes, madam. First one is the husband.
ಅಲ್ಲ ಅವರಲ್ಲ. This
ಅಲ್ಲ.
appellant.
No. ಇವ್ರದ್ದು ಹಿಂದಿಂದ ಬಂದು ಹೊಡೆದದ್ದು ಇನ್ನೊಂದು ಬೈಕ್.
ಹಿಂದಿಂದ.
ಹಾ.
ಅದಕ್ಕೆ ಕಿಲಿಯನ್ ರೈಡರ್ ಅಂತ ಇತ್ತು. Another motorcycle number K16. Okay.
Deceased was the pillion rider in.
Their vehicle was driven by this first claimant.
First respondent. First appellant here.
ಅದಲ್ಲ, offending vehicle ಅಲ್ಲ. She was also traveling.
She was traveling in the vehicle of her husband.
ಅದಕ್ಕೆ he is responsible.
Yes. First respondent's vehicle ನಲ್ಲಿ ಹೋಗ್ತಾ ಇತ್ತು. As a pillion.
The husband and sons of deceased. Son ಅಲ್ಲ, ಒಬ್ರು daughter, son and daughter. The children of the deceased. Hearing of this matter make it 2018 case ಅದು.
ಹೌದು, 2018.
Therefore, tribunal deposit money. It's a fit case to release the amount to the respondent. Claimant. ಅದೇನೋ ಅವ್ರು ಮತ್ತೊಂದ್ಸರಿ ಹಾಕೊಂಡು ಯಾರೋ somebody 25% ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. we have shown lot of concession to him.
ಕನ್ಸೆಷನ್ ಅಂದ್ರೆ ಅವ್ನು ಕೊಟ್ಟಿದ್ರೆ ಇನ್ನು ನಿಮ್ ಅಪೀಲ್ ಹೋದ್ರೆ ಅದು ಸಿಗ್ತಾ ಇರ್ಲಿಲ್ವೇ?
The tribunal shall release the amount in deposit.
ಈಗ ಅದ್ ಮಾಡಿದ್ದೆ ತಪ್ಪಾಗ್ಬಿಡ್ತು ಅಂತ
claimants in
ಅರೆಸ್ಟ್ ಆಗಿದ್ದು
digitally subject to the result of this appeal.
Yes, much obliged.
ಸೆಕ್ಯೂರಿಟಿ ಮೇ ಬಿ ಗೆಟನ್ ಅಂತ ಹೇಳಿ, ಯಾಕೆ ನಮ್ಗೆ ಇದಾದ್ರೆ
ಹೇಳೋದಿಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ನಿಮ್ಮ ಮೇಲೆ ಆಗಿತ್ತಾನೆ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅವ್ರು 2 vehicles ಆರ್ ಇನ್ವಾಲ್ವ್ಡ್.
ಅಲ್ಲ, ಅವರು
ಅವ್ರ ಮೇಲೆ 50-50 ಬರೋನು ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಕಮ್ ಇನ್ ಫೋರ್ಸ್ ಅಲ್ಲ ಲಾಶಿಪ್.
Cell number 17, Manisha Kangovi. Dulfikar Kumar Shafi.
Appear for respondent 1 to 3. It's my application for an early hearing. I was the plaintiff before the lower court. It's a suit for money recovery. There is a decree in my favor, my lord, but till date I have not been able to get the benefit of the decree.
This suit have year is
2013.
2013.
13.
What was the defense?
was the termination that was suppressed.
No, there is no suppression.
Contract, no?
Yes, there was an MOU entered into between the parties.
ಏನು security court withdraw ಮಾಡ್ಬೋದು ಅಂತ ಏನು ಮಾಡಿಲ್ವಾ? How much is deposit?
No, I filed an application.
10 crores is deposited. my lord.
50% is deposited. I filed an application
For release.
for release,
Ah.
but it was objected by them, so that
That application is disposed of or pending?
Dismissed.
dismissed. But this application is
Started and
dismissed. Because there are three ladies, 1 to 3. And the first one's husband is not working. Second one is suffering from a very debilitating disease, multiple sclerosis. Third one is a divorcee. Now, this was the last asset they had. Now they are all literally on the streets. my lord.
Considering, the original proceedings are of the year 2013. The respondents plaintiffs, those succeeded, are not able to reap the fruits of their decree. Therefore, this for final hearing on
4 weeks.
2 weeks.
25/9.
Publish.
IA number ಎಷ್ಟದು?
1 of 24.
1 of 2024 is disposed of accordingly.
26th or 27th?
26 ಅಂತ.
26.
26.
26th.
Yes.
Publish.
18.
Yes, sir.
Allur Shivayogi Baswaraj.
Yes, sir, appearing for appellant, my lord. Lord, appellant is a defendant number 1 and respond number 1 is the plaintiff and respond number 2 is a defendant number 2 and the respond number 2 is selling with the appellant, my lord. The suit is for declaration that the sale deed dated 2/3/2000.
Say for condonation of delay 198 days.
My lord, 198
My lords,
days.
ಅವ್ರು ಹೇಳಿ ಮೊದಲ ಡಿಲೇಗೆ ಯು ಆರ್ ಸೀರಿಯಸ್ಲಿ ಅಪೋಸಿಂಗ್ ದ ಡಿಲೇ?
no, my lords, I have no objection to allow that, but I have one problem. Today only I have received the files. With regard to other IA, maybe I require some time to go through the. First time I may consider.
It is for stay.
Stay, my lords. I do not.
2022 and the pending.
Today only I have received the file, my lords.
When did
So,
you appear?
uh,
When did you appear in the case?
oh, my lords, my colleague has given me today only. I need 1 week accommodation, my lords, so that I will appear on the next date of hearing.
8 days. What is the reason you have said for?
My lord, for delay, earlier before coming,
Health, senior citizen, ill health, old age, etc.
please. And now the execution court has issued the delivery warrant against the appellant, my lord.
Once,
Hence I-
first we'll condone the delay.
Please,
I order sir 1 of 22. But considering the reasons assigned to explain the delay of 198 days in filing the appeal is condoned in the interest of justice. I number 1 of 2022 is disposed of accordingly. You know, what was the suit for?
my lord, suit for declaration, declaring that my sale deed dated 2/3/2005 is null and void. And subsequent sale deed for the year 2009 is also null and void. And the suit is declared in favor of the plaintiff, respond number 1 herein.
She is the earlier purchaser. She or he?
No, my lord. The appellant has purchased the property from the brother of the plaintiff
Not binding on her. at that
on
time.
bond.
What was the date of the sale?
My lord, 2005, my lord, 2/3/2005, and suit is filed in the year 2015.
Registered sale is.
Yes,
Now possession is also.
position with the appellant, my lord. Now, the execution court has issued a delivery warrant, hence I am praying for the stay, my lord.
No, I have to secure instructions. Only 1 week.
You undertake that you will not precipitate in the execution proceedings.
No, because tomorrow morning only the,
Files. Sale deed has challenged in 2015, that's what he's saying.
my lord, I got an instruction from my client. Today, Amin is there in the site, my lord.
For TCRs, admit ಆಗಿರ್ಲಿಲ್ಲ ನೀವು?
ಆಗಿರ್ಲಿಲ್ಲ, sir.
Call for TCRs, appellant's counsel shall submit the paper books within 4 weeks ಅಲ್ಲಿ ಹಾಕಿ ನೀವು paper
Please.
books. ಎಷ್ಟು ಜನ witness? 3 witnesses, ಒಂದ್ ಕಡೆ 31, ಇನ್ನೊಂದ್ ಕಡೆ 15 documents.
ಹೌದು.
Within 4 weeks, it is submitted that the decree is for the declaration and possession. Appellant's counsel shall submit that delivery warrant is issued.
How submit? I am
The
kindly
delivery
permit.
warrant is issued against the appellant. 2005. As per the records, the sale deed executed in, registered sale deed executed on 2/3/2005 was questioned in 2020. Considering the aforesaid facts and circumstances, interim stay of the execution of the interim decree till further orders. Any one of those, 2022 is
So that's
disputed
some,
accordingly.
a date may be fixed, but I will come prepared so that, please.
Now one submission, my lord.
1610.
And delivery, my lord.
Hand delivery of the order is permitted. List on 1610. 1610.
Publish.
Memos.
Memo ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Still number 19, L. Srikant Rao.
I filed an application for the notice
Substituted
But-
service.
for 6 or 6 is the issue.
Second respondent filed an application for withdraw the amount of deposit by the appellant, my lord.
Who is R6?
R6 is the owner of
Owner of
the
the
owner insured.
What is the point involved?
ಹೋಗಿ ಎರಡು ಸಾರಿ ಹೋಗಿತ್ತು.
What is the point involved?
Negligence. The deceased himself was charge sheeted by the
Two vehicles.
police for not possessing a valid license, was riding the motorbike.
Lorry and two-wheeler.
Two-wheeler.
Charge sheet was filed against him only.
Against my driver, my lorry driver.
Lorry
Also
driver.
against the insure the deceased.
Deceased motor vehicle.
Charge sheet was filed, not filed against.
Both the drivers, injured
Sir.
rider and injured driver of injured vehicle.
Now, have you examined the lorry driver? Lorry driver and examine ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ sir, ಮಾಡಿಲ್ಲ.
Early,
Officer ಮಾಡಿಲ್ಲ.
Officer was not an eyewitness.
I can.
So now, even assuming that 50% reduce ಆದ್ರೂ ನಿಮ್ದು contributed.
ಅದು
Now,
50% release ಮಾಡಿ. 50% of the deposited amount.
you have deposited 50% of the award.
ಹೌದು. ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇದು deceased himself was responsible for the accident. ಅದು condition ಮಾಡಿದ್ದೀವಿ ನಾವು.
So, you have not examined the driver of the
No, I
lorry. Then
ಅಲ್ಲ charge sheet has been filed against him. Filed.
substituted service. So first orders and I number 1/2024. ನಿಮ್ ಕನ್ಸೆಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೋಬೇಕಾ 50% ನಾವೇ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ 50%.
Appellant's counsel submits that an appellant's counsel under the above application, the claimants respondent number 1 to
1 to 4, my lord. 2,
1 to
respondent number 2 filed a application for the amount, release amount.
respondent number 2 ಮಾತ್ರ
2
ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಮಾತ್ರ ಹಾಕಿದ್ರೆ ಅವ್ರಿಗೆ ಅದರ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರ ಹೆಸರು ಬಿಡುಗಡೆ ಮಾಡಿ ಅಂತ. ರಿಲೀಸ್ ದ ಅಮೌಂಟ್ ಆಫ್.
ಯಾಕೆ ಒಬ್ಬರಿಗೆ ರಿಲೀಸ್ ಮಾಡ್ಬೇಕು ಅಂತ? ಹಾಗೆಲ್ಲ ಮಾಡಕ್ ಆಗಲ್ವಲ್ಲ?
ಆಯ್ತು,
ಒಬ್ಬರಿಗೆ ರಿಲೀಸ್ ಆಗ್ಬೇಕು.
ಆಗ್ಲಿ ಸರ್.
Application
favor of
is
the-
filed by respondent number 1 to 4 ಅಂತಾನೆ ಹಾಕಿದ್ದೀರಿ.
24.
Application ಅಲ್ಲಿ 1 to 4 ಅಂತಾನೆ ಹಾಕಿದ್ದೀರಿ.
ಸರಿ.
Under the above application, the claimants respondent 1 to 4 are seeking release of the amount in deposit. Appellant's counsel opposed the application that the appellant had had questioned the liability on the ground that the deceased himself was negligent. According to him, the charge sheet was filed both against the deceased and driver of lorry that is respond number 5. The records show that the driver of the lorry was not examined under the circumstances. Tribunal alva?
Before trip.
Tribunal shall digitally release 50% of the amount in deposit to the claimants in terms of the award and furnishing required documents. I 1/2024 is disposed of according to 1/20.
ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ದಾಗಿದೆ.
ಇಲ್ಲೇ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲಿ ಮಾಡಿ.
ಇಲ್ಲೇ ಆಗಿದೆ.
Registration deposit.
17/1/2023 ನಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಅಮೌಂಟ್ ಅಪಲೆಂಟ್ ಮೈ ಲಾರ್ಡ್ಸ್. ಇಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲೇ ಮಾಡಿ.
ನೀವೇ ಮಾಡಿ.
Registration. ಇನ್ನೊಂದು ಯಾವ್ದು? IA ಅವ್ರದ್ದು? IA 2024.
9,08,360.
ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರ ಅವರು? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವ್ರು ಕಾಂಟೆಸ್ಟ್ ಮಾಡಿದ್ರು?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ if you are not disputing any breach of condition of the policy,
ಅದೇನಿಲ್ಲ. ಇದೊಂದಷ್ಟು ಡ್ರೈವರ್
ಯಾಕೆ ಕೇಳ್ತೀರಿ?
ರೈಡರ್ ಹೆಡ್
ಅಲ್ಲ, ರೈಡರ್ ಆಫ್ ದ respond number 5 is the rider of the scooter. ಅಲ್ಲ,
ಅಲ್ಲ ನಮ್ಮ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಇಲ್ಲಿ 5 is the driver of the insured ಇದು insured lorry.
ಯಾಕೆ ಕೇಳ್ತಾ ಇದೀರಿ ಅವ್ರ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅಂತ? ಬಿಕಾಸ್ ಯು ಆರ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟಿಂಗ್ ದಟ್ ಯು ಹ್ಯಾಡ್ ಇನ್ಶೂರ್ಡ್ ದ ವೆಹಿಕಲ್. ಮತ್ತೆ ಯಾಕೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಳ್ತೀರಿ? ಡಿಸ್ಪೆನ್ಸೇಷನ್ ತಗೋಬೋದಿತ್ತಲ್ಲ.
I will file it.
1 to 4 ಮೆಮೊ ಫೈಲ್ ಅಂತ ಬರ್ಕೋಬೇಕಾಗಿದ್ರೆ ನಾನು ಸ್ವಲ್ಪ appellant files submits memo for dispensation of notice to ಎಲ್ಲ ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 5 and 6 ಅಂತ ಇಬ್ಬರಿದ್ದಾರೆ. ಅದಕ್ಕೆ
ಅಲ್ಲ 5 ಡ್ರೈವರ್ ಆದ್ರಿಂದ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡ್ಬೋದು. 5 is respond number 5 driver.
5 is
driver.
Sivanesh and driver. You are seeking to 6. Respond number 6, the owner of the insured vehicle. Since the liability of the insurer is not in a dispute, notice to respond number 1 is dispensed with as paid for. In view of this aforesaid order, I number 2 of 2024 does not survive for consideration and disposed of accordingly. ಇದ್ರಲ್ಲೇನೀಗ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ?
ಬಂದಿದೆ ರೆಕಾರ್ಡ್ ಬಂದಿದೆ. It could be posted in next week somewhere.
ಇಲ್ಲ
ನೋಟಿಸ್ ಅಷ್ಟೇ ರೆಕಾರ್ಡ್ಸ್
ಬಂದಿಲ್ಲ. ಅಡ್ಮಿಟ್ ಆದಂಗೆ ಕಾಣೋದಿಲ್ಲ. Admit call for TCRs. Paper book page ಇದರಲ್ಲಿ ನೆಮ್ಮಿಸ್ ಇಲ್ಲ ಇದೆ. But one thing is that tribunal record ಇಲ್ಲೇ ಕೊಡ್ಬೇಕಲ್ಲ, ಹಾಗಾಗಿ ನಾವು call for TCRs list after 4 weeks.
Much.
Number 20, Shivkumar.
The delay is because the appellant, who was the third defendant,
have
he was placed ex parte.
Hanumantrayappa has filed the caveat only for respondent number 1, no?
Yes, ma'am, plaintiff. He was the plaintiff. Not the contention raised here is, not the appellant is a resident of Chennai.
But copy serve ಮಾಡಿದ್ದೀರಾ ಅವ್ರ ಮೇಲೆ? Have you served the copy of
Yes,
the
yes.
caveat?
They have been sent, madam. Copies have been served, everything is done.
ಜನರಲಿ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ತಿರ್ತಾರಲ್ಲ.
ಆಗ್ತಾರೆ.
ವಕಾಲತ್ ನಾಟ್ NOC ವಕಾಲತ್ ಫೈಲ್ ಯಾರೋ ಶ್ರೀಧರ್ ಅಂತ ಎನ್ ಶ್ರೀಧರ್ ಅಂತ
ಎನ್ ಶ್ರೀಧರ್ ಫಾರ್ R1.
ಅವರು ಹನುಮಂತರಾಯಪ್ಪ was also appearing for R1. Yes, what is the matter?
The matter is this, there is a delay because the third defendant, who was a party in the proceedings, but he was not served with the notice. Paper publication taken to him was in Bangalore city, whereas he is a resident of Chennai. Suit is decreed. He is the owner in possession of the property. If the notice,
order ಮಾಡೋಣ ಇವ್ರಿಗೆ. ಡಿಲೇ ಇದೆ ಅಲ್ಲ, ಅದರ್ 2 respondents.
they are all served. All are served.
No, ಇಲ್ಲ ಎಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ. R1 ಮಾತ್ರ ಕೇವೆಟ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ.
ಹೌದು.
2 and 3 are not served.
Not all are served.
ಇಲ್ಲ.
Notices have been taken on all of them.
No, ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ. ಡಿಲೇ ಇರೋದ್ರಿಂದ ನೋಟಿಸೇ ಹೋಗಿಲ್ಲ. ನನ್ನ ಅಪಿಯರ್ಸ್ ಲಾಸ್ಟ್ ಟೈಮ್ ನನ್ನ ಅಪಿಯರ್ಸ್ ಅಂತ 18/1/2024 ಬಂದಾಗ, even before that on 9/1/2024 none appears. Issue notice of IA 1 of 2023 to response 2 and 3 list on
1410.
14.
Number 21, Jagdish HT.
I'm appearing for the second respondent, your lordship. I have no objections for condoning the delay, and the TCR may kindly be called for as the claim petition has been dismissed.
Delay may be condoned. Case of injury.
The claim petition is dismissed. Call for TC.
25 years.
Please.
Order number 1 of 2023. 9 days. Considering the reasons assigned to explain the delay of 9 days in filing the appeal is condoned in the interest of justice. IA 1 of 2023 is disposed of accordingly. Admit. Respond number 1 ಏನಾಗಿತ್ತು?
1 served. Already served.
Admit call for TCRs. List after 4 weeks.
Please.
Please, your lordship.
Cell number 22, CR Ravishankar, KT Gurudev Prasad.
Appellant in 7143 of 23.
33 days, ಅವರಲ್ಲಿ 106 days.
ಅವ್ರದ್ರಲ್ಲಿ 106 ನಮ್ದ್ರಲ್ಲಿ
ಕಂಡೌನ್ ಮಾಡ್ಬೋದಲ್ಲ ಎರಡು ಕೇಸಲ್ಲಿಂದ 22.1 ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ವಕಾಲತ್ ಆಫ್ ಶ್ರೀ ರವಿಶಂಕರ್ ಶ್ರೀಆರ್ ಫಾರ್ R1 is taken on record. ಈಗ ಎರಡು ಕಾಮನ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. Considering the reasons assigned to explain the delay of 123 days in filing MFA number 7143 of 2023 and 106 days in MFA number 6599 of 2023 is condoned in the interest of justice. IA 1 of 2023 in both the appeals are disposed of accordingly. ಏನಿದು
Filed application seeking permission to withdraw the amount.
ಅವ್ರು ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ನೀವು ಯಾರ ಪಿಚ್ ಗ್ರೌಂಡ್
Quantum.
ಓನ್ಲಿ ಕ್ವಾಂಟಮ್ ರಿಲೀಸ್ ಮಾಡ್ಬೋದು ಹಾಗಾದ್ರೆ ಅಮೌಂಟ್ ಇನ್ ಡೆಪಾಸಿಟ್ admit call for TCRs orders. How much is deposit is
59 lakhs.
59 lakhs 17,066.
1 crore 18 lakhs.
Early before tribunal.
PAN card etc. What was he?
He was a civil engineer, supervisor. Amputation of above knee.
23 years, very. Only the quantum of compensation is under dispute. Therefore, under circumstances, ಇಲ್ಲಿದೆ ಅಲ್ಲಿದೆ ಟ್ರಿಬ್ಯುನಲ್
ಟ್ರಿಬ್ಯುನಲ್ ಮಾಡಿರೋದು.
The amount in deposit to the claimant digitally and furnishing the required documents. IA 1 of 2024 is disposed of accordingly. Admit call for list for final hearing and receipt of the TCRs.
Admittedly.
Admitted.
Cell number 23, Nehru P, GM Srinivas Reddy.
Vacating state.
The respondent. On the last date of hearing, the name of Srinivas Reddy is directed to be deleted. My name is Shubh.
You are appealing.
I have filed NOC.
Since 23, since Shri DP Mahesh has filed wakalat for respondent. Only
both the
he
matters.
shall be shown in the cause list, henceforth for the respondent.
Yes,
Is vacating stay.
2 weeks time may kindly be granted. In the meantime, we are also negotiating with the party.
ಇನ್ನೊಂದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಅಲ್ಲಿ ಡಿಲೇ ಇದೆ ಅಲ್ಲ
Delay may be condoned. It may be condoned. One is for dissolution of marriage.
ಫಸ್ಟ್ ಅಪೀಲ್ ಆನ್ ಟೈಮ್ ಮಾಡಿ ಸೆಕೆಂಡ್ ಟೈಮ್ ಯಾಕೆ ಡಿಲೇ ಮಾಡಿ
ಅಲ್ಲ in fact we have filed a common
ಕಾಮನ್ ಅಪೀಲ್
appeal.
against 2 decrees.
Then the officer has objected, hence we have prepared 2 different appeals.
650.
Yes, there is a delay.
Accepting the reasons assigned to explain the delay of 3 days in filing the appeal is condoned in the interest of justice. IA 1 of 2024 is disposed of accordingly. ಇದರಲ್ಲಿ ಎರಡರಲ್ಲೂ ಕಾಮನ್ ಆಗಿ heard matter requires
No, it is already order is passed. I have filed application for vacating because the interim order is until further order.
ಅಷ್ಟೇ ಅಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿತ್ತಾ ಅಡ್ಮಿಟ್
ಆಗಿದೆ.
ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಟ್
ಆಯ್ತು.
ಆಗಿದೆ 650 ಅಲ್ಲಿ 650 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ connected matter is already admitted. Hence admit this matter also for hearing. Vacating stay ಹಾಕ್ಬೇಕು ಈಗ.
Until further orders ಇದೆ. Therefore, after appearance, I have filed application. Let it be for vacating only. In the meantime, we are negotiating. If it is admitted, parties will not show interest. That is why.
Settlement ಆಗೋ ಚಾನ್ಸ್ ಇದೆ.
Yes, that is what we have discussed just now.
Seek time to explore the possibility of settlement and report. List after 2 weeks, huh?
Yes, ma'am.
List after 2 weeks.
Obliged.
Cell number 24, Krishna Kishore S.
Lord, insurance company appeal me, Lord. Lord, a case of death. He was working as mechanic.
Delay ಇದೆ ಅಲ್ವಾ? Issue notice for the respondents.
24 days.
How much is awarded?
Lord, 27,36,000.
50% deposit ಮಾಡಿ.
ತಮ್ಮಂದೇನೆ ಮಾಡಿದೆ ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ we deny the issuance of policy in respect of offending tractor and trailers.
ಆದ್ರೆ interim stay ಬೇಕಾದ್ರೆ deposit.
ತಮ್ಮ ಮುಂದೆ
404 ಎರಡು ಇತ್ತಲ್ಲ ಕೇಸು. There are two claim petitions.
ಹೌದು ಸರ್, ಒಂದು ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಬರುತ್ತೆ.
ಇದು 405 ಒಳಗಿಂದ.
ಹೌದು ಸರ್, ತಮ್ಮ ಮುಂದೆ ಇರೋದು 405 ಡೆತ್ ಕ್ಲೇಮ್ಸ್.
ಎಷ್ಟು award ಆಗಿದೆ? 27,36,000.
ಹೌದು ಸರ್.
Interim stay of execution of the improved award till next hearing date. Subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of.
ತಮ್ಮ ಮುಂದೆ ಮಾಡ್ತೀನಿ, ಲೈಬಿಲಿಟಿ ಇಲ್ಲ ನಮ್ದು ಅದಕ್ಕೋಸ್ಕರ.
ಬೇಡ, ಅಲ್ಲೇ ಮಾಡಿ.
ಸರಿ ಸರ್.
List on
2110.
issue notice ಅಂತ ಮಾಡಿದ್ದೀನಿ. List on
2110.
21.
ಮಾಡ್ತೀನಿ.
Till number 25, Monish Kumar KB.
Time for the appellant in this case, my lord, the next party judgment and decree, lords. The plaintiff, my lord, the defendant, my lords, appellant before my lords, is a well-known, my lords, a press person, please, my lords, working, my lords, for various national press, my lords, sports media. He has accompanied the Indian cricket team.
Notice.
Please, my lords. Now, ex parte decree, please, my lords, I have suffered. A defamation, please, my lords, a suit for defamation and damages.
Sir, no.
I was served, but my lords, what happens is, I was not notified, my lords, by my counsel.
ಬೇಕಂದ್ರೆ ಮಾಡಿ.
I was not, my lords, the execution ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ನನ್ನ ಮೇಲೆ. ಅಲ್ಲಿ my attached mobiles ಎಲ್ಲ.
ಈಗ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲೂ ಡಿಲೇ ಮಾಡ್ತೀರಿ.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಪಾಪ, he did not know correctly.
ಏನೇನು ಪಬ್ಲಿಷ್ ಮಾಡಿದ್ರು ಅಂತ ನೋಡಿದೀವಿ ನಾವು ಇದ್ರಲ್ಲಿ.
He did not know, please, my lords, that the suit has been decreed against him.
You are very public spirited person. ಇದನ್ನೆಲ್ಲ ಪಬ್ಲಿಷ್ ಮಾಡಿಸ್ತೀರಿ, ಎಲ್ಲ ಮಾಡ್ತೀರಿ.
Until the
appear before the trial court. Here also you cause delay in filing the appeal.
What transpires is, my lords, he was not aware, please, my lord, that the suit has been decreed. And he was not, till notice of execution proceedings only, please, my lords, he realized that, my lord, the suit has been decreed.
But on your behalf, some advocate had appeared.
Appeared, my lords, kindly appreciate, my lord. Thereafter, page number 52, please, my lords. Page number 52. Page number 52, my counsel is not represented.
Deposit the entire amount will grant
Where he
stay.
will deposit, he is a sports person, please, my lords. He cannot, my lords.
Issue emergent notice of.
But, my lords, at least till such next date, my lords.
List on.
Let's, some expert in, let's kindly appreciate page number 52, my lords. He is a
Sorry, it is not expert here, third and
third
represented.
represented, my lords, but my counsel, my lords, page number,
Right, Nodi, we are giving you two options.
please.
Either you deposit the amount, then we'll grant.
Let's
interest rate.
deposit the amount, so at least
Delay also.
50% of a time.
ಇರೋದೇ 1 ಲಕ್ಷ ಇದೆ.
50% of a time.
Sorry, yes, next.
I will deposit it. I'll ask him to deposit. There is no other alternative. Otherwise, my,
ಅವರು ಏನಾದ್ರು ಅಪೀಲ್ ಹಾಕಿದಾರ ನೋಡಿ, ಯಾಕಂದ್ರೆ ಅವ್ರು ದೇ ಹ್ಯಾಡ್ ಸಾಟ್ ನೋಡಿ ಪಬ್ಲಿಷ್ ಮಾಡಿಸಿರೋದು ಸ್ಟೇ. ಮತ್ತೆ ಯು ಶುಡ್ ನಾಟ್ ಪಬ್ಲಿಷ್ ಎನಿ ಡಿಫಾಮೇಟರಿ ಆರ್ಟಿಕಲ್.
kindly appreciate this aspect. The plaintiff himself was, my lords, embroidered, please, my lords, in various aspects, please, my lords.
He is embroiled in something.
And it was general public.
Not only payment of amount.
Lords, I will pay, please, my lords.
Notice.
Let's execution ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ನಾನು.
Execution.
I will deposit, please, my lords.
Stay only recovery of the amount, not the other part of the amount, other part of the decree.
Let's, my submission,
Injunction decree also.
please, my lords. No, my lords, freedom of press, my lords, it can't be curtailed, my lords. My lords, may I execution ಹಾಕೊಂಬಿಟ್ಟೆ.
For the appellant insists for the interim stay. Okay.
I will deposit, my lords, minimum amount, my lords.
Filing the appeal and the appellant had not contested the matter despite.
Page number
giving
52, my lords, it is.
Okay. We do not find any grounds to grant ex parte interim stay. Issue emergent notice to the respondent. List on
18-9.
Let me ask, execution is going on, my lords, my mobiles will be attacked.
ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲೇ ಕಟ್ಟಿ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಕಟ್ಟಿದ್ರೆ
ಅಲ್ಲ,
ಕೊಡ್ತಾರೆ.
I'll submit our direction, my lords. My humble prayer, please, my lords. ಅಲ್ಲ, execution ಹಾಕೊಂಡಿದ್ದಾರೆ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ 1 ಲಕ್ಷ ಕಟ್ಟಿ.
ಅಲ್ಲ, I'll deposit it here only, please, my lords, my lords.
ಬಾರ್ಗೇನ್ ಮಾಡ್ತೀರಿ.
ಅಲ್ಲ, ಇಲ್ಲೇ ಕಟ್ತೀನಿ.
We stay only that recovery aspect ಅಂತ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ
Please.
you have freedom of.
No, I will advise him not to go ahead with any publication, please, my lords, as against this person. Against this person, I will advise him, lords, not to go against any.
We have passed the order, please. Next person.
ಇಲ್ಲ, execution ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಕಷ್ಟ. ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ನೀವು ತಾವು ಆರ್ಡರ್ ಮಾಡ್ಬಿಟ್ರೆ ನನಗೆ ಅನುಕೂಲ ಆಗತ್ತೆ ಸ್ವಾಮಿ.
Sorry, we cannot go on showing indulgence to this kind of people.
Only submission.
Pressurizing the courts also so much.
My only submission.
We have already recorded that your prayer is rejected. Please, you should.
I will make good, please, my lord, the deposit, my lord. Subject to condition ಮಾಡಿ ಸ್ವಾಮಿ.
Tippeswamy BC.
This case I
am affair for respondent number 1 to 3, my lord.
he will take steps against the owner of the vehicle. A week's time may be granted, my lord.
Withdrawal of the amount gain.
Yes,
And
ma'am.
I have challenged the liability.
On what from?
On a permit,
There are two ground, my lord. On that ground, I am challenging the liability. One is, my lord, there is no permit to play the vehicle on the public road.
It at all or?
And the vehicle is, please.
RTO examine ಮಾಡಿದ್ದಾರೆ my lordship.
Our article.
ಅವರು ಆ ಟೈಮ್ ಅಲ್ಲಿ
Right.
ರೂಟ್ ಪರ್ಮಿಟ್ ಇಲ್ಲ ಅಂತ
The
ಹೇಳಿದ್ದಾರೆ.
accident was occurred in the private place. And the insured vehicle was not involved in. What has happened, that while unloading the grenade from the lorry, he was standing in front of the lorry. At that point, the crane, while removing the slab from the lorry, it is fell down. Therefore, my lord, he has filed a claim petition against the motor, under the Motor Vehicle Act.
It doesn't amount to motor accident
Please,
antana?
please.
Workman's compensation antana?
ಅಲ್ಲಲ್ಲ
If-
MSC
if
my lord.
he comes, my lord, if
There is
if
a
the
make
court
and-
comes to conclusion that, my lord, he may enter, but under the third party compensation, he is not, the claim petition is not maintainable.
But the statistic is at least you have
That's
to take a notice also at the earliest.
Out, none.
Or for the second time.
ಅವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡಿದ್ದೀನಿ, ಸೆಕೆಂಡ್ ಟೈಮ್
Contest ಮಾಡಿದ್ರ second?
ಇಲ್ಲ ಇಲ್ಲ, ಈ ಪ್ಲೇಸ್ ಎಕ್ಸ್ಪರ್ಟ್.
Respond to Zina. Then why do you want to take notice here? Contest ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರ expert ಇದ್ರಿ?
ಈ ಪ್ಲೇಸ್ ಎಕ್ಸ್ಪರ್ಟ್.
Respond. What was her rank? ಇಲ್ಲಿ Zina Devi, petitioner number 2.
ಹಾ, ಇದ್ರಲ್ಲಿ
You are not filing.
Petition. Climates, petition,
Let's-
respondent number 1 to 3 my lord.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಈಗ ನೋಟಿಸ್ ತಗೋಬೇಕಾಗಿರೋದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಆಗಿ
Eh,
ಸಾರಿ
respondent number,
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
respondent number 4 my lord.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ವಾಸ್
Owner of the T Ravi. Insurance company appeal. Respondent number 4 ಗೆ
ಸ್ಟೆಪ್ಸ್ ಆಗಿದೆ.
he was respond number 1.
ರೆಸ್ಪಾಂಡ್ ಈ ಪ್ಲೇಸ್ ಎಕ್ಸ್ಪರ್ಟ್.
respondent number 1.
I filed the necessary memo to it.
Necessary. Nana counsel for the appellant submits memo for dispensation of notice to respondent number 1. The record show that respond number 1, respond number 4, I'm sorry. Record show that respond number 4, who was respond number 1 before the tribunal, had not contested the matter despite service of notice. Therefore, notice to respond number 4 is dispensed with as paid for. Appellant's counsel
reach out
expressly disputes the insurer's liability and applicability of the MV Act to the case, to the incident. ಆಯ್ತು, ರೆಕಾರ್ಡ್ ಬರ್ಲಿ, ಒಂದೇ ಸರಿ ಹಿಯರ್ ಮಾಡಿ ಮುಗಿಸ್ತೀವಿ.
ಇವ್ರದ್ದು ಏನು ಅಪೀಲ್ ಇರ್ಬೇಕಲ್ಲ?
ನಮ್ದೇನು ಅಪೀಲ್ ಇಲ್ಲ ಮಹಾರಾಜ್. ಅಪೀಲ್ ಏನ್
ಆಯ್ತು,
ನಿಮ್ದು ಅಪೀಲ್ ಇದೆ?
ಅಪೀಲ್ ಏನಿಲ್ಲ.
ಇಲ್ಲ.
Appeal
ಎಸ್ ಸಿ ಆರ್ ಕಾಲ್ ಮಾಡಿ ಸ್ವಾಮಿ, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಲೆಟ್ ದಿ
22:10.
ಮಚ್.
ಇಲ್ಲ, ಬೆಂಗಳೂರು.
Number 27, Krishna Kishore S.
This is the death claim, Lord. The appeal is filed against the award made by the tribunal questioning the liability, my lord.
ಇಲ್ಲೇ ಇದೆ ಅಲ್ಲ?
22,95,596 is awarded death claim.
Auction notice to the respondent. 50% deposit money. Interim stay of execution of the influent award till next year ended, subject to appellant depositing 50% of the award amount before the tribunal within 4 weeks from the date of this order. List on
22:10. For admission, cell number 28, Sanat Kumar Shetty.
In this matter, my lord. Respondent number 5 died recently, my lord. 1 week time may be granted for taking steps to
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು connected.
connected matter 1871 of.
But you have to file a memo at least to that effect.
Morning only party intimated the same matters.
Is that correct? Whether they are related to each other, partition suit.
Yes, my lord.
Respondent number 5, who is?
Yeah. 3.
ಅಲ್ಲಿ try ಕೊಡಿ.
Current is.
She was defendant number 5. But ನಿಮ್ sister ಅಲ್ಲ, ನಿಮ್ಗೆ
Yes,
ಗೊತ್ತಿರತ್ತೆ.
yes, manage. Morning, parties intimated this.
Submits that respond number 5 reportedly died and seeks time to fix. Report the matter. You have to
This-
file a memo for
This,
that
this,
respect first.
within week, I will. Text.
Next after 2 weeks. He connected laterally R5 and 7 for the second time. At request finally, 2 weeks time is granted to do the needful in respect of R5 and 7. Failing which appeal against them shall stand dismissed. Okay.
This.
Next after 2 weeks.
Till number 29.
Previous matter. 2110 years. Number 24, 2110 ಕೊಟ್ಟಿದೆ. 27 ಕೂಡ 2110 ಇದೆ.
2110.
Sorry,
That
21.
Serial number 27.
27, 2110. Till number 29, Nataraj Ballar, S. Satisha.
Appear for the appellate. But I have filed an application for TI. He has entered appearance. I will serve a copy on him.
TI, CD in filing. delay in
Except
sitting
that,
aside.
my lord, the,
LRs of
Yeah, yes,
ಇನ್ನೂ
it is,
notice
no.
ಹೋಗಿಲ್ವಾ? ಅಲ್ಲ, you have appeared for.
I have already entered appearance on behalf of
So
respond.
applications can be allowed.
That, those applications can be allowed.
1 of 23, 2 of 23 and 3 of 23.
3 of 23 can be allowed.
So only about R3, no?
How?
ರಾಮಕೃಷ್ಣ.
Field memo ಬೇಕು. Field memo ಇಲ್ಲ.
ಅವರೆಲ್ಲ ಬ್ರದರ್ಸ್ ಏನೋ ಅವರು R1
ಎಲ್ಲ family
Yeah,
parties within the
All
family.
are family members.
number 1. Addition I number 1
One is
1 to
of
3 of
24.
2023. 1 to 3 of. What else? Applications ಇಲ್ಲ 1 of 2023. ಮೂರೇ ಜನ ಇರಲ್ಲ, only 3 LRs are there.
Yes, yes.
How much delay is there? 426 days. ಯಾಕೆ ನೀವು ಸ್ಟ್ರೇಂಜರ್? Yeah. Set aside the abatement ಅಂತ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ. You abated the death, ಏನದು?
Sorry, I correct it. Got it. For court purpose. Lord, since he has appeared, my lord, I will file a memo. Those IAs may be.
ಅದಕ್ಕೆ
has
dispose.
not pressed, not.
ಅಲ್ಲ ಅಲ್ಲ.
ಅಲ್ಲ ಮಾಡ್ಬೇಕಲ್ಲ ಅದು ಅಪ್ಲಿಕೇಶನ್.
It has to be allowed.
You have to amend the constitution.
First it is.
Yes, yes.
Third, accepting the reasons assigned to explain the delay of 426 days in filing. I number 2 and 3.
1/23, 2/23.
Is condoned. Abatement of the appeal against respond number 3 is set aside. Appellant is permitted to bring on record proposed respond number 3A to C as the legal representatives of deceased respond number 3 on record. Appellant's counsel shall amend the constitution of the appeal memo and furnish the copies of the amended appeal memo. Furnish the copy of the amended appeal memo. ಇನ್ನುಳಿದವ್ರು ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ.
Notice has to,
I number 1 to 3 of 2023 are disposed of accordingly. What is that injunction you have sought?
Lord, that injunction is with regard to, stay was granted by this honorable court on 15/12/2023. And FDP is pending. During that
Putting
time,
up
my lord, the
construction.
respondent number 3A to C have constructed, put up construction in the property, my lord.
Only on 7 and 8 of item
Yes,
number.
because that I claim as the appellant, I claim, my lord, that is my self-acquired property.
ಅಲ್ಲ ಇದೇನ್ ನೀವು ಕೇಳಿರೋದು ನೋಡಿ, ಐಟಮ್ ನಂಬರ್ 7 and 8 ಅಂತಾನು ಹಾಕಿದೀರಾ, A and B ಪ್ರಾಪರ್ಟೀಸ್ ಅಂತಾನು ಬರ್ದಿದ್ದೀರಾ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ.
Schedule A and B.
You have the copies of all
Those
this.
are item number 7 and.
I need to
ಅವ್ರ
secure the.
ಕಾಪೀಸ್ ಸಾರು ಮಾಡಿ.
Yes, ma'am.
Now that he has entered appearance, I'll serve a copy. A date may be fixed for that.
ಅಲ್ಲ, but what about the notice to the other
The
respondent?
respondent notice may be ordered, my lord. I will.
It has been ordered.
Big number,
If it is not-
34 response are there.
How?
Yes, ma'am.
All are
Issue
done.
notice to respondents 1 to 1, 2 and 4 to 34.
Yes, ma'am.
34, list down.
Lord, regarding this IA of 1 of 24, my lord, I have served a copy on him. Date may
But
be
it's not only against him, you have sought injunction against.
Only
others also.
against him, my lord. I have named the
Only
all.
our against our ಮೇಲೆ ಅಂತ ಮಾತ್ರ ಇಲ್ಲ. Restraining the respondents ಅಂತ ಹೇಳಿದೆ.
ಹೇಳಿದ್ದೇನೆ, so ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗುತ್ತೆ.
List down.
2310.
20.
Still number 30, Chandrasekhar H.
Records ಕಾಲ್ ಫಾರ್ ಮಾಡ್ಬಿಡ್ಬೋದಿತ್ತನಲ್ಲ ಮತ್ತೆ ಅವಾಗ ಹಿಯರಿಂಗ್ ಹಿಯರಿಂಗ್ ಬೇಕಾದ್ರೆ.
Yes, madam. It may be called for.
Admit call for TCS. You file the paper books also. Paper book shall be filed within 4 weeks. ಅದಾದ್ಮೇಲೆ issue notice to list down
2310.
2310.
Still number 30.
For the appellant, my lord, I
PN
pray
letter.
for week time, my lord. Have some inconvenience, my lord.
Declaration and possession.
Possession. Any date may kindly be fixed, my lord.
Whose appeal is this? Defendant's appeal.
Defendant's appeal.
What is the decree? ಅದಕ್ಕೆ ಒಂದು admit ಮಾಡಿ records call for ಮಾಡಬಹುದಲ್ಲ? Do
Please,
you have
Lordship.
any objection for that?
No, Lordship. It may be admitted.
What were the issues?
Lordship, what had happened was that I was in possession of two certain properties. The scheduled property has been,
The perfection of title by adverse possession.
please, your Lordship.
Okay, sir. ಏನೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರಲ್ಲ, what is that appeal? Grant leave. IA1 for ಇವೆಲ್ಲ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ? ಮೊದಲಿನವೆಲ್ಲ IS ಡಿಸ್ಪೋಸ್ ಆಗಿದೆಯಾ? Interim order granted earlier is extended till next year. What was the interim order granted?
Interim order was not to precipitate the,
Not to evict them. Possession is order. 14 is permitted to prosecute the appeal. ಅದೆಲ್ಲ allow ಆಗಿದೆ. Third, admit call for TCS. Appellant's counsel shall submit the paperbooks within 4 weeks.
please.
Interim order may kindly be extended.
Interim order grant, already it is there. Granted earlier is extended till next hearing date. List down. 4 weeks only.
1610.
Please.
Obliged.
Still number 31, case Mallikarjunaya. Hearing for the appellant.
Raised for 1 week time, my lordship. Senior sister husband passed away, he went there, man.
May I make a submission, no? This appeal becomes infructuous by the fact, my lord, that the execution has been FTP proceedings, well, they have challenged that, this appeal. FTP proceedings has culminated in a execution. Execution has been, my lord, taken possession also. Kindly see, my lord, the order sheet I am producing. FTP order has been put into execution and execution proceedings initiated, and then possession of the property is also taken. So therefore, my lord, nothing.
File a memo along with the documents. Now, they are saying that there is a bereavement in the council's family.
Please.
You can file it so that we can take it up in
Please,
the next hearing.
I'll do that. The lordship may fix a
Appellant's
date.
counsel. ಆಯ್ತು, date
Please.
ಅಲ್ಲಿ ಕೊಟ್ಬಿಡಿ. Appellant's counsel, adjournment is sought on the ground that there is a bereavement in the family of the appellant's counsel. Response counsel submit that the proceedings have become infructuous. I'm sorry, the appeal has become infructuous as the impugned judgment and decree is already executed. He can file the documents to that effect if that is the case, he shall produce the documents to that effect. List on date.
17/9. Still number 32, PV Kalpana.
For appellant, my lord. In this case, insurance company is served but unrepresented, my lord. Tata AG, my lord.
So, two vehicles are involved.
Ravi S. Samprati appears.
Ravi Samprati appears for
Tata AG.
served unrepresented.
Served unrepresented.
Shri Ravi Samprati, Learned Counsel, Learned Standing Counsel for respondent number 2 is requested to accept notice for respondent number 2. Appellant's counsel shall serve the copies on him. Admit ಮಾಡಿ records call for ಮಾಡಬಹುದಲ್ಲ?
Yes, madam.
ಬಂದಿದೆ. Admit post for final hearing on after 4 weeks. Post for final hearing. ಅವ್ರು ನಿಮ್ದ್ರಲ್ಲಿ adjournment ತಗೊಂಡೋಗಿದ್ದಾರೆ ಬೆಳಿಗ್ಗೆ. ಇವ್ರದಲ್ಲಿ adjournment ತಗೊಂಡಿದ್ದಾರೆ. ಅದೇ ತಾನೇ?
ನಾಳೆಗೆ.
Tomorrow, some
Tomorrow.
inconvenience, my lords.
Again, what is that, accident or something,
After 9th, if my lords, I'll inform my lawyer friend if I get his number. My lord, tomorrow, my lords, my colleague.
ಅವ್ರಿಗೆ ಪ್ರೆಸ್ ಮಾಡಿದ್ವಿ ನಾವು ಓದ್ಕೊಂಡ್ ಬಂದಿದೀವಿ ನೀವು ಹಗಲೆಲ್ಲ ಮತ್ತೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಳ್ತೀರಾ ಅಂತ ಹೇಳಿ.
My lords, tomorrow, some inconvenience, I'll request my colleague to my lords take time.
ಬಿಟ್ಟಿರ್ತಾರೆ ಏನೋ
ಇಲ್ಲಿ ನಾಳೆ ನಮ್ಮ colleague ಬರೋಕೆ time ತೊಗೊಂತಾರೆ ಸ್ವಾಮಿ.
ಗೊತ್ತಿಲ್ವಾ? ಇಲ್ಲೇ ಇದೆ ಫೈಲ್. ಎಷ್ಟದು ಸೀರಿಯಲ್ ನಂಬರ್?
39.
39, please, my lord. Anytime after 10th, I'll be grateful, my lords.
39 ಮೇಲೆ as requested list on
10th.
10th.
Please,
Now,
please.
Again, we have to refresh our memory.
Please, my lord, please, my lord, please. 10th, please, my lord. Oblige, oblige.
Cell number 33, Vijaya MN.
I appear for appellant, my lord. It's a case of injury, my lord. The appellant sustained the has 100% disability, my lord. TCR are required, my lord.
How much is taken by the tribunal?
25% is taken, my lord, but doctor has stated clearly, my
List of receipt of TCS.
date. It may be fixed, my lord, because he is
Records.
2410.
Yes.
Cell number 34, AK Bhatt, Rajendra Singh.
Yes, I appear for appellant in the first matter and
Second matter ಅಲ್ಲಿ
R1, I am
second
appearing
set.
for R1.
ಇದರಲ್ಲಿ ಸೇಮ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
ಹೌದು, ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್, one appeal by insurance company and another for enhancement.
ಯಾರಿಗೆ ನೋಟಿಸ್ R1? R1 is
And one submission in my appeal,
ಅದೇ ಹೆಗಡೆ ಮುಳ್ಕಂಡ್ ತಗೊಂಡಿದ್ವಿ.
Hegde Mulkand was directed to, yes, Sitaram Rao has to be directed to take notice. Online ಇದ್ದಂಗಿಲ್ಲ ಅವರು. I have got an extra copy for appeal. I will serve it on him.
Sitaram Rao DC has filed the connected appeal on behalf of the insurer.
3061 of 23.
Requested to accept notice for respondent number 1 in this case. His name shall be shown in the cause list accordingly. Henceforth, appellant's counsel shall serve the copies on him. ನಿಮ್ ಕನೆಕ್ಟೆಡ್ ಕೇಸಲ್ಲಿ ನೀವು ವಕಾಲತ್ ಹಾಕಿದಿರಲ್ವಾ?
ಹೌದು.
ಎರಡರಲ್ಲೂ ಅಡ್ಮಿಟ್ ಮಾಡಿ.
Second set he has to file
ಇದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಾ?
because they have challenged the negligence aspect.
Admit call for TCS. At least
Yes.
your matter will call for TCS. ಇದರಲ್ಲಿ 34.1 ನಲ್ಲಿ 10 days time is granted to file the second set ಅಷ್ಟೇ ಅಲ್ವಾ?
ಹೌದು.
Second set. ಇಲ್ಲ ನಿಮ್ದು ರೆಕಾರ್ಡ್ ಬರ್ಬೇಕಲ್ಲ, 2 weeks ಕೊಡೋಣ ಬಿಡಿ ಹಿಂದೆ. 2 weeks time is granted to file the second sets. List on 4 weeks ಆಗಿದೆ.
Short date because entire negligence is
ರೆಕಾರ್ಡ್ ಬರ್ಬೇಕು.
ಆಯ್ತು.
ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ರೆಕಾರ್ಡ್?
Date may be put.
ಬೆಂಗಳೂರು ಕೋರ್ಟ್.
Now release ಕೇಳಲಿಲ್ಲ amount because he has
24.
2410.
Cell number 35, Rahul S. Reddy. N. Devraj.
The suit is for declaration in injunction in respect of a site bearing number 410 measuring 30 by 40 feet, which was formed in survey number 171. Lordship kindly say, originally the land bearing survey number 174 belongs to one Narayanappa. He sold an extent of 2 acres on 2/3/1991 in favor of respondent number 1. On 6/7/2002, the first respondent executed a general power of attorney in favor of fourth respondent, and on the strength of the general power of attorney, he formed a layout and sold almost all sites to several persons. They are in possession of the property. In the meantime, your lordship can say her husband was addicted to bad habits. First respondent's husband, he created some GPA and he also sold the property in favor of some other persons, these defendants. Because of that reason, the suit is filed. Several persons have filed a suits against the same person. The lordship can see the issue, my lord. Issue which was framed in the suit. That
There was
second.
one more suit.
What?
Issues are on page number 20, right? But
Page
there-
number 20.
There was one more suit.
There one more suit, connected matter. Here, your lordship will lay two, there are so many suits. Even your lordship will issue number 2 and issue number 4. Lord, the other court, your lordship can see that findings is given in the,
Other appeal.
how, the same issues are framed in some other cases. Wherein your lordship can see findings as given as at page 10, internal page 10, that in OS number 2637, connected with 26917 of 2013, wherein the same issue was framed.
Correct, but these two judgments were separately passed.
That is separately, a different judge. That here your lordship will say findings given as a affirmative. In this case, my lord, the findings given as a negative.
This is in.
Conflicting of judgments.
This was in 30th June 2020.
Please, ma'am.
E-judgment.
The e-judgment 24.
This was
24.
on 21st March 2020.
Please. Even these judgments were produced before the trial court.
26,918. This was in 18th March 2024.
Oh.
Where is it, John? Yes.
Either findings your lordship kindly see these issues were not, the same issues are framed in all those sorts.
In this 2637 and 26,000.
How though? Adali, second issue,
One. Second issue is at page number.
page number 10, my lord.
Sure. Page number 10 or 16?
10 ಅಂತ ಇದೆ.
ಅಲ್ಲಿ ಯಾವ್ದಕ್ಕೆ ರೆಫರ್ ಈ ಕೊಟ್ರಲ್ಲ ಇದಕ್ಕೆ ರೆಫರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಹೌದು. 2637 of 16 and 26917 of 13.
16. 10 ಅಲ್ಲಿ ಇದನ್ನ ಮತ್ತೆ 16 ಮೇಲೆ ಯಾಕೆ ಮಾಡಿದ್ರೆ on the basis of
ಎರಡು issues ಆಗಿರ್ಬೇಕು.
6917 ಅಂತ ಅದರಲ್ಲಿದೆ.
ಅಲ್ಲ page 10 ತೆಗಿರಿ.
2637.
Please, ma'am. Issue number 2 and issue number 4. Does the plaintiff proves that two sale deeds dated 18/9/2003 executed by Sri Narayan Reddy to be a fraudulent document? Then issue number 4, my lord. Does the plaintiff proves that the judgment in decree dated 16/11/2007 in OS number 289 of 2004 is not binding on the plaintiff? Your lordship can see the page 20, my lord. The same issues. Even a single word is not changed. Second issue. Here also, in this case. Does
ಯಾವ್ದ್ರಲ್ಲಿ ಈ ಕೇಸಿಂದ?
ನಮ್ಮ present appeal.
Present
Present appeal ಅಲ್ಲಿ page number 20.
Hmm.
Does the plaintiff, second issue,
Yes. Same
does
thing.
the plaintiff proves that the sale deed dated so and so 18/9/2003 only? Even that the fourth issue is the one and the same. Then your lordship can see findings given in the 2637 of 16, my lord. Issue number 2 and issue number 4 at page 18, my lord. Affirmative.
2 and 4. It's affirmative. Hmm.
Here, my lord, in my case, my lord, the issues, findings as given as a negative.
ಅಲ್ಲಿ ಸತೀಶ್ ನಿಮ್ ಸೂಟು ಸತೀಶ್ ಅಲ್ಲಿ ನಂಜುಂಡಪ್ಪ ಅಂತ ಇದೆ.
Both are purchasers.
You were also party in that suit?
Wait, in that suit, I am not a party.
Jairam Reddy.
Jairam Reddy is the, all the defendants, same defendants, my lord, in all cases. Venkatama is the original owner.
Hmm. Her husband was Narayan Reddy.
Oh.
Really, reverse contrary view was taken here.
Oh.
Really negative ಅಂತ hold ಮಾಡಿದ್ದಾರೆ. Any appeal is pending against these judgments?
I think appeal is pending. Whether they have filed or not, I don't know. But somebody says it is pending. I think it can be checked with from the internet.
All right, now you are seeking stay of this judgment.
Please.
Your suit is dismissed, right?
Suit is dismissed.
But then what is there to be stayed? Suit is dismissed. ಏನ್ stay ಕೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವೀಗ?
ಯಾವ್ದು stay ಮಾಡಿ?
Stay ಅಂತ ಹಾಕಿದ್ದಾರೆ.
In this matter, 1088, we have not sought for any stay, madam.
ಅಲ್ಲ ಇಲ್ಲಿ ಇದ್ರಲ್ಲೂ ಕೂಡ 26
1088 ಅಲ್ಲಿ stay ಇಲ್ಲ.
18 was his suit. Jairam Reddy ಅನ್ನೋದು.
ಹೌದು.
Gabriel, what is the decree granted? Suit for permanent is here, injunction is hereby. Decree, defense are hereby restrained by a permanent injunction from interfering with plaintiff's peaceful possession. No, the court has held in that case that this Jairam Reddy is in possession of the property.
Oh,
You were also party in that.
I am a party. Debate number 3, Satish.
Jairam Reddy has purchased through GPA holder, huh?
Yes, Jairam Reddy claiming to be a GPA
You
holder
have
of
purchased through?
Narayanamma, the original owner,
Yep.
executed a power of attorney in favor of Srinivas Reddy, and Srinivas Reddy executed the sale deed.
In your favor.
Yes. Then your lordship can say that Jairam Reddy.
Sale deed ಯಾವ year ಇದ್ದು?
Now, this your lordship can see that 2/3/1991, that Narayanamma purchased the property. Then 6/7/2002,
1 second. 2/3/2000?
2/3/1991,
So 1991,
that Narayanamma has purchased the property, entire property, 2 acres.
D1.
How?
Hmm.
Then Narayanamma executed a power of attorney in favor of the 4th respondent
Fourth
on
respondent,
6/7/2002.
6/7/2000.
That is L. Srinivas Reddy. He formed a layout and sold the sites to several persons.
When did you purchase?
I purchased the property on 26/4/2013.
26/4/2013 from the power of attorney holder. From power of attorney holder.
Please, ma'am.
This fourth respondent is Jairam Reddy. When he
Fourth respondent, Srinivas Reddy.
ಅಲ್ಲ ಇಲ್ಲಿ the other suit in the other.
Other suit, your lordship can see Jairam Reddy.
Jairam Reddy was the plaintiff. When he purchased,
That he claims to be purchased on 18/9/2003, earlier to my sale date.
18/9/2003. From whom?
From the general power of attorney, that respond number 5,
Same Srinivas Reddy, na?
Narayan Reddy. Narayan Reddy, who is the husband of the first respondent.
No, husband was a power of attorney holder or he himself?
Husband is the power of attorney holder, claiming to be a power of
So
attorney.
she executes two power of attorneys.
No, that is the reason your lordship kindly see Narayanam has filed a suit against her husband, it is pending. Stating that she has not executed any power of attorney in favor of her
And
husband.
power of attorney, there is a presumption.
Correct. Because they claim that he created the said documents.
Power of attorney was executed in her favor of her husband, alleged power of attorney.
Alleged power of attorney was executed. Sale deed date is there.
And power of attorney. Husband is not a party at all in this case.
Husband is not a party. He passed away.
He passed away. Is it? ಅಲ್ಲ, ಯಾವ ಡೇಟ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ?
3 told.
ಡೇಟ್ ಎಷ್ಟದಂತ ಅದು ಯಾವ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಅರ್ಲಿಯರ್ ಇನ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂತ ನೋಡಕ್ಕೆ 26/4/2013 was the power of attorney executed by her in favor of Srinivas Reddy.
Please, ma'am. 6/7/2002, that power of attorney was executed.
6/7/2002.
Please.
Husband's favor ನಲ್ಲಿ ಇದ್ದ power of attorney ಯಾವುದು?
Husband's power of attorney is not mentioned.
Judgment ಅಲ್ಲಿ ಎಲ್ಲೂ ಬರ್ತಾ ಇಲ್ಲ. Under the registered deed dated.
Our judgment.
He is purchased on 18/9/2023 ಅಂತ ಅಷ್ಟೇ ಇದೆ.
In entire judgment, they are referring to executed people GP on their own.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಡೀಡ್ ಯಾರು ಎಕ್ಸಿಕ್ಯೂಟಿವ್?
Executed by
18/9/2003 ನಲ್ಲಿ that he purchased the property.
ಇದರಲ್ಲಿ ಇಬ್ಬರದ್ರಲ್ಲಿ ಯಾವ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಅರ್ಲಿಯರ್ ಪಾಯಿಂಟ್ ಆಫ್ ಟೈಮ್ ಅಂತ ಇದೆಯಲ್ಲ ಅಂತ. You are not aware, you are not able to get it?
That power of attorney date, your lordship, is not available.
Because it is difficult to grant stay for injunction.
Even in that-
Otherwise, there is likelihood of dispossessing them ಅಲ್ವಾ? Injunction stay ಮಾಡಿದ್ರೆ. Taking advantage of this.
The status quo should be.
ಸ್ಟೇಟಸ್ ಏನಂತ ಡಿಸೈಡ್ ಮಾಡಬೇಕಲ್ಲ, ಸ್ಟೇಟಸ್
Because of that reason, your lordship, their suit is decreed, granting injunction order. Even on the strength of that injunction order, our,
See, right, we have to decide what is the status. To decide, grant status order, we should know what is the status.
according to this,
Records call for ಮಾಡ್ತೀವಿ, ಆಮೇಲೆ ಕನ್ಸಿಡರ್
ಆಗ್ಬೋದು.
Issue notice. Shri. Sana Sharade, learned senior advocate, appearing for advocate and record for the appellants. Issue emergency notice. Admit call for TCRs, issue emergency notice for the respondents. ಒಬ್ರು ಯಾರು ಕೇವೇಟ್ ಹಾಕಿದ್ದಾರೆ, ಅವ್ರು ಬಂದ
KVT ಹಾಕಿದ್ದಾರೆ, KVT even copy has been served.
ಯಾರೋ ಬರ್ತಾನೆ, ಒಬ್ರಿಗೆ ಹಾಕಿದ್ದಾರೆ, ಅವ್ರು ರೆಸ್ಪಾಂಡ್ 5ಗೆ ಮಾತ್ರ.
He is only the contested party.
1088, ಅದೇ ಆ ಜಯರಾಮ್ ರೆಡ್ಡಿ ಅನ್ನೋರ
ಹೌದು. Even Narayanamma and other, these persons are not appeared.
ಜಗಳ ಹಚ್ಚಿ ಅವರು ಹೊರಗೆ ಹೋಗ್ಬಿಟ್ಟಿರ್ತಾರೆ, ಆಮೇಲೆ
How they have sold the property because of this.
ಪ್ರಾಪರ್ಟಿ ತಗೊಂಡು
ಹೌದು.
issue emergency notice for response 1 to 4. ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಕೊಡಿ ನೋಡೋಣ, ರೆಕಾರ್ಡ್ಸ್ ಬಂದ್ಮೇಲೆ ನೋಡಿಬೇಕಂತ.
Both the cases.
Both.
Same.
29.
The IA 1 of 2024 shall be considered on receipt of the TCRs.
I think your lordship kindly, if appeal is there, I will give these numbers, both the appeals should be clubbed together because the different conflict of judgments are there.
You can check that from the High Court website, check.
Please.
So number 36, KV Shyam Prasada.
First respondent in this case, KVT respondent. They have served only appeal memo. The IA per stay, they have not served.
How many respondents are there?
Only one respondent.
She is the plaintiff.
Yes, madam. Good for partition. The road enters.
Appellants are?
See, my lord, it's appellants are father and 2 children.
Of, no, how they are related
The
to the
first appellant is the father and appellant number 2 and 3 are children. And first respondent is a sister.
father and brothers.
Father, brother, and one of the sister are the appellants. And another sister is the
Now, which is this fourth defendant?
fourth tenant in occupation of the one of the premises.
Tenant, only tenant, ಬೇರೆ ಏನೋ
Yes.
sale ಅಂತದ್ದೇನು?
No independent right, he remained as party before the trial.
ಇದ್ರಲ್ಲೇನೋ self-acquired property. Issues are at page number? ಹಿಂದೇನೋ
Issue page number 13, 27, into page 27, judgment page number 13, my lord.
No, item number 5, 6 and 8 are the self-acquired property.
My self-acquired property, that is second.
Defense number 2, that ಒಂದೇ ಡಿಫೆನ್ಸ್ ಇರೋದಿಲ್ಲ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
Further to that, no properties are available for partition.
that is my defense.
Defense 1 to 3 are members. Your defense was, you are concerned with 5, 6 and 8.
No,
Item
full,
number 5.
I am concerned full, my lord. Not the, specifically that one also, reason is like this, my lord. See, my lord, she received the property by cash and by way of gift from father in lieu of the oral partition entered between the parties, my lord.
That's where issue ilvalla. There was already a partition.
That is why no property available for partition is the issue.
Issue ಅಲ್ಲ. There was, according to you, there was already a oral partition.
Oral partition and it is.
Issue, there is no such issue raised. Copies ಅವ್ರಿಗೆ ಕೊಡಿ, ಉಳಿದವ್ರು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ ಉಳಿದವ್ರು ಯಾರಿಲ್ಲ.
Appeal is preferred by all the defendants.
All the defendants before the trial court. Either 1, 2, 3, not tenant.
ಇಲ್ಲ ವಯಸ್ಸಾದ್ಮೇಲೆ ಯಾಕೆ ಏನು you represent daughter.
May I make one submission, my lord? What happened in this case? We have given the daughter, that's a respondent over herein, one house during the year 2006, 2000 itself, and made her to stand her alone nearly 1,20,000 during that time itself is a rent. And apart from that, she has constructed a fallacious house worth nearly 6 crores. Apart from this, her husband, 1 minute, her husband is none other than his the sister's son. They resided together.
ಜಾಸ್ತಿ ಇರೋದು ಜಗಳ. We are able to solve the disputes between the strangers. or some commercial disputes. He
ಅಲ್ಲ
relates
ಏನು
matrimonial.
6 ಪ್ರಾಪರ್ಟಿ ಅಗ್ರಿಕಲ್ಚರ್ ಪ್ರಾಪರ್ಟಿ
How is her relationship with the father? Papa, they become pawns in the
This is
hands of the
weeping, my
children
lord. There's
for
a
fighting
situation
against
like
each
that.
other.
Minutes that I will find out minutes.
ಏನಿಲ್ಲ ಸೆಟ್ಲ್ ಮಾಡ್ಸಕ್ಕಾದ್ರೆ ಮಾಡ್ಸಿದನೆ any
I will try my next.
decision was held
See,
with-
my lord, during the trial also I tried because ಅವಳ ಹಸ್ಬೆಂಡಿಗೆ 6 ಪ್ರಾಪರ್ಟಿ ಅಗ್ರಿಕಲ್ಚರ್ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟೆವು ಅವಳ ಹೆಸರಿಗೆ. ಅವೇನ್ ಮಾಡಿದೆ ಇದು ಅಕ್ಕನ ಮಗ ಏನ್ ಮಾಡಿದೆ ಎಲ್ಲ ಮಾವನ ಹತ್ರದಿಂದ ಕ್ಯಾಶ್ ಅಲ್ಲಿ ತಕೊಂಡು ಅವನ ಹೆಸರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಮಾಡಿದೆ. ನೋ ಡೌಟ್ ಇಟ್ಸ್ ನಾವು ಕ್ಲೈಮಿಂಗ್ ಸೆಲ್ಫ್ ಅಕೌಂಟ್
Tying up of the final decree ಅಷ್ಟೇ ಸ್ಟೇ ಮಾಡೋದು ನಾವು.
ಹೌದು ಫೈನಲ್ ಡಿಗ್ರಿ ಇದೇ ನಂಬರ್ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಇಮಿಡಿಯೇಟ್.
They are receiving 5 lakhs rent, my lord, from the fourth respondent. Let them deposit 1,25,000 before.
No, my lord, sir.
The decree is only for partition, hereby and 1/4 share in the social property.
Yes, ma'am.
Relief of mean profits is kept upon separate inquiry and
I availed the loan and the constructed house, the building, my lord, loan continue.
in respect of
All the property.
claim in respect of item number 3 is dismissed.
See, my lord, they have taken, that is also the ancestral property. Subsequently, they failed to prove that there are existing
Call for
property.
TCS. Interim stay only for drawing up of the final decree till further orders. Appellate's counsel shall find the paper books within 8 weeks.
Till next date, my lord, because they have not served copy, my lords. I will file objection to the
Wait, wait.
application.
Judgment stay gives.
ಇದ್ರು ನಾವು ಅಷ್ಟೇ ಅಲ್ರಿ ಫೈನಲ್ ಡಿಗ್ರಿ ಮಾಡೋದು.
ಅಲ್ಲಿ ಸಿಕ್ಕಾಪಟ್ಟೆ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಫೈನಲ್ ಡಿಗ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
ಇಲ್ಲ ಒಬ್ಬರೇ
Notice to respondent number 4, my lord, remained expert.
ನೋಟಿಸ್ ಅಂತ ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ ಅವ್ರ ಮೊದಲು ಒಬ್ಬರೇ ಇದಾರೆ ಅಂದ್ರೆ ಈ ಕಡೆ
Respondent number 4, tenant remained expert.
ಕೇಳ್ತಾ ಇದ್ದೀರಾ? ನೋಟಿಸ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
I'll take, it may be taken as filed, man.
ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
ಆಗ್ಲಿ.
ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ರವರಲ್ಲಿ.
ಹೌದು, expert.
The heard advocate call for TCRs. Issue notice to respond number 4. Appellate's counsel shall file the paperwork within 8 weeks. Interim stay only for drawing up of the final decree till further orders. I am in of 84 disposed of. This one 8 weeks are needed.
Respondent number 2 ಅಂತ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
Respondent number 2, my lord.
Two ಅಂತಾನೆ ಹೇಳಿದ್ವಿ.
2, defendant number 4, respondent number 2.
ನೋಟಿಸ್ ಮಾಡುವಾಗ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಅಂತ ಮಾಡ್ತಾ ಇದೀವಿ. ಡಿಪೆಂಡೆಂಟ್ ರ್ಯಾಂಕ್ ಯಾಕೆ ಹೇಳ್ಬೇಕು ನಾವಿಲ್ಲಿ?
Sorry, my lord.
2810. Seal number 37, Gururaj R.
Please, your lordship. Please, your lordship.
Very sorry to see these kinds of fighting between the children and the parents. ತುಂಬಾ ಬೇಸರ ಅನ್ಸುತ್ತೆ ನೋಡೋ. We were discussing that ಕರ್ಮ ರಿಪೀಟ್ಸ್ ಅಂತ ಅಂತೀರಿ. ಯಾವತ್ತೋ ಮುಂದೆ ಇವ್ರು ಪ್ರಾಪರ್ಟಿ ಮಾಡಿದಾಗ ಅವ್ರ ಮಕ್ಕಳಿಗೆ ಬರೋ ಚಾನ್ಸಸ್ ಇರುತ್ತೆ.
Plaintiff's appeal, my lord. Suit for declaration and possession has been dismissed. Though, my lord, we have produced the title documents and other revenue documents also.
Cases.
On the, my lord, case of the plaintiff number 1 is the, my lord, father. Plaintiff number 2 is the son. Land in question, my lord, was granted to him, my lord, in the year 1960, my lord, in 1977, my lord.
He claims to have purchased the property.
My lord, the defendant, my lord,
There is no interim.
there is no interim order.
Heard admit call for TCRs. Appellant's counsel shall submit the paper books within ಎಷ್ಟು ದಿವಸ ಎಲ್ಲ ಆಗ್ತೀರಾ paper books?
In the 12 weeks,
Documents ಜಾಸ್ತಿ ಇದೆ. 8 weeks. Within
12 weeks.
12 weeks.
ಅಂದ್ರೆ ಎಲ್ಲ ಟೈಪ್ ಆಗ್ಬೇಕು.
ಏನ್ ನಿಮ್ಮ ಹತ್ರ ರೆಕಾರ್ಡ್ ಇರುತ್ತೆ ಅದನ್ನ ಜೆರಾಕ್ಸ್ ಮಾಡಿ ಹಾಕಿ.
Please,
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ 8 weeks ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಂತರ 8 weeks.
please.
List after 8 weeks. ಅದೇ ಡೇಟ್ ನೋಟಿಸ್ ಆಗಿದೆ ಅಲ್ಲ 8 weeks ಆಗಿದೆ.
30th October.
30th October. Yes.
Please. Oblige.
Seal number 38, Jaisima KP.
This case occurred for petition of my appellant, my lordship. The appellant is aggrieved by the order, judgment. judgment and decree on 3/7/2024 passed by the principal judge, family court at Bangalore.
Dismissed.
The dismissed, my lordship. This appellant is petitioner. He filed a petition for
Except.
resolution. My lordship.
Except two documents are not produced any document in proof of cruelty or not examined anybody.
So desertion is there, my lordship. This is the
One
respondent.
A and one B, ಎರಡು petition ಇದೆಯಲ್ಲ.
Yes, my lordship.
Petition is on both the grounds.
Both the grounds, but this respondent is left the matrimonial house in 10 years back.
Issue notice
So 10
for
years.
Call for TCRs. Notice and call for records.
Obligement. Date.
Date
2210.
22.
Obligement.
List number 2 for further hearings, Cell number 41. Cell number 41,
41.
Anuparna.
It is not failing well.
Madam?
After 80.
Pardon?
Certificate is not failing well, Ramalingam, and the plaintiff.
ಆಯ್ತು ಬಿಡು.
ಇಲ್ಲ, ಇದಲ್ಲ madam.
ಇದ್ಯಾವ್ದು?
List number 2, cell number 41.
ನೀವಲ್ಲಿ.
List number 2, cell number 41.
Parted matter that is. ಅನುಪರ್ಣ. ಎಲ್ಲಿದ್ದಾರೆ? Where is your counterpart? ನಿಮ್ಗೆ ಕೊಟ್ರ ಏನೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪೀಸ್ ಕೊಡ್ತೀನಿ.
On the limitation points is.
Whether she has given it to you. ಬೆಳಿಗ್ಗೆಯಿಂದ ಬಂದೇ ಇಲ್ವಾ ಇಲ್ಲಿ?
Bandit, I'll just call her.
ಬೇರೆ ಮ್ಯಾಟ್ರ್ ತಗೊಂಡ್ರೆ ಮತ್ತೆ you call her.
Yes,
We'll see.
yes.
ಬೇರೆ ನೋಡಿ ಅವ್ರು ಯಾರೋ ಅವ್ರು ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇರಲ್ಲ, ಅದನ್ನ ಅಡ್ಜಸ್ಟ್ ಮಾಡೋ ಆಗುತ್ತೆ ಅದು. ಯಾರೋ ಪಾರ್ಟಿ ಅವ್ರು ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರು. ಸೀರಿಯಲ್ ನಂಬರ್
ಅದೇ number 41, list number 1.
ಸೀರಿಯಲ್ ನಂಬರ್
41, list number 1. Ramalingam PH. ಅದನ್ನ submission ಮಾಡ್ತಾರೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಎಲ್ಲ ಯಾರೋ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಅವ್ರು ಕೇಳಿದ್ರಲ್ಲ, ಅದು ವಸಂತ ನಾಯಕ್. 40 ಜನ ಆಗಿತ್ತಾ? 40 ಇದಾರ, ಇವ್ರು ಇದಾರ ವಸಂತ. ನೀವ್ ಯಾವ ಕೇಸಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದು? ಯಾವ ಕೇಸ್? 41. ಓಹೋ, ಇದು ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರೋ ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ರು ಅದ್ರಲ್ಲಿ ಬೆಳಿಗ್ಗೆ
ಬೆಳಗ್ಗೆ ಯಾರು ಕೇಳಿದ್ರು?
ಯಾರು ಕೇಳಿಲ್ಲ. ಎಸ್, ದೇ ಆರ್ ರೆಡಿ ಆರ್ ನಾಟ್ ರೆಡಿ? ಇವರ ಅಡ್ವೊಕೇಟ್
Sir is engaged in other matter, ma'am.
ಆಯ್ತು. 48 ಜನ ಆಗಿತ್ತಾ? ಇಲ್ಲ
40 ಇಲ್ಲ ಇದೆ.
ಕರ್ಸಿ.
For final hearing, cell number 40, Vasant V. Naik, MPRD.
Yes. This IPF for the appellant.
41 ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಕಂದ್ರೆ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ತಗೊಳಕ್. ಆಯ್ತು, ಅವ್ರು ಬರ್ರಿ, ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ನೀವು. ಎಸ್.
Cell number 40.
ಕೇಸಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇದ್ರಲ್ಲಿ ಬರೀ ಹೇಳಿಬೇಕು. 230 ಅಂತ ಹೇಳಿದ್ರ? ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇರೋದು? Yes.
Yes. Well, this appeal is filed against an order, my lord, passed on IA, my lord, IA number 2, the suit, my lord. IPF for the appellant.
Production of documents.
I have filed, no, the suit is pending, suit, my lord, no evidence was led, even no issues were framed. IA was filed for dismissal of the suit on the ground that it is bad by res judicata. Therefore, my lord, I have filed, my lord, an IA number 2 in this honorable court for production of additional documents, my lord, to show, my lord, that.
First you argue on
Yes,
the
my lord, yes.
can consider.
Yes, my lord. Your lordship may kindly, my lord, take the order, my lord. Order says, my lord, orders on IA number 1 and 2. And, my lord, para 4, my lord, is the application, my lord, filed for dismissal of the suit on the ground of res judicata, para 4 of the judgment, my lord.
Paragraph number
Para 4. Para 4 of the judgment, my lord.
Number internal ಇದೆ. Page number, internal page number ಹೇಳಿ.
Yes.
Internal. Page 23.
Yes. The paperwork, it is 40, my lord.
23.
Control page 11.
Yes. 40.
ಕೊಟ್ಟಿದ್ದಾನ? ನೀ ಕೊಟ್ರಾ? ಮೊದ್ಲ ಕೊಟ್ಟಿದ್ದೆ. Yes.
Page number 40. Starts at page number 40. No?
Yes. ಆಯ್ತು ಹೋಗು.
Para 4, my lord, is on page 45, my lord.
Yes.
Page number 45. I'll read, my lord. The defendants have filed IA number 2, an application under section 11 read with section 151 CPC along with affidavit of third defendant praying to dismiss the suit as the subject matter of the suit is directly and substantially was in issue in OS number 7258 of 1996, and the same was decided finally between the parties, and the suit is hit by principles of res judicata and for the reasons stated in the enclosed affidavit. Now, Lordship McKinley, I'll just point out one fact here, Lord. OS number 7258 of 1996 was in respect of only a scheduled property. I have brought in two other properties which are Schedule B and Schedule C. I'll read from the judgment. In the enclosed affidavit, third defendant stated that the amendments made. Now, the court below has proceeded directly to consider the affidavit of the third defendant without going into the plaint. The judgments are to the effect that the written statement and contentions of the defendant cannot be taken into account at the stage of hearing of IA on res judicata, because it involves not looking into documents.
Now, your suit was for what relief?
The suit was filed for a declaration, Lord, that the judgment and decree.
Plaint is that page?
Yes, ma'am. Plaint, you Lord, can you see the plaint? Plaint is page number 9, Lord. No, it is plaint is page number 1.
That is a judgment.
Yes, Lord, yes, Lord, the relief claim, Lord, is for a declaration that the judgment and decree dated 9/11/2005 passed in OS number 7258 before the Honorable Judicial Court being a partial decree as being null and void. And for fresh partition by means and bounds of her lawful share in the plain scheduled properties. Now, my lord, in the, your lordship may kindly.
Property in the earlier suit?
Schedule A, my lord.
Schedule A property.
Schedule A property. All that piece and parcel of house property bearing number so and so in Jagjivan Ram Nagar, Bangalore. Now, Schedule B and Schedule C.
She was also a party in that suit.
I was a party in that suit. That's why I have claimed a relief, not that for a declaration that the judgment and decree dated so and so in OS number 7258, being a partial decree as being null and void. Now, there are judgments of the Honorable Supreme Court which say a suit for partial partition is not maintainable, which is also confirmed by this Honorable Court in several decisions.
Judgment was passed in 2005 and you filed a second suit in 2015.
Yes. No, the reason is this, the defendant, this same plaintiff, who was defendant in that suit, had taken up a contention that there was a will in her favor in respect of a scheduled property. And the appeal was also filed on the basis that the will was had given her a right. Now that appeal was dismissed. After dismissal of the appeal in this Honorable Court.
This is the plaint of that earlier suit.
No, yes, now your plaint in the.
In this paper book, you have filed that earlier plaint also?
No, that is not filed, Lord.
Now,
that is the reason, Lord. The Honorable Supreme Court has held, Lord, for res judicata when other.
You tell us the basic facts.
Yes, Lord. The plaint.
They have filed with index
All the documents, even the previous court judgment, everything I have
You
filed.
have filed it.
Yes, he has filed. He has not given me a copy. You have filed, okay, but give me a copy.
Which one?
No, you have not
On
given a
date
copy of
on serving
the-
you,
the
you have
orders-
filed the documents.
Along with your counter you have filed.
Yes.
Counter out it, you have filed. You served copy also on the other side. You were one on
Yes,
Kutila.
7258 of 2019.
Yes. Now, my lord, your lordship may kindly see this, my lord. If none of these documents can be taken into account, my lord, in an application under section 11, which is filed because the Honorable Supreme Court has held, when the court is required to go into the documents of the other suit, then, my lord, it cannot be dismissed at initial stage of the suit. Now, here the suit is dismissed at the initial stage, immediately
They're framed in this suit or not?
no issues are framed in this suit and no evidence is permitted so far. Therefore, Mullah, what I am seeking is this, Mullah, to prove that my case, Mullah, this matter is required to be sent back to the trial court again to frame issues and then lead evidence. Only after leading evidence, the court can decide whether it is barred by res judicata or not. Res judicata cannot be decided without looking into the other documents produced by the defendants, not merely on an application when the issues are not framed.
Yes, that's all.
Yes. Now, your lordship may kindly see schedule B and C, C schedule, there are two other properties are there. Now, in respect of B and C schedule properties, not because I was not permitted to file my lead evidence in the court below, I have filed by way of additional documents, not the two properties. Your lordship may kindly see, Lord. I gave number 2, Lord.
IA2?
IA2 for production of additional documents. Yes, filed in this honorable court. Not there is evidence to show the father of the appellant and the respondents also own other properties. And your lordship may kindly see, Lord, the first document, Lord. Certified copy. I have filed a certified copy of the document number 1 along with the English translation. Your lordship may kindly see, Lord, the document number 1 at page 6. No, it is not a certified copy of the sale deed in favor of the father of the appellant and respondents executed in the office of the sub-registrar Puducherry, Pondicherry. And this is a sale deed dated I will point out, no, the sale deed is the certified copies of 2017. Then the document is there, then the translation. On 9 August 1980, a property is purchased. Page number 12 may kindly be seen.
Yes.
Page number 12. On 9th August, 1980, I, Mr. So-and-so, son of Rajay Mudlia, for myself as well as in the capacity of power of attorney of so-and-so.
Yes. Yes.
Next page, to and in favor of Mr. R. Arokya Swami, son of late Rayappa, residing at number 40, Bungalow, Swadeshi, Cotton Mill, Puducherry. He is the father of the appellant and the respondents. And this is a sale deed which is of B schedule property, which has not been brought into a partition at all. Therefore, whereas by virtue of the will executed by so-and-so, whereas the seller has received this day, the third para on page 13, whereas the seller has received this day the above said sale consideration from the purchaser. From this day onward, the purchaser shall enjoy the said property in full and ownership and with absolute rights of alienation. The sale declares that he and other legal heirs have no title or interest whatsoever over the property.
What is this 50 kuri means? What is that measurement?
No, yes, it comes to about 57 cents, which is just about more than half an acre. And your lordship may kindly see the next document on page 15. Sides are carved out, Lord. Sides are carved out.
CLD date sale certificates of apply ಮಾಡ್ತಕೊಂಡಿದ್ದಲ್ಲ date.
Yes, certified copy was applied, my lord, in 13/1/2017.
15 ಅಲ್ಲಿ.
So, my lord, I have got a certified copy of the sale deed in favor of father of the appellant. And to show that this is also another property which was purchased and which is not brought into partition, my lord. Therefore, my lord, prima facie to show that, my
That
lord.
included this property in the suit or not?
No, my lord, that
In
is,
the present
yes, I have included in the present suit, my lord. B schedule property is, my lord, this sale deed is in respect of B schedule property in the plaint. B schedule property, all that piece and parcel of the house and agriculture property situated in survey number 48 with subdivision numbers 1, 2B.
What is the cause of action you have stated here?
Which one, my lord?
When did you come to know about this existence of these
No,
properties?
these properties were purchased by the, yes, I
Your
know.
knowledge, when did you come to know about these properties?
No,
Where have it stated in your plaint?
yes, plaint, my lord. Your lordship may kindly see the
Has
plaint itself.
recently traced, Ashtane.
Yes.
Recently, para 11 has recently stayed. I was not aware, she was not aware of the details
Yes.
of the properties. Yeah, when exactly she came to know, that is not revealed. During 1988, that's what you say in the plaint. He has purchased
No,
these
that
properties.
was purchased, my lord.
He has said in para 11 of the plaint
Yes.
that your father purchased these properties in 1988.
Yes. No, it is something that the plaintiff has been deciding with the family, but that is para 11.
But now sale deed you have produced here shows that it was purchased in 1980.
Yes. But the, and late father Arupya Swami during 1990 and 2001, when the plaintiff father and mother expired respectively during 1996, when the partition filed by the, when the partition suit filed by the defendant was decreed during the year 2005 and the appeal of the plaintiff being dismissed during 2012, when the final decree proceedings were initiated and is pending adjudication. Now, my lord, there is one judgment of this honorable court, my lord, which says, my lord, limitation is not an issue when it comes to your share, my lord. Your lord, I will point out that judgment of this honorable court, my lord, where, my lord, limitation is not an issue when shares are denied to any of the parties. And may I just point out the document in respect of C schedule property, my lord. C schedule property, my lord, I have produced as document number 3, page 20, my lord, of the IA, my lord.
Yes.
Now, your lordship may kindly take note of the sale deed, my lord. I have got a certificate.
Yes, page number.
Yes, page number 20, my lord. Page number 20, my lord, is the sale deed, my lord, executed in favor of the respondent number, the husband of respondent number 4. Respondent number 4, Grace Catherine daughter. But this sale deed was executed in respect of, in favor of the husband of respondent number 4, and the sale consideration was paid by Mr. Arokya Swami. That is the case of the plaintiff.
Arokya Swami was a party to the sale deed?
No, the Arokya Swami paid the consideration for.
That forthcoming, from whom they have received
Yes, yes.
consideration.
Your lord, you kindly see the next page, my lord.
Where do we find that Arokya Swami had paid the consideration?
No, Arokya Swami, my lord, the name is not found here. What is found here is, my lord, the name of the husband of respondent number 4, defendant number 4.
Correct. He was the member of the society.
Yes, he was a member. No, he was a member. He became a member, and the sale consideration was paid by Aroke Swami for purchase of this.
Where do we find that in the
Yes,
document?
yes, my lord. No, that portion, my lord, you are lucky.
Any document shows that so and so has paid the money, purchase money.
Yes, yes.
Consideration.
No, that, my lord, I have stated in the IA, my lord. Your lordship may kindly see in the IA, I have mentioned that, my lord, the sale consideration was paid by Mr.
Listen, when
Aroke.
you say that some person has funded the purchase,
Yes.
it should be there in the record.
No, my lord, there is evidence to show, and which will be produced before the court, that, my lord, this property was purchased by Mr. Respondent number 4, my lord, on the consideration being paid by Mr. Aroke Swami. That is part of the evidence, that, and that evidence is yet to begin in the court below, my lord. I have stated here in the IA, my lord. Your lordship, para 3 of the IA, my lord, I state that in respect of fee schedule property, I had documentary evidence, which is the certificate copy of the sale deed executed on 4/6/1986 of the house, number 4 in plot number 4 measuring shows. I see that fee schedule property was purchased by my father, late Aroke Swami, in the name of my sister, Grace Catherine's husband. IA number, para number 3, my lord, of the IA, my lord.
All right. Earlier, against the earlier suit, appeal was preferred before this court.
Yes.
And against the judgment of this court, any appeal was preferred?
No,
before
no,
Supreme
no,
Court?
it was not preferred.
Not filed?
No,
Against-
no SLP was filed.
No SLP was
No
filed.
SLP.
This was disposed of in 2013.
Yes.
Thereafter, you filed this,
This
2 years thereafter.
With great respect,
2000.
I produced documents.
We are seeing that is.
Rescheduled property is a concocted document.
No, that is their case.
We produced document. Rescheduled property belongs to one Aroke Swami, Maurice Anthony, was given site in the Pondicherry.
That is their case. They have been wrongly representing before.
I will argue, you argue, sir.
Yes.
Your contention is the plain suit should not have been dismissed, exercising the powers under section 11 of the.
Yes, yes.
law ಏನಿದೆ ಅದನ್ನ ಹೇಳಿ.
Yes, that is what I'll point out from the judgment, my lord. And your lord.
Judgment?
Huh?
Which judgment you are referring?
Yes, my lord. I will give the judgment, my lord. Well, you know,
Yes.
This is my first judgment, is the latest judgment of the Supreme Court, 2021 9 ACC, page 99. I'll just read the head note and then go there to the specific. Applicability of bar of res judicata held cannot be determined at stage of rejection of plaint. The same can be determined upon trial of the suit. In this case also, my lord, without going to the trial, no issues are framed. The court rejects the plaint on the ground of res judicata. Then, my lord, second head note. Plaint in subsequent suit cannot be rejected on ground that it is barred by principles of res judicata, as same will require production of pleadings, issues framed, and the judgment in previous suit to compare it with the present suit, and that cannot be done by deciding an application under Order 7 to 11D, as only the abatement in the plaint itself can be considered at this stage, seen so and so. Then the third note, Order 7 to 11 and Section 11. This applies to this present application. Rejection of plaint, applicability of bar of res judicata held cannot be determined at stage of rejection of plaint. The same can only be determined upon trial of the suit, as only the abatement in the plaint itself can be considered at this stage. Then you will have the observations of the Supreme Court. Those are to be found in para 25. On perusal of the above authorities, the guiding principles for deciding an application and Order 7 Rule 11D can be summarized as follows.
to reject a plaint on the ground that the suit is barred by any law, only the abatements in the plaint will have to be referred to. Now, what he has done in the lower court and also in this honorable court is he has filed all the pleadings of the other suit in this case, and he has asked the court to look into his documents, which cannot be done at all. To reject a plaint on the ground that a suit is barred by any law, only the abatements in the plaint will have to be referred to. The defense made by the defendant in the suit must not be considered while deciding the merits of the application. Now, even in this honorable court, he has filed a list of documents and he's saying, look into this and dismiss it. That is not permissible under law, because issues have to be framed, parties have to be permitted to lead evidence, and then thereafter, the issue can be decided whether it is barred by limitation, adjudicate or not. Para 25.4. Since an adjudication of the plea of adjudicator requires consideration of the pleadings, issues, and decision in the previous suit, such a plea will be beyond the scope of Order 7 Rule 11D, where only the statements in the plaint will have to be perused. That is the latest decision of the Honorable Supreme Court, 2021 Supreme Court, page 99. Now, the next decision is also another decision of the Honorable Supreme Court of 2023, Order 7 to 11, rejection of plaint. Hence, in our view, the issue of res judicata could not have been decided on an application under Rule 1 of order by keeping open the issue of res judicata appeal is disposed of. Now, the court directs the matter to be considered. Next page, After hearing the learned counsel appearing for the parties, we find the plea of res judicata cannot have been gone into on an application by the appellant. Then para 6, hence in our view, the issue of res judicata could not have been decided on an application under Rule 11 of Order 7 of CPC. The reason is that the adjudication on the issue involves consideration of pleadings in the earlier suit, the judgment of the trial court, and the judgment of the appellate court. Therefore, we make it clear that neither the learned single division bench at this stage could have decided the plea of res judicata raised by the appellant on merits. Therefore, we agree that the final conclusion of division bench of the High Court that the suit needs to be decided on merits with a modification that the issue of res will remain open and the learned single will frame an issue on res judicata along with other issues. Now, therefore, for deciding whether a suit is barred by res judicata or not, issues have to be framed and parties must be permitted to lead evidence. And only after looking into the documents filed by both the parties, res judicata can be considered. This is the decision of this Honorable Court, which is also in the next decision of the Supreme Court, 2008, 12 SEC.
Your prime contention is that it cannot be dismissed at the preliminary stage.
At the preliminary. Yes, and I will complete my argument. Your Lordship may kindly take the next decision, that is of 1994, 4 SEC, page 294, the fourth judgment, fourth judgment, 1994, 4 SEC, 1994, 4 SEC, here Hindu law, partition, suit for partial partition.
Considering that, if at all this is to be considered on the merits of the case,
Yes.
why the court should consider at this stage?
Yes.
You are saying the suit for partial partition is not maintainable?
Yes, yes. Yeah, and
Now, according to you, the trial court would not have considered this orders of this is section 11 issue
yes,
as a preliminary issue.
Preliminary, yes,
So
yes.
the other judgments are not required, only
Yes.
that.
No, yes, that is also, and your Lordship may kindly take the last decision of the which I filed RFA number 946 of 2012, just to point out one fact, RFA number 946 of 2018, which was disposed of only last month by the other bench, 26 July 2024, that is RFA 946,
Yes, yes.
last decision, last judgment which I filed. Yes, there, my lord, para 25 may kindly be seen. Para 25. Similarly, in the case of Tara Kishore Das, page 20, para 25, page 20 of that judgment, my lord, page 20 of that judgment, para 25, mark portion. On the face of it, the decision of the learned subordinate is quite illegal. He appears to have ignored the position that a right to obtain partition is a right inherent in the joint ownership of property. It is a natural legal incident of ownership which could not have been denied to a co-owner of the property so long as his right subsists. The mere fact that on an earlier occasion he could not have obtained.
Correct. You are not getting our point. Once you
I
say
understand.
that
I understood.
have been decided in
Yes,
this
yes.
way, then why should we hear you whether you
Yeah.
have a right to seek file another suit,
Yes, yes.
etc.
Yeah, and I just wanted to point out one aspect of this. It says that in this case, it has been held that limitation is not an issue. That is what in the subsequent para it has been held. Para 6, para 6 ಅಲ್ಲಿ para 6. Yes.
Main matter decide
Yes, I may just point out para 6. In other words, it is open to the owner to ask for separate enjoyment of his share of the property at any time he likes, and the right to.
Your argument is contradicting your own statement.
No, it's not contradicting. No, it
You say at
limited, since your lordship.
At the first instance, you say that this section 11 issue cannot be
Yes,
considered.
that is my main issue, yes.
If that is considered, then how can you argue that you had a right to file a suit or your?
No, that is only, that is only to point out that I have a right to file a suit. Yes, yes.
That's the scope of the litigation.
No, that is only to point out that all these have to be considered by the court below by framing issues.
Say for this judgment,
I continue with great respect. It is already concluded in the previous judgment, 1940 issue.
no, he is relying on the Supreme Court judgment to say that
With great
given
respect,
section 11
B and C
issue could not have been, cannot be considered as a preliminary issue because that also requires production of pleadings, evidence, etc. Therefore, it cannot be decided on a mere application. That's what he is saying, and he is citing these judgments for that. What do you say for that?
great respect. What they say, B and scheduled property, they never belong to Arvind Swami father. The B scheduled property, a produced document, is a concocted document. That property belong to one Arvind Swami.
Your concocted documents are not whether that
I
requires.
am producing document.
Evidence that
I am producing document.
I will lie, just wait.
Yeah.
Whether that requires evidence, evidence means oral evidence also required.
They have not,
That's what Supreme Court judgment says. What have you got to say to the Supreme Court judgment?
with great respect.
But
Regarding this property, OSU, no documents of title was produced by the plaintiff in that suit. Because of that, I have produced documents of title regarding B schedule.
defendant in that suit, earlier suit.
Yeah. In the earlier suit,
No, they were the plaintiff. I was the defendant.
ಏನೇ ಹೇಳ್ತಾ ಇದೀವ್ರಿ?
it is, with great respect, in the earlier suit, in the OS party issue, OS, which I have filed. There were,
Defendant. She said
Will
her
con-
file there.
continue at 2:30. Now, ಹೇಳ್ತೀನಿ.
At 2:30 we have some other matters. ಇನ್ನೊಂದು ಸಾಕು.
In the earlier suit, great respect, they contended the suit schedule provided at Bangalore belonged, given to the appellant herein. All the property situated at Pondicherry were given to all the children of the Arvind Swami. In fact, in the partition suit, there was evidence, there are issues were framed. ವಿವಾದಾಂಶ 7, 8, 9, 10, 11 ಮತ್ತು 12 ಈ ಜಾಗವನ್ನು ಸಾಬೀತುಪಡಿಸುವ ಜವಾಬ್ದಾರಿ ಪ್ರತಿವಾದಿಗೆ ಇದಾಗಿದೆ. ದಟ್ ಇಸ್ ಅಪೀಲ್ ಹಿಯರ್ PWL ಅವರನ್ನು ಪಾರ್ಟಿ ಸವಾಲು ಮಾಡಿಲ್ಲ. ಆಕೆಯೂ ಸಹ ಯಾವುದೇ ಸಾಕ್ಷ್ಯವನ್ನು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ಹಾಗಾಗಿ ಈ ವಿವಾದಾಂಶಗಳನ್ನು ಸಹ ನಕಾರಾತ್ಮಕ ಇದು ಪಾರ್ಟಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಪೇಜ್ ನಂಬರ್ 87 ಅಲ್ಲಿ ಎಲ್ಲ ಪಾಂಡಿಚೇರಿ ಎಲ್ಲ ನಮ್ಮ ಭಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬೆಂಗಳೂರು ಪ್ರಾಪರ್ಟಿ ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ನೋ ಎವಿಡೆನ್ಸ್ ವಾಸ್ ಲೆಟನ್ ಬೈ ಹರ್ in spite of substantive opportunity given to her. In fact, issues were framed against her. She has not given any evidence regarding issues 7, 8, 9, 10, 11 and 12 in the party issue. Great suspect.
In fact, my lord, the earlier judgment cannot be looked into, issues cannot be looked into at this stage.
Let him argue.
Yes, it's great suspect.
Please take your seat.
Please, in the earlier suit, there were issues. Does the defendant prove that the father late Arakshami made a will in her favor in the year 1980 as contained in para 6 of the print? Issue number 8, does the defendant prove that late Arakshami divided amongst the children?
It on record, you are representing some respondents there.
No.
Both of you are together.
Uh,
See, this Supreme Court judgment says that section 11 issue cannot be considered. As it requires production of evidence, pleadings and adducing evidence. Therefore, it cannot be considered, by way of an application on the head. That's the, now what do you say for
Yes.
that?
I will say submit in the suit filed by
Contrary to this.
great suspect, in the earlier suit filed by them, the honorable court held the documents produced by them does not report B and C properties. That is why the suit was dismissed for non-production of the documents pertaining to B and C properties. The produced internet copy of some documents, and I have produced the internet copy standing in the name of Arog Jnana Pargasam. He has produced the internet copy to show that belongs to my father or Arog family. Based on those documents, no documents are produced by the plaintiff in 82 to 13.
You cannot hold a trial under an application. That's what the Supreme Court judgment says. Citation ಅವರು ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
ಅವ್ರಿಗೆ citation ಅವಲ್ಲೇ ಅವತ್ತು ಕೊಡ್ತೀನಿ. ಬರ್ಕೊಳ್ಳಿ.
ಬರ್ಕೊಳ್ಳಿ ಅಲ್ಲ, citation ಕಾಪಿ ಅವ್ರಿಗೂ ಕೊಡಿ, ಒಂದು ಓದ್ಕೊಂಡು ಬಂದು ಹೇಳಿ ಅದನ್ನ. You read those, go through those judgments and then submit.
Copy ಕೊಡಿ.
Heard the appellate's counsel.
B ಹೇಳ್ತಾರಲ್ಲ, that property
Around ಏನ್ ಹೇಳಿದ್ರು ಮಿಸ್ಟರ್ ಪಯಾಸ್ ಅಲ್ವಾ?
ಹೇಳ್ತಾರೆ ಬಯಾಸ್ ಬಿ ಶೆಡ್ ಪ್ರಾಪರ್ಟಿ.
ಇದ್ದಾರಂತೆ 2:30ಗೆ ಬರ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು.
You can come at around 3:30 or so, because we have another matter which is. ಮೂರು ಗಂಟೆ ಸುಮಾರು ಬನ್ನಿ.
Great respect.
You come at about 3:30.
Question, serial number 6.
Serial number 6 in which list?
In list 1.
List 1 17. Pass over ಆಗಿದೆ.
The date was fixed, my lords. For paper publication, this honorable court had been ordered, my lords. I request only modification in the date, my lords. In the date, shorter date, my lords.
Shorter date ಬೇಕಲ್ಲ?
My lords, I request, my lord, that we'll make the publish of newspaper on 8/9, and for the appearance of the parties, my lord, let 39 may be fixed, my lords. I've informed the other side.
I appear for respondent number 17 in this case, my lords.
ಇದು paper publication order ಆಗಿದೆ.
Notifying the date of hearing on 15/10.
So I request on 8/9 for the publishing of paper. But there is some urgency, a kind request.
ಇದು ಏನು ನಾವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಮುಂದೆಲ್ಲ ಆಗೋಗಿರುತ್ತೆ, ಮತ್ತೆ ಪದೇ ಪದೇ ಬರ್ತೀರಿ, ಅವಾಗ ಏನ್ ಮಾಡ್ತೀರಿ? When we are passing the order.
My lords, we have informed, my lords. Kind humble.
Sorry, we will not, even if both of are agreeable.
My lords, may I make a mention, my lords?
ಅಲ್ಲ, ನಾವು ಕೊಡ್ತೀವಿ ಸಫಿಷಿಯಂಟ್ ಬೇಕು ಅಂತ ಹೇಳಿ. ಯಾವಾಗೂ ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿ, ಯಾವ ಇಯರ್ದ ಅಪೀಲ್ ಅದು?
2019.
2019 ಅಪೀಲ್ ನಲ್ಲಿ ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾಳೆ ಸಬ್ ಸರ್ವಿಸ್ಗೆ.
3 times.
Pressurize.
Yes,
why all the crowd has come like this? Afternoon ಒಂದು ಅವ್ರದ್ದಿದೆ ಪಾಠಡ್, ಅದು ಬಿಟ್ರೆ ಇದು ತಗೊಳ್ಳೋದು ಬೇರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಮ್ಯಾಟರ್ಸ್.
Serial number 41, my lords.
One after another. See,
My lord,
we
serial,
have an appointment with the justice, 2:30 we can mention.
My lord, serial number 51, my lord, can be taken up next week.
ನಾವ್ ಏನ್ ಹೇಳಿದ್ವಿ ಅವ್ರಿಗೆ ಹೇಳೋದು ನಿಮ್ಗೂ ಅಪ್ಲೈ ಆಗುತ್ತಲ್ಲ, ಐ ಕ್ಯಾನ್ ಕಮಿಟ್ ಟು 2:30.
ಆಯ್ತು.
Serial number 42.
Court officer, madam.
1:30 ಗೆ ಎದ್ದೇಳ್ತಾರಲ್ಲ ಊಟಕ್ಕೆ.
Madam,
officer.
serial number 42.
Sir. 42.
Sir, ಹೇಳಿ.
42 ಇದೆ ಸರ್, ಅರ್ಜನ್ ಆಗಿಲ್ಲ.
Madam, ಅದು 2:30 ಗೆ final.
ಆಗಿಲ್ವಾ?
Madam.
2:30 ಗೆ ತಗೊಳ್ತಾರ ಮೇಡಮ್.
Number 59.
ಫೈನಲಿ ಮೇಡಮ್
42 ನಡೆಸ್ತೀರಾ, ಟೈಮ್ ತಗೊಂತೀರಾ?
42 ಇಲ್ಲ ಟೈಮ್ ತಗೊಳಲ್ಲ.
42 ಟೈಮ್ ತಗೋತೀರಾ?
42 ಇನ್ನೂ ರೀಚ್ ಆಗಿಲ್ಲ, ಅದು ರೀಚ್ ಆದಾಗ ಹೇಳಿ ತಗೊಳ್ತಾರ ಇಲ್ವಾ ಅಂತ ಇವಾಗ ಕೇಳಿದ್ರೆ.
ಅದೇ 6863 ಅಲ್ವಾ ಮೇಡಮ್?
ಹೌದು.
Court officer.
Yes, 42 ರೆಡಿ ಸರ್. ರೆಡಿ ಆಯ್ತು.
2:30 ಗೆ.
ಓಕೆ.
Court officer. Madam, court officer. Court officer.
ಅಚ್ಚುಕಟ್ಟಾಗಿ ಬಿಸಿ ತರ
Court officer.
National Insurance Company.
Court officer.
In this case. Copy to be served. Admit to forward.
Court officer.
ಹೇಳಿ ಸರ್.
Serial number 49.
49 ಇದೆ ಸರ್.
ಅಲ್ಲ, ಪಾಸ್ ಓವರ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್?
ಪಾಸ್ ಓವರ್ ಒಂದಿದೆ ಸರ್.
ಮಧ್ಯಾಹ್ನ ಬೇರೆ
ಎಲ್ಲ ಇದೆ.
ಮಧ್ಯಾಹ್ನ ಬೆಂಚ್ ಇದೆ ಬೇರೆ ಏನಾದ್ರು ಇಲ್ಲ?
45 ಇದೆ. ಸರ್, ಎರಡು ಇವಾಗ ಪಾರ್ಟೆಡ್ ತರ ಇದೆ, ತಗೊಳ್ತಾರ ಇಲ್ವಾ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ರೀಚ್ ಆದ್ರೆ ತಗೊಳ್ತಾರೆ.
ಮೇಡಮ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟು ಕಂಪ್ಲೀಟ್ ಆಯ್ತು ಮೇಡಮ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 41 ಇದೆ, 40 ತಗೋಬೇಕು. ಮತ್ತೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫರ್ದರ್ ಏರಿಯಾ.
ಬಾಕಿ ಫೈನಲ್ ಡೇಟ್ ತಗೊಂಬೋದಾ ಅಥವಾ
2:30 ಬೇಕಂದ್ರೆ ಡೇಟ್ ತಗೊಳ್ಳಿ.
ಡೇಟ್ ಕೊಡ್ತಾರೆ ತಗೊಂಡು ಯಾವ್ದ್ರಲ್ಲಿ ರಾಮಕೃಷ್ಣ ವಕಾಲ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ನಾನೇ ಯಾರು ಡೈರೆಕ್ಟ್ ಮಾಡಿ ಬೇರೆ ಕೇಸ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ, ಸುಮ್ಮನೆ ಇರ್ಬೇಕು. ಕರ್ದಾಗ ನೀವು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನೇನು ಮಾಡ್ತೀನಿ. ಇಲ್ಲ, ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ತಗೊಳ್ಳಲ್ಲ.
ನಮ್ದೊಂದು 2:30 ಬಂತ ಶುರು ಮಾಡ್ಬಿಟ್ರೆ
ಮಧ್ಯಾಹ್ನ ಅದು ಡಿಕ್ಟೇಷನ್ ಕೊಡೋದು.
Ready.
Lordship permission, what?
Yes.
Serial number 49. But will explore the possibility of settlement, not if any.
49.
49 MFA, is two appeals connected. Insurance appeals, my lord.
Insurance.
Yes, my lord. Date may be given after 10 days, my lord.
As requested by response counsel, list after 10 days. Yes.
Date
The
may
serial
be
number
given, Lordship.
41, appearing for the petitioner, just praying time for the matter,
You are for the appellant.
for the petitioner.
Other side
I
is
appear for
opposing
the
in the
response.
morning. You are opposing, no?
No,
ಅಲ್ಲ ಇದು
Minutes,
ರಾಮಲಿಂಗಂ
but,
TH.
Ramling sir, our,
He was seeking
for the petitioner, ma'am.
somebody on this side, arbitration matter ಅಂತ ಹೇಳಿ ಹೇಳಿದ್ರು.
please, minutes.
Requested by
Minutes,
appellants
there's
counsel.
they're seeking adjournment on health ground, minutes. Short accommodation, minutes.
No,
It's
after
a
18th
old
will be
matter.
good, my lord, because he's going for treatment actually.
How much time you want? Tell us.
Actually, but he's having a severe back issue, so he's going out of town for
How
treatment.
much time you want?
After 18th will be good.
18%.
Please.
21st, 21/9.
Oblige.
Oblige, ma'am.
Serial number 58 minutes, 58.1. That an application for impleading, my lord, is filed. Now the part
57 or 58?
58 minutes.
Oh, no, 58 is.
58.2, my lord, 2020 of 2022. An
Memo of
application.
retirement is there. Somebody has filed memo of retirement or for appellant, 58.2 nalli. Chandrasekhar, who is appearing now? CM Nagbhushan is there. Who has filed memo of retirement? NOC. ಆಯ್ತು ಗೊತ್ತು.
In this matter, my lord, the parties have, my lord, come to a amicable settlement. They want to go before the mediation center, my lord. Only impediment, my lord, is an application for impleading is filed in the RFA 2020 of 2022.
Yes.
That the proposed respondents are the family members. That they want to make sure that, my lord, all the family members are parties to the compromise. Only for that purpose, the application is filed. If this application is allowed, my lord, the parties are ready to, my lord, go before the mediation center. Lordship may kindly consider the application, my lord, and
Correct.
or, my lord, some other day, my lord.
matters.
That's one, my lord, any other day, my lord, not today, my lord, any other day.
This Nagbhushan's matter, only that will clear.
Please.
58.2 nalli ತಗೊಳ್ಳಿ. Since Shri V. Chandrasekhar has filed wakalat for the appellants or appellant? Appellant, Shri CM Nagbhushan Learned Counsel is permitted to retire. As requested by both counsel, list on, when do you want it?
Let Monday or Tuesday, my lord, only for this. In the orders
Or
list.
if you wait for some time, we'll pass orders on that application.
Please,
and
we will
then
wait,
refer
we will
it
wait,
to
we will wait.
Mediation, then
We will-
refer it to mediation.
We will wait.
Somebody 47, ಅದೊಂದು
57.
57, yes, But today, we have two part-heard matters. It may not be possible. As requested by response counsel, list on
25/9.
25?
9.
9. Yes.
Number 51, my lord. For appellate.
I appear for response number 2 and 3.
As requested by appellant's counsel, list after one.
Started meeting.
List on and the date.
29.
Serial number 60, my lord.
Bill number 59.
59.
59, last matter.
Hearing for the
Next
respondent,
week,
your
my
lord.
lord.
Yes.
Lord, an application filed under section 24 is also pending.
As requested by the appellant's counsel, list in the next week. You are not filed wakalat in the first matter. GB Sharath.
I will, your lordship. Next date I'll file wakalat.
List in the next week. All right.
Serial number 60, my lord. I appear for appellant. I inform respondents in 10 days time.
You appear for the appellant.
60.
60.
Appellant,
60, no?
60. After 10 days.
After 10, 1 week.
Any date, ma'am?
24 matter.
List on 24. ಮತ್ತೆ ಅದರಲ್ಲಿ ಎಷ್ಟು
We have filed early hearing, my lord. So that is why date is
List date.
September last.
30 days.
September.
Much obliged.
Serial number 47, my lord.
47, I am for the appellant. 47.1, I am for the respondent.
Matter is not likely to reach, my lord, then 9th or 10th, may I request, my lord, for 9th or 10th.
Requested by appellant's counsel, list on
9th or 10th of September.
9th or 10th, both are.
10/9.
10/9.
Much obliged.
My lord, serial number 49, my lord.
49 adjourned, sir. List after 10 days.
Please, my lord.
ಇದು ಇವ್ರದ್ದು ಯಾವ್ದೋ ಒಂದು ಶಾರ್ಟ್ ಇದು ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ mediation ಗೆ refer
Mediation.
ಮಾಡೋದು. ಅದು ತಗೊಳ್ಳಿ.
Serial number 58.
58.2 ನಲ್ಲಿ ರಿಟೈರ್ಮೆಂಟ್ ಹೇಳಿದ್ದೆ ನಾನು. 58.1 ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. 2020 ಹೋದ್ರ ಅವರು ಕೌನ್ಸಿಲ್ both of them left. ವಕಾಲತ್ತು ಹಾಕಿಲ್ಲ ನಾಗಭೂಷಣ ಚಂದ್ರಶೇಖರ್ ಇದ್ದಾರೆ. A number 1 2024. 2024. Yes, the form 6024. ಇವ್ರು ಏನಾದ್ರು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಎಷ್ಟೊಂದು ಕಷ್ಟ ಆಗುತ್ತಲ್ಲ 25 ಜನರನ್ನ ಸೇರಿಸ್ಕೊಂಡು. Suit is dismissed. Item number 44. Being restored harmonies. What is the number? 2024. Who has filed this application? Appellant has filed. Our service ಆಗಿದೆಯಾ? 2 of 2024 including application 2 to 25. ಇದ್ದಿಲ್ಲತಾ? ಇಲ್ಲ. ಇಲ್ಲ. ನೋಟಿಸ್ ಹೋಗಿಲ್ಲಲ್ಲ. ನೋಟಿಸ್ ಹೋಗದೇನೆ ಹೇಗೆಲ್ಲ ಮಾಡೋದು ಇದನ್ನ? ಅವ್ರು ಬರ್ಲಿ ಅಲ್ವಾ ಮೇಡಮ್ ಆಮೇಲೆ ಬರ್ತಾರೆ. No, but we ask them.
Pastor matter, seal number 2. Gangadhar Aital.
Appearing for the appellants, my lord.
For the
Needful done, my
respondent.
lord.
Papers,
For the rest.
they have filed. but
Yeah.
put up ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ
They filed the
ಸರಿಯಾಗಿ
paper.
copies, they are
Yeah, copy received.
Ministry has placed the paper books filed by the appellant's counsel. Learned counsel for the respondent submits that she has received 700. She has received the copies. ಇನ್ನೊಬ್ರು ಯಾರು ಕಿರಣ್ ತಿರುಮಲೇಶ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
2 and 3.
For 2 and 3.
The offers of protection circumstances.
Either.
The order date
You will give it to
14
me.
2024.
I'll give it.
Currently order date 14/8/2024 is recalled, and the appellant's appellant is permitted to proceed with the matter. Okay. Paper books ಆಗಿದೆ ಅಲ್ಲ ಈಗ. Okay. Please for final hearing.
Wealth, my lord.
Absence is there.
She is 82 years old, my lord. The mother.
For
She is
final hearing.
12/9.
12/9. Highly obliged.
List number 2, seal number 41 for further hearing. Anuparna?
My apologies, my lords. Morning I was held up.
But your matter had reached.
My lords,
We
my
are taking up
apologies.
matters in 3 days or 4 days.
My,
With
I-
this process, parties will also get aged and cases get aged.
my lords, my apologies. I was on my legs. I thought I'll make it.
Yes.
My lords,
See, in this case, your main argument was that he should have given an option, at least time wise and rate of rent wise, etc. Now we have already spent 14 years here. That time is over now. What
my
else
lords,
is required?
might as
Then
well,
by compulsion, you have made him to exercise that.
my lord, might as well another 30 years if I'm allowed.
No,
I'll-
but submission was that the conditions may be regarding the rate of rent and structure, etc.
Please, my lord.
Period of lease.
Yes, my lord.
But he should have given an option. Now,
Yes, my lord.
that option is now 14 years spent.
Yes, my lord. My lords, at the same time, I'm paying rent also. Where I was paying 827, now I have ended up paying 7 crores. My lords, I have concluded 3 issues on the last date of hearing. My lords, Yesterday I concluded 3 issues, my lords. My lords, whether the plaintiff proves that a defendant are liable to surrender the vacant possession of the suit scheduled property, whether the D2 proves that the lease agreement between the parties to the suit is compulsory renewable, and whether the plaintiff proves that the virtue of sale deed dated 1912 plaintiff is acquired a right to seek renewal. Then, my lords, I will not take much time, my lords. That's the reason I have made a concise. There are certain admissions in the plaint as well as written statement as well as the evidences. With regard to the assignment, the defendant number, in favor of defendant number 2, my lords, it's wrongly typed as defendant number 1. In that, my lords. My lords, the status of defendant number 2 as an assignee of the defendant number 1 as well as purchaser of the leasehold right of the defendant number 1, and also the fact that defendant number 2 is bound by the terms of lease deed dated so-and-so is admitted by plaintiff in plaint in OS number 144 of 2011. It is also admitted that defendant number 1 had purchased his interest under the lease.
No, one had assigned.
Assigned, my lords, had assigned his interest under the lease deed dated 23/9/1961 in favor of defendant number 2. My lords, the admissions I have mentioned, which all the page numbers and paragraph numbers in the plaint, in the written statement, in the evidence of PW1. If my lords permit, I will just go through one of this.
Position is not disputed at all by them.
Yes, my lords. No, as a, what they have disputed that.
Most of the things are admitted here.
Yes, my lords.
This lease agreement in favor of defendant number 1.
Yes, my lord.
Assignment in your favor.
Yes, ma'am.
They're all admitted.
Yes, ma'am.
And even that exchange of notice P3 and P4.
Yes, my lord.
Only question is whether you are entitled to seek specific performance.
Please, ma'am.
You are entitled to seek,
Yes,
you are
my lord.
entitled to specific
Yes.
performance. Yes.
Then, my lords, with regard to the limitation, also the court have, in the trial court has answered it in our favor, though there was, the plea was raised at the time of arguments, no issues were raised, no averments were found in the plaint. And the court have ultimately held that since the cause of action arose when the lease expired, so from 3 years, the date was taken, my lords. So the finding of the trial court is not challenged by the plaintiff here. And my lords, there was no reference of that earlier letter in the present, in P3 and P4. Earlier letters were pertinent to fresh lease. Then, my lords, the next statement is admission with respect to charitable trust. So, my lords, recollect that in the order, there was a controversy whether it's a trust or an institute. In various places, they have admitted that it is a charitable trust. Then, my lords, there are certain contradictory statements which has been taken.
Exhibit 330 is the trust deed.
Trust deed, my lords.
So
Trust
what
deed has been, in the trust deed, they said that it's a public trust.
It is a public trust.
Yes.
It is registered in which year?
My lords, it's
330 is the registered trust deed.
it's a registered, it is not a registered trust deed. There is the evidence of PW1, he himself have admits that it is not a registered trust deed.
Okay.
It's
But
a
do you
P30
dispute-
month.
Have you disputed that it is a charitable trust?
Yes, my lords, we have.
That exhibit 330 is of which year?
My lords, it is of the year.
What is it?
Let's P30 is at
Records, ECS.
page 462, my lords.
We'll see the original. P30.
It is dated
30 years old document.
19th March 2010.
19/3.
March P30,
So
19th.
it's more than 30 years old document that presumption has.
Yes, ma'am.
In the document, what they have stated?
It is a charitable institution, public in nature.
Memorandum of trust.
That was at
Assistant and
464.
Assistant Commissioner. So it is registered with sub-registrar.
Well, as, I don't have the benefit of that.
Bangalore Taluk. It's a certified copy.
Because in the evidence, it says it is not registered.
Because the endorsement here is sub-registrar and assistant commissioner stamps Mangalore Taluk.
It's a stamp maybe.
Regarding stamps.
It must be stamped.
Regarding stamps only.
Because there is a deposition, my lords, wherein the PW1 has
Okay,
stated.
we are, even assuming that it is unregistered, this is a 30-year document.
Yes, ma'am.
Public charitable trust, it says the contents. Public charitable trust. Bishop of Solomon is the present incumbent in pursuance of the resolution of the managing committee of so and so. To have a public charitable trust created by this indenture, a declaration constituting under mentioned parties as the trustees. Whereas the trust was established in 1898. The trust was established in 1898. as
Yes,
per-
my lords.
Name of the trust shall be Continue Charity Institution Trust. All right. So if not registered,
It's a stamp
charitable trust.
trust. Therefore, my lords, the section, under section 1 of the Trust Act, it is not applicable. Therefore, section 36 is also not applicable.
What section 1 and 36? Trust Act.
My lords,
One is about the short title, etc.
lords, short title commencement, local extent and savings.
First. It extends to whole of India and the Andaman and Nicobar, but central government may by from time to time. Andaman and Nicobar is. What 36 says? Regarding
20, maximum 21 years, it says.
36 bar. In addition to the powers expressed.
Section 30. Well, 36 proviso.
Exception, there is, except with the permission of the principal civil court of the original jurisdiction, no trustee shall lease trust property for a term exceeding 21 years from the date of executing the lease, nor without reserving the best yearly rent. Okay. A trust is interpretation clause. Trust is an obligation annexed to ownership of the property. Benefit of another. How it excludes section 1 will not exclude it, it seems. How section 1 excludes this?
My lords, but nothing contained affects the rules of Mohammedan law as work or the mutual relation of the members as individual as determined by any customary or applies to a public or a private religious or charitable endowment or to trust to distribute prizes taken so and so, so and so.
See, what is not applicable is Mohammedan law has to work for. Then mutual relationship of the members of an undivided family. This is not.
Yes, my lords.
This will not.
Or applies to public or private religious or charitable endowments.
Trust to distribute. That is what
Or
for
to
that.
trust.
Trust to distribute prizes taken in war amongst the captors.
My lord, assuming for a moment, even if it is a trust or an institute, my lords, the only requirement is that you need to take a prior permission of the civil court, my lords. So far as we are concerned, my lords, yesterday I shown that clause 2 of the affidavit, which says that I am agreeing into it based on the terms of the lease deed. So terms of the lease deed includes the renewal. My lords, assuming for a moment if specific performance is granted in my favor, they can go to the court and seek a permission for the same. It's
the
not.
court can grant it
No,
without the permission of the court.
No, my lords, it
Show
is.
us the law which permits that after passing a decree for specific performance,
My lords,
permission can be
my lords,
granted.
first of all, my contention is permission has already been taken.
Permission was for that 50 years.
My lords, it also.
Prior 50 years.
But it also includes for renewal. And that is also a part of the affidavit.
Where is that?
My
Because that order is not there. Only
Order is not there, the affidavit is there, my lords. The affidavit is that.
Paper volume 1. Sorry, volume 2 ಅಲ್ಲಿ ಇದೆ print. Affidavit is at page number?
Page number 433.
433, 434, my lords.
Where it says that.
I say that in consequence of mutual discussion, the draft of the term lease filed along with the petition of the lessor has been approved by me, and my firm is prepared to take that property on lease on those conditions. So the lease deed was presented before the court, and it has been.
No, now renewal or extension.
Please, my lord, is contemplated in the term lease.
No, you said in this affidavit, extension permission is also.
No. What I'm saying is, my lords, in the clause 2, it says that the draft of the term lease filed along with the petition of the lessors has been approved.
That was for a period of 50 years. Next 50 years or next any period.
Yes, my lords.
If at all it is to be extended.
Yes, my lord.
Exceeding 21 years.
Yes, my lord.
That is required, no?
My lords, the clause includes renewal term. Renewal term will be as.
Only it says shall give an option.
Please, my lord.
Subject to the terms and conditions agreeable to the parties mutually with regard to rent, term, etc.
Yes, my lord.
Yes.
I agree, my lords, but.
No, to grant specific performance. Now you renewal.
Yes,
there should be specific, if there is renewal clause that it should be next for 20 years, 10 years, then
Yes.
specific performance could have been granted.
Yes, my lord.
Now it says it is to the, subject to the terms agreeable by the parties.
Yes, my lord.
So if at all, now
Yes.
you have not said how long you wanted it
Yes, ma'am.
in your suit.
In my suit, my lords, I asked for 50 years, my lords, that is the.
If at all you say 50 years, then permission of the court is required.
Yes, my lords.
Without permission of the court, can we grant it?
My lords, in that case, my lords, then permit me, if it is within the law, how much ever it is entitled to, the plaintiff is entitled to give me at least that much I am entitled to. If-
Which you have already taken a
No,
14
my
years.
lords, first of all, there was no redder when renewal clause doesn't contemplate a condition that you have to take subject to the approval of the civil code. That is not contemplated. That was
If at all lease is to be beyond that statutory period required under section 36,
yes, ma'am.
then permission is required.
Please, my lords, what I am trying to say, my lords, in the lease deed, there was no condition precedent which
Even if there is no
Not-
condition
if the-
precedent, you cannot bypass the law.
Well, if there was a statutory requirement to take a permission from the court for the renewal, so they can grant me renewal in terms of that. If they can give me within 21 years. Beyond 21 years, they have to take the permission.
Yes.
Then, my lords,
This is about charitable trust. Go to the next point.
Yes, my
Contradictory
lord.
stance of plaintiff with regard to reasons and refusal for. Yes.
my lords, so far as specific performance is concerned, my lords, all the cases which has been relied upon by the other side in that there was no readiness and willingness after the termination was over, they sought for renewal. In our case, in terms of the act, I have exercised my option. My argument is renewal is my right. Assuming for a moment, even if it is not a right, it is an option. I have exercised my option duly in terms of the term lease. There are more than 300 workers working in that place, my lords, and there are substantial improvements that I have taken up on the property. And my lords, according to them, they are a charitable institute, bar trust. Will they carry out the hotel business in that property? They will also ultimately lease the property to a third party, my lords, or anybody for that matter. They may not run a hotel. Ultimately they have to lease it out. It is not the case that, and they have stated also in their evidence that they need this property for raising finance. Therefore, my lords, ultimately they will give it to a third party, if not me. If on a basis of a fair rent, if it is given to us, then I don't see there is any difficulties that they will face.
Yes. Yes.
And my lords, may kindly turn to page 391. 391. First volume.
Volume 1 or volume 2?
Volume two.
Volume.
Volume two.
Yes, sir. Exhibit P4.
My lords, at page 394, at para 6,
Yes.
the lease property is required by us for achieving the object of our institution. We have been running ashram and we require sufficient finance for extending our charitable activities. It is not my case that I want to continue with the same rent of 800 rupees. I am willing to give the rent what they expect us to pay based on the nature of the property. Therefore, my lords, there is no hardship that will cause to them if specific performance is granted in our favor. Yes. Then, my lords, page 1. Then, my lords, at page 404, first para bottom, at no point of time our institute had given you the option to renew the lease. Then, my lords, there are 3 conditions that they have cited for refusing the specific performance. Being, my lords, renewal was not sought by the original lessee.
Yes.
Renewal was not sought by the original lessee. The renewal terms is ambiguous and non-enforceable. My lords, these 2 I have already addressed yesterday. Milagir's charge did not permit them to renew the lease. There is no requirement for them to seek permission from because they are on permanent tenancy. And it was not one of the condition precedent.
Yes.
Then, my lords, civil court permission is required for renewal under section 36, my lords. My lords, if that was the case, my lords, then they could have taken they could not have added this clause. The courts have time and again held that renewal clause cannot be ignored. So the clause should not have included only if it was not permitted under the Indian Trust Act.
Yes.
Then, my lords, next is with respect to specific performance.
You have to make one compilation.
My lords, I will, after I finish my arguments, I'll just make it one.
We cannot go and search here.
My lords, I'll make one. After I conclude, my lords, I'll make one.
Oliver, this synapses also, this
My-
also piecemeal base.
I'll give a comprehensive one, my lords. This is for the reference.
Then another not comprehensive.
This
another
only
one,
I'll stitch
and
it.
another time for that is.
My lords, we'll stitch it and give it to you.
Yes.
My lords, the first proposition is that the court may properly exercise the discretion to decrease specific performance in any case where the plaintiff has done substantial acts or suffered losses in consequence of the contract capable of specific performance. My lords, in this case, whatever obligations we had to do, we have done it. We have shown our readiness and willingness. We have offered substantial rent. In spite of that, my request was not adhered to. It was straight rejection. There was not even given an option that this is the fair rent, and it is not their case. My lord, so far as equity is concerned, it is not their case that they will demolish the building or they'll do something about it. It's a charitable institute, what they are saying, and they want finance. So all comes down, boils down to rent. The rent I am willing to discuss, and if they are willing to give, come to a discussion with respect to the reasonable and rent, then that can be extended, my lords. And my lords, what is the loss that they are suffering that they have not shown? Then, my lords, the next judgment, the relevant paragraph also I have enclosed, para 14.
Yes.
It is well settled law that the power to order specific performance of contract is discretionary, and the parties cannot claim it is a matter of a right, although it is a lawful to such discretion should be exercised judicially and prudently. Section 20 of Specific Relief Act, discretion as to the decree specific performance. The jurisdiction to decree specific performance is discretionary, and the court is not bound to grant specific relief merely because it's lawful to do so. But the discretion of the court is not arbitrarily, but sound, reasonable, guided by judicial principle and capable of correction by court of appeal. The following are the cases in which court may properly exercise discretion not to decree specific performance, where the terms of the contract or conduct of the parties at the time of entering into the contract or other circumstances under which the contract was entered into are such that contract, though not voidable, gives plaintiff an unfair advantage over the defendant, where the performance of the contract would involve some hardship on the defendant, which he did not foresee, where its non-performance would involves no such hardship on the plaintiff, where the defendant entered into a contract under circumstances which, though not rendering the contract voidable, makes it equitable to enforce specific performance. Mere inadequacy of consideration or the mere fact that the contract is onerous to the defendant or improvident in its nature shall not be deemed to constitute an unfair advantage within the meaning of clause A or hardship within the meaning of clause B. Explanation. The question whether the performance of a contract would involve hardship on the defendant within the meaning of clause B shall except in cases where the hardship has resulted from any act of the plaintiff subsequent to the contract be determined with reference to the circumstances existing at the time of contract. The court may properly exercise the discretion to decree specific performance in any case where the plaintiff has done substantial act or suffered losses in consequence of the contract capable of specific performance. The court shall not refuse to any party specific performance of a contract merely on the ground that contract is not enforceable at the instance of that party. Then, my lords, the possibility of injury to the interest of the third party does not by itself disentitle the plaintiff from specific performance, but it depends upon the facts and circumstances of each case, which will be considered by the court in the exercise of discretion. The court may properly exercise the discretion to decree specific performance in any case where the plaintiff has done substantial act or suffered losses in consequence of a contract capable of specific performance. In the instance case, the respondent number 1 and 2 filed an original suit for the specific performance of contract.
Why do you want to read the facts of that case?
My lord, the sum and substance is that it is a case which can be specifically performed.
Right, principle you read.
Yes, my lords. Then, my lords, the next judgment is with respect to there is no prohibitory in the absence of prohibition against assignment. The vendee under an agreement to sell is entitled to law to assign his rights, title, interest under the agreement to any person of his choice, and assignee is entitled to enforce specific performance. My lords, at page 13, para 10, the legal proposition which emerges from the above referred decision is that in the absence of prohibition against assignment, the vendee under an agreement to sell is entitled to, in law, to assign his rights, title, interest under the agreement to any person of his choice. Once he assigns his right under the agreement, the assignee steps into his shoes and being his representative in interest, he can seek specific performance of the contract in view of the statutory right conferred upon him under section 15B of Specific Relief Act. My lords, 20.
Yes.
The next, that's page 23. Para 28. In Simanso Suhara VV versus GLX, this court, while dealing with a matter relating to grant of compensation by High Court under Section 21 of Specific Relief Act, in addition to the relief of specific performance in the absence of prayer made to the effect either in plaint or amending same at any later stage of the proceeding to include the relief of compensation in addition to the relief of specific performance observed. Grant of such relief in the heat of express provisions of the statute to the contrary is not permissible. On equitable consideration, court cannot ignore or overlook provisions of the statute. Equity must yield the law.
Yes.
Then, my lords, the next judgment at page 33. Let's page 41, para 12.
Yes.
In case of so-and-so, the question placed before the Privy Council is whether the counterpart document agreeing to reconvey village earlier conveyed to vendee in favor of A, who was mentioned in the counterpart document, would enable A heir B to enforce the terms of the said counterpart document by selling the said right to the plaintiff of that case. Then, my lords, in some 20 lines below, my lords, on terms of document, my lords got it? On terms of documents, no implied prohibition was also this concerned by the Privy Council. In this connection, we have also keep in view 23B of the Specific Relief Act, which is analogous with Section 15B of the Specific Relief Act. It lays down that except as otherwise provided, the specific performance of a contract may be obtained by representative in interest or the principal of any party thereto. Thus, normally any interest in a contract could be assigned to any representative in interest who also can enforce specific performance of the contract against the contesting party. However, if the terms of the contract expressly or by necessary implication prohibited the beneficiary from transferring his contractual interest to third party, then only such assignee cannot sue for specific performance. Then, my lords, the next judgment also pertains to the right of the assignee to enforce specific performance.
Yes.
My lords, at page 47, para 15. I am supporting my view with Privy Council decision in so and so, in the light that authority of law has been, the rule of assignability appears now to firmly establish that the exceptions founded on contrary intention has to be proved by the party asserting it to deprive assignees of benefits of the contract. This is true approach, and converse rule apparently underlying the decision in 35 so and so can no longer be said to be a good law. Then, my lords, para 26. I have no doubt in my mind that it was the intention of the parties, also the effect of two so and so, and the fact that Fear Ali, who had made a party to present suit performer defendant, did not controvert the position in spite of specific allegation in this point. This again, it's a fact. Then, my lords, the next judgment at page 55. That is with respect to limitation, my lords.
Yes.
Article 54 of Part 2 of Schedule of the Limitation Act stipulates the limitation period for filing of the suit for specific performance as 3 years from the date fixed for performance, and in alternative, when no date is fixed, 3 years from the date when the plaintiff has noticed that performance has been refused. Section 9 of the Limitation Act stipulates that once the initiation period has commenced, it continues to run irrespective of any consequent disability or ability to institute suit or make an application. In this case, my lords, both the clauses of Article 54 is taken care, my lords. My cause of action arose when renewal was due and when my renewal was refused. And trial court have, though issue was not framed, held that limitation, it is not within the limitation. My lords, next I'll deal with main profit.
Yes.
My lords, so far as mean profit is concerned, my lords, there are two sections which Section 212, my lords. It's 212, main profit of a property means those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest on such profits, but shall not include profits due to the improvements made by the person in wrongful possession. Order 20, Rule 12, my lords. Where the suit for recovery of possession of immovable property or for rent
We can read.
or mean profit, the court may pass a decree for the possession of the property for the rents which have accrued on the property during the period prior to the institution of the suit, or directing an inquiry as to such rent. For the mean profit or directing an inquiry as to such mean profit, directing an inquiry as to tenth or mean profit from the institution of the suit until the delivery of possession to the decree holder, the relinquishment of possession by the judgment debtor with notice to the decree holder through the court, or the expiration of 3 years from the date of the decree, whichever event first occurs. So the eventuality has been defined, my lords, and the tenure for which mean profit can be granted. When an inquiry is directed under clause B or clause C, a final decree in respect of rent or mean profit shall be passed in accordance with the result of such inquiry. Yes. My lords, admittedly, there is no evidence which was produced by the plaintiff for the calculation of the mean profit. The evidence was led, my lords, I may be permitted to show the evidence. My lords, 177 of paper book volume 1. $177, my lords.
Yes.
My lords, my difficulty is to read it. I read it with translation.
You want us to read?
I understood, my lords. I got it.
To read?
Please, my lords.
You want us to read?
No, my lords, I will, if permit, I can read the English translation of it.
Yes.
My lords, in this, witness have stated that he has no, he states that there is lot of income and we earn 1 lakh income, rupees 1 lakh we earn and per day. But I'm saying based on the eyewitnesses and the nature of the property.
Yes.
So based on his assumption, it is 1 lakh per day. And taking that into consideration, court have granted 50,000 per day. On the contrary, my lord, there is no admission by DW1 to state that they earn rupees 1 lakh per day.
Yes.
Then, my lords, the citations.
Yes.
The first citation, my lords, wrongful possession in essential to the claim mean profit. The first judgment is Shyam Kishore versus Roop Sari Kendra and others, my lords. The relevant paragraphs are para 19 at page 9.
In our compilation, you have left the para blank.
My lords, I'll write.
In yours, you have written.
It's written. My lords, I'll.
See, we said, Mr. Shashi Kiran Shetty, that if you will not argue, we'll dismiss the petition. So she is taking revenge of that.
No, my lords, my apologies. I'll write it down.
All right.
My lords, I think after Xeroxing, they wrote the paragraph numbers. I'll write it, my lords.
Your colleagues want to help you and not us. Yes. Yes, page number.
My lords, page number 9, para 19.
Page number 9, para 9. Yes.
There is no gainsaying the fact that the suit of mean profit or for that purpose for damages enumerates from wrongful possession of a tenant. Section 212 of the CPC defines mean profit as under. Mean profit is showing of the property means those profits which the person in wrongful possession of such property actually receives or might with ordinary diligence have received therefrom by the person in wrongful possession. Thus, unless and until the possession of the tenant is wrongful or unlawful, the suit for mean profit does not lie. Termination of tenancy of a tenant by way of notice under section 106 of the TP Act does not render the possession of the tenant either unlawful or wrongful for the purpose of the Slum Clearance Act. It affords additional protection to the tenant that unless and until the permission is obtained under section 19 of the Act, suit or petition for eviction would lie. My lord, this is with respect to facts. A tenant cannot have two split personalities, one for the purpose of suit for recovery of possession and another for the purpose of recovery of mean profit. That is for purpose of recovery of possession, he will continue to be a tenant and not termed as unauthorized or unlawful occupant. But for the purpose of recovery mean profit, he is unauthorized or unlawful occupant by virtue of termination of tenancy under section 106 of TP Act. Had the termination of tenancy of a tenant by way of a notice under section 106 of the TP Act had the effect of rendering the possession as unlawful or wrongful, remedy by of a suit of possession would have been readily available as available in respect of tenants who are not governed by the Slum Clearance Act. Once a protection is affordable by a statute to a tenant, the only effect of termination of tenancy by virtue of notice under section 106 of TP would be that tenancy would be treated as a statutory tenancy, if not regular tenancy. Then, my lords, the next judgment is at page 12. My lords, page 19, Roman 3. The period for which page 19, my lords, Roman 3.
Yes.
The period for which the mean profit have been awarded is to be restricted to one permissible under Order 20 Rule 12(1)(c) of the Code of Civil Procedure. Such period in light of the provision would be the one commencing from the date of the institution of the suit and ending on the expiration of 3 years from the date of the decree of the trial court. The expression decree occurring in the aforesaid clause according to the council means the decree of trial court. In other words, the maximum period for which mean profit can be awarded and would be deemed to have been awarded is 3 years from the date of decree of the trial court, and the courts below were wrong in awarding mean profit for a period more than 6 years, commencing from the date of institution of the suit till the delivery of possession in accordance with decree of this court to the plaintiff. 24, my lords, para. Mean profit being in nature of damages, no invariable rule governing their award or assessment in every case can be laid down. The court may mold it according to the justice of the case. Even so, one broad basic principle governing the liability for mean profit is discernible from section 212 of the Code of Civil Procedure, which defines mean profit to mean those profits which the person in wrongful possession of the property actually received or might with ordinary diligence have received therefrom together with interest on such profit, but shall not include profits due to the improvements made by the person in wrongful possession. From a plain reading of this definition, it is clear that wrongful possession of the defendant is the very essence of the claim of mean profit and the very foundation of the defendant's liability thereunder. As a rule, therefore, liability to pay mean profit goes with the actual possession of the land. That is to say, generally, the person in wrongful possession and enjoyment of the immovable property is liable for mean profit. But where the plaintiff's dispossession or his being kept out of possession can be regarded as a joint or concerned act of several persons, each of them who participate in commission of that act would be liable for mean profit, even though he was not in actual possession, and the profits were received not by him, but some of the confederates. Then, my lords, another 26, para 26, another principle recognized by the court in so and so is that decree of order 20 rule 12 of the court directing inquiry into the mean profit, however expressed, must be construed to be decree directing inquiry in conformity with the requirement of rule 12(1)(c), so that the decree holder is not entitled to mean profit for a period commencing from the date of the institution of the suit, extending beyond 3 years from the date of preliminary decree. Then, my lords, the next judgment is at page 28. The relevant paragraph is at page 14, my lords. Page 37.
This
mean profit are defined in section 212 of the Civil Procedure Code as meaning those profits which the person in wrongful possession of such property.
all the judgments are repetition, only the same point.
My lords, that is the reason.
Payable by a person in wrongful possession.
Yes, well,
But why are you multiplying so
my lord,
much?
this judgment talks about the difference between tenant with respect to the wrongful possession. My lords, I may be permitted to read this judgment and the next judgment. After that, my lords, the position is very clear that I have written down in
See,
the
all those judgments,
Please, my lord.
they arose out of rent control acts or some special enactment governing
The slum. But irrespective of that, my lords, that
they say that
the provisions of Rule 20, Order 20, Rule 12 and Section 212 is applicable.
no, therefore it was held that they become statutory tenants.
My lord,
So
so far
whatever
as
rent is payable, they cannot be called as a persons in wrongful possession. At the most,
Yes, my lord.
their possession is protected by the law.
Yes, my lord.
Therefore, they cannot be called as. Then why do you
So
repeat
far
those
as-
judgments?
So far as we are concerned, my lords, as per Order 20, Rule 12, the inquiry has to be conducted. There is, and my lord, there are
So
judgments.
which of these judgments say that inquiry is a must? Because that provision says or.
My lord, irrespective of that, there should be some yardstick to decide the mean profit.
So they were trying to rely on your own admission. Your evidence, your
I
admission.
never said, my lords, 1 lakh per day I make profit, my lords.
Oh, senior counsel pointed out some.
My lords,
admissions of,
what I have stated is that there are 100 rooms and the rent is 1,000 rupees to 1,000 rupees to 4,000 rupees. That does not mean every day I have a full room.
Occupied.
A full occupancy, and I have no expenses at all. There are 300 employees sitting there, and it says that there is a marriage hall. Every 75,000 or something I charge. Every day there will be marriages. That cannot be construed, my lords. In that case,
they said 50% of that has to be deducted towards.
No, my
expenses.
lords, that is not the point. The point is, it cannot be based on some assumptions. The mean profit cannot be calculated based on assumptions that some days there will be full occupancy, there will be zero occupancy certain months.
Yes.
So average has to be taken.
Why have you not produced your income tax returns to
Please,
show
ma'am.
how much income you have shown for this property for consistently
My lord,
for
it
some
is,
years.
it is not for me to prove. Mean profit has been claimed by the plaintiff. So they have to produce necessary evidence for that purpose. It is not me who's claiming mean profit, my lord. It's they who has claimed. And if they doesn't have any documents, they should have sought for an appointment of an inquiry, a commissioner to inquire into it. That is what the courts have time and again held, that you have the petition for mean profit is not maintainable if there is no prayer for appointment of commissioner.
Where it is said, shows. Where it is said?
My lords, it is there. My lords, 81, page number. My lord, that page 87 may be taken, my lords. 2008 3 SEC 183.
Page 87.
Please, my lords. Para 4.
Yes.
It was therefore pointed out that the grant of main profit without an inquiry in terms of Order 20 Rule 12 was permissible. As para 7, it was para 6, my lords. It is however pointed out by Sri S.T. Sinha that the High Court erred in awarding the plaintiff mean profit even though there is no demand for the same in the plaint. The learned Solicitor General appearing for the plaintiff considered that there was no demand for mean profit as such, urged that the claim for mean would be included within the expression awarding possession, occupation of the property aforesaid, together all rights pertaining to thereto. We are afraid that the claim of mean profit cannot be included within the expression. High Court in error awarding to the plaintiff mean profit, though they had not claimed in the plaint. The provision with regard to the mean profit will therefore have to be deleted from the decree. We miss the appeal defendant number 1 to 5 and affirm the decree passed by so and so. With regard to mean profit, the High Court, while deciding the second, have failed to notice that while issuing notice, it was categorically noted plaintiff had not prayed for an inquiry relating to the mean profit in terms of Order 20 Rule 12 CPC, and in the absence of any specific prayer for any inquiry into the aspect, the same could not have been granted. As rightly contended by learned counsel for the appellant, that though at the time of issuance of the notice, the High Court had noticed that substantial question of law did not arise for consider while deciding the second appeal, the aspect lost sight of. In circumstances, would be appropriate to remit the matter to High Court to consider that aspect. The appeal is allowed the aforesaid extent with no order as to the cost.
Yes.
Hello, there has to be some yardstick.
Yes.
And my lords, it's a charitable institution. They are well aware this property is given for the commercial purpose. And I have argued yesterday also with respect to the stepping into the shoes of the defendant number 1. So the improvements are definitely was done by defendant number 1, but I have also repaired. The property cannot stay in the same shape from 1984 when I took it over. And I step into the shoes of the defendant. So improvements, the at max mean profit can be claimed with respect to the land, not on the improvements. That's a settled principle, my lords, with respect to Section 212 is concerned. And these judgments.
Have you laid evidence about that? You said now they have to prove the mean profits. Now you say you have made certain improvement, you repaired, etc.
My lords, in my evidence, I have stated, my lords, that
how much you have spent, how much
I have spent 19 crores.
No, have you laid evidence, any documentary evidence?
A documentary evidence I have not laid.
Yes.
But my lords, it is an admitted position that they have, the land was given to defendant number 1 and there are certain structures which were made by defendant number 1. He could not run the hotel and then he has assigned it to me. And I step into the shoes of the defendant number 1. So therefore the improvements which has, and I have paid a substantial amount of 1 crore 14 lakhs at 1 crore 14 lakhs at that point of time. whereby I have purchased the land. I have purchased the building, my lords, and leasehold right.
But can you say that you have purchased the land?
No, not land, my lords. No,
Even
the,
buildings also. What you got is only leasehold rights.
the improvements, my lords, I have purchased.
Leasehold rights. What you got is only leasehold rights.
Leasehold right,
not-
absolutely
You
right, my
can't
lords.
say you purchased
No,
the
no, no,
building.
no, I stand corrected. I have purchased the leasehold right and the improvements made thereon.
Yes.
Therefore, my lords, the claim for mean profit has no legs to stand.
Yes. Yes, have you got to say anything on this?
My lord, that list of dates correlated to, my lord, same list of dates, there is no change, correlated to the page numbers of their paper book I've made. Because my list of dates, my lord, I had correlated to this, but she was arguing, my lord, based on their paper book. So, my lord, I have made that. Then just, my lord, give me 10 more minutes, I'll point out. First of all, last, my lord, submission of my learned friend is, there has to be, my lord, compulsorily an inquiry into mean profits. My submission is, please look at order 20, rule 12, 2B. Order 20, rule 12, sorry, BA.
Last time you pointed
ಹೌದು, ಅದನ್ನೇ.
or that
ಅಷ್ಟೇ,
word or.
mean profits. So, my lord, when
Hmm.
either, my lord, there could be, my lord, mean profits awarded in the decree, or there could be, my lord, an inquiry. Inquiry is not needed if, my lord, there is sufficient evidence already, my lord, before the court for, my lord, arriving at a question of mean profit. It is only when, my lord, there is no evidence available. In the instant case, he himself says, these are, my lord, my learned friend started saying, namage expense ide, not one evidence has been led by him. On the contrary, in the cross-examination, your lordships have seen, he goes on saying, I earn, my lord, these are the number of rooms, 110 rooms. He gets, my lord, an income of 1,000 to 4,000 per day. And he also says that, my lord, there is a Kalyan Mandap, there is a banquet hall. He categorically states, 75,000 rupees I collect. Every month, my lord, there are 5 to 7. That's what, my lord, his evidence is. Your lordships have seen. I don't want to repeat myself. And based on his evidence, my lord, I have, in my list of dates, computed, my lord, how much, my lord, would the income be? It will be, my lord, 2,67,000, my lord, per day. I have said, my lord, I am taking only 50% and therefore 1 lakh. I put all that. I don't want to, my lord, repeat myself.
Yes.
Then, my lord, the other contention, my lord, that has been canvassed is that limitation, my lord, a duty is cast on the court. Anyway, my lord, that's one aspect. That's why, my lord, some of the judgments, in anticipation of her, my lord, argument, my lord, I had placed, my lord, those. If your lordships take, my lord, my list of judgments.
Section 3.
Correct. Your lordships are aware, my lord, it's like carrying coal to Newcastle. ಯಾವಾಗಲೂ ನಾನು ಹೇಳ್ತೀನಿ, ನಾವೇನೋ ಇಲ್ಲಿ ಬಂದು ನಮಗೇನೋ ಬಹಳ ಬುದ್ಧಿವಂತಿಕೆ ಅಂತ ತೋರಿಸ್ತೀವಿ. ನಮ್ಮ ಹತ್ರ ಎಲ್ಲ ಇರುತ್ತೆ.
Section 3.
ಹೌದು, ಅದನ್ನ ಫಾಲೋ ಮಾಡಿನೇ, my lord, the Honorable Supreme Court has held that duty is cast on, my lord, the.
Only one distinction was tried to be made, that in those exhibit P3 and P4, they sought fresh lease, not renewal
My
of
lord, that is
lease.
why I.
Therefore, cause of action did not start from there.
My lord, that is why I gave, my lord, on the first day itself, renewal is nothing else but a fresh lease. If my lord sees, again, my lord, just to repeat myself, please come to, my lord, the judgment I have given to your lordships. It is a fresh lease, my lord, renewal is a fresh lease. Please come to running page, my lord, 284 of the judgment compilation. I did mention this on the last occasion, but our time only, probably, my lord, focus ಇರಲಿಲ್ಲ. ಯಾಕಂತ ಹೇಳಿದ್ರೆ ಇವರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇರಲಿಲ್ಲ. ಹಾಗಾಗಿ now please come to 284.
Yes, please.
If your lordships come to, my lord, paragraph 29 at running page 297.
297.
Yes, my lord.
Yes, we have marked.
See, correct. My lord, renewal is nothing else but a fresh lease.
Grant of renewal is a fresh grant.
Correct.
And must be consistent with law.
Law. ಅದು ಒಂದು. ಎರಡನೇದ್ದು, my learned friend, my lord, referred to. So, my lord, it is, renewal is nothing else but, my lord, a fresh grant, a fresh lease. She asked for a fresh lease. In the year, my lord, 2019, my lord, 1986, we said, sorry, you can't. Therefore, my lord, limitation, my lord, will squarely apply. At any rate,
You are trying to say that by in the terms of fresh, in the words of fresh grant, or using that
That's right.
phraseology, he sought renewal.
correct.
That is it.
Then, my lord, the other contention that has been canvassed is fair rent to, my lord, conduct and ಹೇಳಿದ್ರು. Oh, I was willing to pay, my lord. For 50 long years, he was paying 800 rupees a month. And he says in his written statement, if your lordship stay, he says, I will give you 50,000 rupees per month. A person who, my lord, after all, my lord, charitable institution, ಅದಕ್ಕೆ ಹೇಳೋದು conduct ಅಂತ ಹೇಳೋದು repeatedly.
Not quite, probably you were here or not, we do not know. That she was trying to say that this was not a registered public trust.
My lord, ultimately, my lord, whether it is registered public trust ಅಂತ ಅವರೇ ಒಪ್ಪಿದ್ದಾರೆ. ನಮಗೆ ಅವರ ಡೆಪೋಸಿಷನ್ ಅಲ್ಲಿ ತೋರಿಸಿದೆ ಚಾರಿಟಬಲ್ ಟ್ರಸ್ಟ್ ಅಂತ ಒಪ್ಪಿದ್ರು. That, my lord, it is a public trust is admitted by them. If it is so, that's why, my lord, I gave you a lot, my lord, two judgments of the Honorable Supreme Court, where the Honorable Supreme Court has categorically held there is a parents patria jurisdiction vested in the court to protect the interests of, my lord, charitable institutions. And what is it that they are saying? I will give you, my lord, for 110 rooms. ನಿಮಗೆ ಆ ಬ್ಯಾಂಕ್ವೆಟ್ ಹಾಲು, ಕಲ್ಯಾಣ ಮಂಟಪ ಎಲ್ಲ ಇದೆ, 50,000 ತಿಂಗಳು ಕೊಡ್ತೀವಿ ನಾವು. Look at the conduct. A person who has invested 500 crores in a hospital, he admits that, I pointed out on the last occasion. He has, my lord, invested in, my lord, 25 acres of land. He sets up a medical college. In fact, I am told, my lord, it's not on record, he has set up another hotel. ಇಷ್ಟೆಲ್ಲ ಇದ್ದುನು ಅದು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಸೊ, my lord, it's not in the evidence. Therefore, my lord,
Was there any negotiation for enhanced rent?
ಏನು ಬಂದಿಲ್ಲ ಅವರು, ಬರ್ಲಿಲ್ಲ. ನಾವು ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ವಿ. ಅವರು ಇಲ್ಲ, ನಾವು 50,000, ಅವ್ರ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 50,000 ಕೊಡ್ತೀವಿ ಪರ್ ಮಂತ್. ಲುಕ್ ಎಟ್ ದ ಕಾಂಡಕ್ಟ್. ಅಲ್ಟಿಮೇಟ್ಲಿ, my lord, it is this. We require it because, my lord, ನಾವು ಈ ಇದರಲ್ಲಿ ರೂಮ್ಸ್ ಅಲ್ಲಿ old people, my lord, can always be accommodated. We run, my lord, an orphanage, an old age home. Where do these people go?
She was referring to some of your pleading or deposition that you have said that you want to generate income from this for running
My
your
lord,
trust.
either that or, my lord, we will use it personally for ourselves. Whatever it is, my lord, our prerogative. It is our property. That, my lord, it is our property is undisputed.
No, it was submitted that after all you have said like that.
You can
you
as well.
offered it after us, I mean, on a reasonable rent.
My lord, my submission to your lordship is simple as this. One, what I want to do with my property, my lord, after all, property right under Article 300A, your lordships are aware. It's a property right. It is not only a constitutional right, but it's a human right, is what the Supreme Court has time and again held. When that is so, can, my lord, a person who, my lord, has enjoyed this property for 50 years at 800 rupees a month, my lord, please look at this person, 800 rupees a month.
Yes, or 61.
50,
He came
50
in
years.
position 84 onwards. ಈಗ ಆಯ್ತಲ್ಲ ಮತ್ತೆ.
ಆಮೇಲೆ ಕೋರ್ಟಿಗೆ ಬಂದ್ಮೇಲೆ ನಾನು 2,000 ರೂಪಾಯಿ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. Please look at, my lord, the conduct.
2,000, they are paying 2,000.
ಹೌದು.
Why?
2,000?
ಆಮೇಲೆ ನಾವು, my lord, we in the trial court, my lord, in the trial court, my lord, ask them how much were they paying till the 2,000 rupees.
No, my lords, we have paid in the trial court when the matter was pending, we paid 2 crores. Here we 2 crores.
Sorry, it is not 2 crores. Please look at, your own conduct. Show me where you have paid 2 crores. 2 crores after the decree.
No, that's what the matter of stay was
After the
granted.
decree, my lord, deposited 2 crores. Why? Because 50,000, my lord, a day for, my lord, how many years? It will aggregate to, my lord, more than 20.
2,000 they paid. On what basis they paid 2,000?
Lord,
Where?
what happened was that 812. ಆಮೇಲೆ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್, my lord, 50,000 ಅಂತ ಹೇಳಿದ್ಮೇಲೆ per day ಅಂತ ಹೇಳಿದ್ಮೇಲೆ we, my lord, sought to execute the decree. ಆ ಟೈಮಲ್ಲಿ they said, they wanted a stay. At that time, the court said, all that you deposit 2 crores. My lord,
2
please look at
crores,
it.
that is one thing. 2,000 per month, that's what is agreed.
2,000 ಅಲ್ಲ, 812. Sorry, I stand corrected. 812, 800, how much is that?
820 contemplated in the term list.
Ah, that's right.
Yes.
Ashte. Then, my lord, the substantial improvement madidini, of course, my learned friend has led evidence, not one scrap of paper, except, my lord, the hotel which he purchases, running hotel. I can understand, my lord, if it is a bare shell he has purchased. No, it was a running hotel. Sale deed alli tavu. If your lordships look at, my lord, the sale deed itself, which my lords get, and, my lord, the 370 of paper book, volume 1.
We asked this question to her. Have you produced any documentary evidence to prove that?
ಏನು ಇಲ್ಲ. And, my lords are aware. I didn't want to, my lord, unnecessarily burden your lordships with authorities.
Yes.
Section 103 of the Evidence Act. Person, my lord, who's in the special knowledge of it, he must, my lord, produce all that. I need not even ask for it. AR 1968, Supreme Court 1413. Your lordships are aware, my lord. ಇದು ನಾನು ಹೇಳದ್ನಲ್ಲ, ತಮ್ಮ ಹತ್ರ ದಿವಸ ಬೆಳಿಗ್ಗೆದ್ರೆ ನಾವು ಬೇರೆಯವರೆಲ್ಲ ಸೈಟ್ ಮಾಡ್ತಾನೆ ಇರ್ತಾರೆ. Always, my lord, burden, my lord, irrespective of the burden, person in the best evidence, my lord, in possession must produce it. He is the person, my lord, who can show how much of profit he is earning. ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? Nothing. Why? Because he wants to suppress everything.
Yes.
And, my lord, deposition, page 201, 203, 204, ಅದನ್ನೆಲ್ಲ ನಾನು ಹೇಳಿದ್ದೀನಿ. My lord, I'll be repeating myself. Therefore, my lord, I don't want to, because we have taken, my lord, more than what is needed actually. ನಾವಿಬ್ಬರು ಸೇರ್ಕೊಂಡು ಇದಕ್ಕೆ ಇಷ್ಟೊಂದು ಟೈಮ್ ಬೇಕಾಗಿಲ್ಲ. ನಮಗ್ ಬಿಟ್ರೆ, I remember, my lord, Justice Balakrishna, when he retired as the Chief Justice of India, ಯಾಕೆ ಕೋರ್ಟಲ್ಲಿ ಎಷ್ಟು ಡಿಲೇ? Because senior counsel will keep on arguing till the cows come home. ಅಂದ್ರೆ cows come home only in the late in the evening. ಹಾಗೆ ಇದು ಹಾಗಾಗಿ my submission is.
Now that is not only for senior counsel, for all counsel. Regulation, yes.
Therefore, my lord, my submission is, and the judgments
See,
that.
in our courts every day, either of you keep saying that our parties are 80 years old, 90 years old. Just before a short time while back, we said because cases get aged and parties get aged, judges also get aged.
Correct.
Because of only lawyers will be young. Yes.
And all the judgments, my lord, which is cited with regard to mean profit, says, what is the profit that he is capable of making? That is what, my lord, I have indicated, my lord, in my list of dates based on his own evidence. I'm extremely grateful, Lord, for the abundant patience and the indulgence that your lordships have shown.
Yes, sir.
Alas, in fact, the matter was referred to, sir is aware, to Justice Venugopal Gowda to bring down a settlement between the parties, because there was no counter offer that has come from them. So that also.
Now you do one thing, you furnish these authorities
Yes.
properly and one
Yes.
compilation.
Yes.
No further time for that. Respondent, they are not going to change. ನಾವು ಹೇಳಿದ್ರು ಮಾಡೋದಿಲ್ಲ ಅವಲ್ಲ, ಅದು ಹಾಗೆ ಇರ್ಲಿ, ನಾವೇ ಬೇಕಾಗಿದ್ದು ದುಡ್ಡು ಕೊಡ್ತೀವಿ.
ಅದರಲ್ಲಿ ಕೆಲವು
You are getting what we said.
I understood, ma'am.
You understood. Yeah. You only understand or you can speak a little.
She is no more Karnataka, my lord. She has been here for the last, I think, more than 10 years.
20 years.
20 years, my lord. So.
But they do not even whisper a single Kannada word now.
My lords, I speak, reading is little difficult, my lords, it takes time to read.
Hard for the, we'll do one thing, use both of you, I mean, that compilation, you change it. We list it for further hearing, not for your arguments.
My lord,
We'll go through that.
What has happened is,
Synopsis and
my
other.
lord, my compilation of judgments, some of them are, my lord, as a, in anticipation what she has argued. I did not want, if necessary, I'll point out. ಹಾಗಾಗಿ ಅದು.
You can just, your compilation, we had said that you minimize that, only one judgment, no repetition on the same point.
ಆಯ್ತು.
Last time.
If there is more than one, my lord, I'll take out.
Because one important prime.
All right, I
judgment or
understand.
latest
ಇಲ್ಲ, ಆ
judgment,
ಥರದ್ದು ಯಾವುದು ಇಲ್ಲ.
larger bench judgment, whatever it is there on the same point, there will not be any repetition.
Correct. My lord,
Same
it is
point.
not there. In
Okay.
fact.
And she has given many compilation for her
I love
written
4.
synopsis. Written synopsis, only 4.
I'll give one, my lords, I'll just take it down.
ಆಯ್ತು. ಹಾಗೆ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ. ಆಯ್ತು.
ಯಾವತ್ತು ಮಿಸ್ ಮಾಡೋಣ? Monday. And then we'll list it on Monday, but you have to give before that.
Please, ma'am.
For February, hard work Friday.
All right.
Sorry?
Take it out and-
For February, list on Monday. So if you give it to us by Friday, because Friday is also holiday. Thursday I have to give.
Thursday,
So we
Friday is a
can
holiday.
organize it by Monday, if possible, we'll dictate here
Please.
also. Yes. ಕೊಟ್ಟಿರಿ ಅವ್ರದ್ದೆಲ್ಲ ಆ ಥರ synopsis she has given in several pieces.
Yes, sir, I'll just.
Yes, next. ಅವ್ರದ್ದು ಇನ್ನೊಬ್ರದ್ದು ಯಾರ್ದೋ ಪಾಠ ಆಗಿತ್ತು. ಒಂದ್ ಯಾವ್ದು you were not there, we wanted to pass orders. ಅಲ್ಲಿ ಏನು application is filed by the appellants, not by the applicants themselves.
Not the applicant, but.
Now notice is not issued to them.
But they are ready with the wakalat because they are wife and children of the appellants and the respondents. It is the partition.
They themselves could have filed an application. Now again.
They should have, yes, Milord.
Again tomorrow another issue, with so and so were impersonated, they filed the wakalat on the same day.
Illa. It's a suit for partition.
Suit for
between the brothers
partition
and-
ಅಲ್ಲಿ ಜಾಸ್ತಿ ಆಗೋದು, matrimonial case suit for partition.
ಹೌದು.
Yes.
Wakalat is also ready.
Why can't you only file an application to come
They
on
should.
record? This tomorrow, we have no difficulty, but
Well, see, your lordships may issue notice and post it tomorrow.
not necessary. Instead of that, we list it tomorrow, let them come and file an application.
One more application.
So that this application may be not pressed on the body, ಅದನ್ನ ಮಾಡ್ಕೋಬಹುದು.
ಅಥವಾ ಇವತ್ತು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ನಾಳೆ ವಕಾಲತ್ ಹಾಕಿಸ್ತೇವೆ. So that ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದು.
ಅದು ಒಂದು ಕಾಂಟ್ರವರ್ಸಿನೇ ಆಗುತ್ತೆ ಮತ್ತು ನೋಟಿಸೇ ಹೋಗಿರ್ಲಿಲ್ಲ ಇನ್ನು ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅಂತ. We understand, we appreciate that also because.
ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ಹಾಕ್ಸಿ ಅಂದ್ರೆ ಹಾಕಿಸ್ತೀನಿ ಸ್ವಾಮಿ.
She appears for undertake to appear ಅಂತ ಹೇಳ್ತೀವಿ. ಈಗ application was already there on record. So and so you undertake to appear for them. How many of you are appearing?
No, he appears in one appeal. I appear in another
No,
appeal.
for this impleading respondent, proposed respondents.
Proposed
ಎಷ್ಟಿದ್ದಾರೆ? 6 to 25. 6 to 25 undertake to appear. ಬರ್ಕೊಳ್ಳಿ, ಯಾವ್ದು? Serial number 58. Okay. Not only this impleading business, they file suit first. We were hearing Mr. Vasant Kumar, next case. They get the suit, disposed of about 20 years back after fighting it. Then they come up with another suit saying that these properties were not within our knowledge. This was partial partition. It was not permissible. ಇದೆಲ್ಲ ಹೇಳ್ಕೊಂಡು partition suits. ಇದಾಗಿತ್ತಲ್ಲ ಅದ್ರ ಮುಂದೆ. Application is there in all the cases.
In one matter.
Only
2020.
58.1 ಅಲ್ಲಿ ಮಾತ್ರ.
One ಅಲ್ಲಿ ಮಾತ್ರ.
2020.
Yes, because that is the appeal by the.
Shri so and so learned counsel ಅವ್ರ ಹೆಸರು ಬರೆಸ್ಕೊಳ್ಳಿ.
SVJ.
Undertakes to appear for proposed respondent 6 to 25. 6 to 25 is permitted to file the wakalat in the registry within
2 days.
Within 3 days. So you wanted to refer this to be referred to the mediation. Both counsel seek the reference of the matters to mediation.
All the three appeals.
All the matters we said.
Yes.
Therefore, all the above appeals are referred to Bangalore mediation, Karnataka mediation center. Bangalore change ಆಗಿದೆ. Karnataka mediation center, Bangalore. For mediation, parties are hereby directed to appear before the mediation center on
Monday, Milord.
9th. So and so. ನೀವು ವಕಾಲತ್ ಹಾಕಿದ ಮೇಲೆ ಮಾತ್ರ ಕಳಿಸ್ತಾರೆ ನಮ್ಮ ಆಫೀಸರ್, ಇಲ್ಲ ಅಂದ್ರೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೊಂಡು ಕೂತ್ಕೊಳ್ತಾರೆ. Without any further notice. ಎಷ್ಟು ಅವತ್ತು ಟೈಮ್ at 1:30 ಅಂತ ಹೇಳೋದು.
We will see to it.
At 11 AM.
ಇಲ್ಲ 1 o'clock.
1 PM. 1 PM. Date. 9. Without any further notice. Okay. Registry shall communicate this order and copies of the relevant records to the mediation center. List will fix a date for appearance.
Yes,
again
please.
here. List on
Maybe 13. We will report.
13.
13.
30 or 13?
Whether they are settled the
They
terms or.
almost settle the terms, but they need little push and pull. It will waste time of this honorable court.
13-9.
13.
One.
Bill number 40.
Grateful, my lords.
Suit is of which year? 2006.
Grateful.
2006 suit. ಆಯ್ತು books.
ತುಂಬಾ ಹಳೆದು. ಬರೀ ಬ್ರದರ್ ಸಿಸ್ಟರ್ಸ್ ಹೊಡೆದಾಡ್ತದೆ.
Second time.
Great number 40, Vasant V. Naik, Bayareddy.
This I appear for the appellant.
Serial number 14.
For respondent.
ಇದೆಲ್ಲ ಲಿಸ್ಟ್ ಹಿಂದೆ ಮುಂದೆ. ಇದು ರಿಜೆಕ್ಷನ್ ಆಫ್ ಸೆಕ್ಷನ್ ಎಲ್ಲ ಮಾಡ್ತಾರೆ.
As I pointed out earlier, my lord, there are 3 decisions of the Supreme Court which say matters have to be.
You have already completed your side.
Yes.
He has to argue. Yes. Yes. Yes.
Yes, yes, but I am submitting synopsis of the arguments.
ತಗೊಳ್ಳಿ. Application. Yes. Synopsis of what?
The documents.
Documents, counter document. First question.
Yes.
Documents, yeah.
Yes.
Yes. Yes, yes, the millennial friend, on part 1, rule 27, production of the sale deed. With respect to the fee schedule property. In this statute, it is a concocted document. I have filed detail of this today.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ
ಕಾಪಿ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಕಾಪಿ ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ?
ಆಯ್ತು, ನಾವು ರೆಡಿ ಮಾಡ್ಕೋಬೇಕಲ್ಲ. ಕಾಪಿ ಕೊಟ್ಟೆ
ಅದರಲ್ಲೇ ಇದೆ.
New copy. Yes, that's right. Regarding B schedule property is concerned, we have produced those documents in RF, in WP, that is the copies are produced here. My learned relies on the alleged sale deed said to be executed in the name of RF Sami. I have produced his copy. ಇಲ್ಲ ಪದ ಹೇಳಿ ಹೇಳಿ ಕಾಪಿ ಕೊಡಬೇಕಾಗಿದಾ? Respect. I learned had produced sale deed dated said to be in the name of. I produced the translated copy. It is at page number 11. It is in Tamil. Certified the typed copy is at page 70. This document refers to stands in the name of T. Vedachalam, son of Thirumal residing so and so and so. It is followed by the same document, same number, same registration. Then after, I have also produced the encumbrance certificate showing the details of properties which refer to that. In this, the first item of property is.
ಕೊಟ್ಟಿದ್ದಲ್ಲ
Huh?
ಈಗ ಕೊಟ್ಟಿದ್ದಲ್ಲ
ಅವ್ರು ಕೊಟ್ಟಿರೋದು. Yes.
ಇಲ್ವಾ?
ನೀವು ಕೊಟ್ಟಿದ್ರಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. But he has produced.
ಸರಿ.
ಇದು ನೋಡಿ.
How do you say that you have produced?
ಇಲ್ಲಿ ಕೊಡ್ತೀರ ಇದನ್ನು ಕೊಡು ಇನ್ನೊಂದು ಸಾರಿ.
ಏನದು? What are you giving? Yes, what is that you are giving?
I am producing document My landlord has produced the
How
document.
can you produce in this manner here? See, if at all you want to produce document, there is a procedure for that.
It's great, sir.
No
These-
matter is set
Allah,
out.
these documents were produced in WP 33609.
Wherever it might have, you might have, see, the question only is whether the whether the trial court without trial could have dismissed the,
I come to that
suit
point.
under order,
Seven rule
holding that the suit is hit by the principle of res judicata.
And for that, I come
Are
to
you holding a trial here? Yes.
the great aspect regarding the document produced by my landlord friend after fee schedule property. I have produced, said the original in FDP pending.
Right.
FDP pending. I have, the copy was served on me. I have produced the same copy. It property which I have said, registered in the name of one.
Already produced trial court. All matter of evidence. And I will,
ಅದಾಗಿದೆ ಅಲ್ರಿ ನೀವು ಮತ್ತೆ ನೀವು ಕೊಟ್ಟಿಲ್ವಾ ಈಗ ಆರ್ಡರ್ 41/27?
I have filed in the.
Correct.
after
For that, I have filed my counter, my lord.
counter.
Where I have stated, he has produced Tamil version and also certificate.
They have produced the translation also.
Translation also, I have also produced translation.
You can
There,
show from that only. They have produced the translation. You can show from that.
I have produced,
Again,
I have filed objection by way of counter affidavit with the application filed by the appellant to show that the shaded said to be in the name of, that is a concocted document. There is the not relevant to this. Not only that, I have obtained certificate from the substitutions of the Pondicherry government that the document they have obtained is Murthy, Tirumurthy, after getting original certificate copy to Dr. State from this office, is request significant criminal action against the offender in respect of the
where
property.
are you reading? Which page number?
It is page number 29.
Page number 29 of your, no, you
Now,
said.
today I have produced.
You said along with your counter, you have filed the original, translated copy of the sale. That we are seeing.
Last document, my lord.
ಯಾವ್ದು the last document of page number ಏನು? What is it?
29.
ಅಲ್ಲಿ ಇದು ಕೊಟ್ಟಿದ್ದಾರೆ. ಯಾವ್ದು ಅದು ಎದ್ರಲ್ಲಿ ಹಾಕಿರೋದು ಅದು?
Yeah, put your.
ಮತ್ತ್ ಹಾಕಿದ್ದಲ್ಲ. ಮತ್ತ್ ಹಾಕಿದ್ದಲ್ಲ. ಹಾಗಲ್ಲ. Is it in filed in any proceedings? Page number 23. In 29 is some order copy, order 6 rule 17. ಅದ್ರ ಮೇಲೆ order. Counter affidavit. This is the counter affidavit. ಇನ್ನೊಂದು ಯಾವ್ದು counter affidavit? ಹಾ, ಇದು ಅವ್ರದ್ದೇ respondent of the counter affidavit. Early hearing application.
Sorry, madam, there is another copy.
ಇದು ಅವ್ರು ಹಾಕಿದ್ದು ಆರ್ಡರ್ 41/27 appellant ಹಾಕಿದ್ದ.
Sorry.
No, we don't like this kind of unorganized things. ಇದನ್ನು ಕೊಟ್ಟು
I will come to the
too unorganized way of making the
with
presentation.
great respect. I will submit
Appellant ಕೊಟ್ಟಿದ್ದಾರೆ.
the facts of the case. Synopsis.
Synopsis ಏನಾರ ಇದ್ರೆ ಕೊಡಿ, ತಗೊಳ್ತೀವಿ ಅಷ್ಟೇ. ಯಾವ್ದು synopsis? ನೋಡಿ, ಇವನ್ ತಾಲೂಕಾ ಪ್ಲೇಸ್ ನಲ್ಲಿ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲೂ ಈ ರೀತಿ ಕೇಸ್ ಕಂಡಕ್ಟ್ ಮಾಡೋದಿಲ್ಲ. ವಿ ಆರ್ ಸಾರಿ ಟು ಸೇ ದಿಸ್.
Sorry, madam.
And we are brought down to that level. ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ನಲ್ಲಿ ಕೇಸ್ ಕಂಡಕ್ಟ್ ಮಾಡ್ದಂಗ ಆಗುತ್ತೆ.
Sorry, madam.
Both of you, even for you, what was the need for filing this order 41/27?
The reason is this, not the court will have.
Now you are
got a
saying.
finding that no evidence is produced.
You are saying that this could not have been done in view of the Supreme Court.
Yes,
And
and-
where was the need for order
Yes,
41/27?
the reason is not the findings of the
Right, you say that there could not be any trial at that stage.
Yes.
Then where is the need of producing those
That
documents?
is the mistake which the court has committed.
Now you want to add to that mistake
No, no, it's
by
not that,
filing
it's
another
not-
application.
I would like to point out.
Yes.
that
With great respect, I'll come to, this is a matter from the year 1990.
We understand.
I show the fact, the judgment referred to my letter will not apply to this fact and
That,
circumstance. The grass-
that's okay, then ತೋರ್ಸಿ.
Yes, with great respect, the appellant concocted a will, certificate to my father, Arokusami. She filed P&SA 117 of 90. That petition was dismissed. She has filed miscellaneous 99 of 1995. It was dismissed as per Annex R. Then against that, she has again filed P&SA 191 of 2001. That one was also dismissed.
All these documents would
It
not
is-
have been.
Don't interfere, sir.
ನಿಮ್ದು ಆಗಿದೆ ಅಲ್ವಾ ನಿಮ್ದು ಮಾಡುವಾಗ
Please,
He cannot be looked,
yes,
cannot be
you
looked
do.
into.
Please quote, sir.
At the
For
stage
us-
of.
The fraud,
Yes, please.
mean, administer the court proceedings, not for you. Please take your seat.
No, I'm. It cannot be looked into.
there is synopsis argument with great respect.
Hmm.
In P&SA, she has filed her affidavit evidence that the petition was all dismissed. Against that, at this stage, now I come to all the respondents, they have filed OS 7258 of 1996. It is at page number 63, my lord. There, the defendant is the sole, the appellant is the sole defendant. She has contended that the Pondicherry properties were allotted to the share of all the children of the state Araswami. The AC, the Bangalore property was allotted to her share. That suit was decreed in favor of the plaintiff in that suit. The honorable court held in that she has stated there are number of, the trial court, the number of opportunities given to the Rita, she is a whole different in that case. There, the honorable court observed in judgment at page 86, ವಿವಾದಾಂಶ 7, 8, 9, 10, 11 ಮತ್ತು 12 ಈ ವಿವಾದಾಂಶಗಳನ್ನು ಸರಿ ಸಾಬೀತುಪಡಿಸುವ ಜವಾಬ್ದಾರಿ ಪ್ರತಿವಾದಿಯಾಗಿದ್ದು ಪ್ರತಿವಾದಿಯು PW ಅವರನ್ನು ಪಾಠ ಸವಾಲ ಮಾಡಿರುವ ಆಕೆ ಸಹ ಯಾವುದೇ ಸಾಕು ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಹಾಜರುಪಡಿಸಿದೆ. ಹೀಗಾಗಿ ಆ ವಿವಾದಾಂಶಗಳನ್ನು ನಕಾರಾತ್ಮಕ ಅಕಾರ್ಡಿಂಗ್ಲಿ suit in respect to the property at Bangalore property was decreed in our favor, giving 1/6 share each to the appellant and all the children. Against that judgment, the appellant has filed RFA 158 of 1958, page number 113, my lord. There, the honorable this court held as at page 113, it is not the case of the appellant that her mother and 3 sisters and 2 brothers were placed well in life, and therefore her father declined to bequeath his property in her favor. Be that as it may be, when the original will has not been seen the light of the day, it is difficult to accept the arguments of the appellant. Therefore, we answer point number A and B against the appellant. After dismissal of this, the P&S 191 of 91 was dismissed by the trial court. After that, they have filed this comprehensive suit. 80 to 13 of 15. There, you can kindly see the schedule. B schedule is all the piece and parcel of the house and agricultural property situated in survey number 48 with subject matter 1, 2B, 3, 6, 7A, 7A, 8, 9A, 1, 10A, and 12A2. But they have produced a document. It is not subject, nowhere related to the B schedule property. What they have produced document, nowhere related to these B schedule property referred to in the schedule B. their property, survey the party, it's, so 1, 2B, 3, 6, 7A, 7C, 8, 9, A1, 10A, and 11, 12, 2. With great respect, no way, yes, this document is subject to some other survey number says it belongs to my father, Arokeswamy. I have in the writ petition, the respondents, the errors of the respondent 5, produced this document, obtain the documents from the sub-registrar and say, the document they have obtained is the concocted document. It is a case of further criminal action has to be taken against the person who has purchased the property. Regarding C-schedule property, my lord, that property was allotted to the share of Maria Anthony, who is husband of the fourth respondent here, who is prisoner 4. In the FDP. I have produced to show the said property is allotted to the share of. I have agreed the sale date dated. At 181, my lord. This clearly stated this property was allotted to Maurice Anthony, husband of Grace Catherine, by the Pondicherry Cooperative House Building Society Ltd, post box number 56, flat number so and so, to Maurice Anthony, site number 4 as a member of the society, my lord. If that is so, they can't claim that C-schedule property belongs to the Arokeswamy. No document is produced to show that C-schedule property was allotted, belongs to my father, Arokeswamy. A document produced by my learned friend is not a genuine document. In fact, I have produced the document. Only site was given to me, but in the schedule, they say regarding B-schedule property, C-schedule property, great suspect, C-schedule property, all the piece and parcel of the house and agricultural property, house number 4, in survey number so and so, but this house number 4 is a one site allotted to Maurice Anthony. I have produced the sale deed to this article.
Yes.
I have also produced the marriage certificate of fourth respondent herein with Maurice Anthony. That marriage has taken place 1 year after the allotment of site in favor of Maurice Anthony. I produced the marriage certificate also to show that Maurice Anthony is individual property. At no time this property belongs to my father, yet Arokeswamy. I produced the document also before his lordship. Then, after dismissal of the suit in 8213 of 15 by the trial court, within their file, R617 application before the in PNA 197 of 2012. The Honorable Court has dismissed the said application as it by res judicata. Against that, they have filed the writ petition before the Honorable High Court. In the writ petition, the Honorable Court have produced document to show the Honorable Court, it was disputed the number of times. Finally, the Honorable Court held in WP 33609 of 2016, as I have copy observed as great suspect. At para page 6, orders, it is however made clear that the order will not come in the way of the trial court proceeding further and passing of appropriate order in respect of existing age scheduled property in the final degree proceeding. Since the litigation between the parties commenced in the year 1995, the trial court is directed to dispose of the proceedings in WP, FTP 192 on or before 21/12/2023. In spite of the direction by the given opposite given to them to lead evidence in respect of B and schedule product, they have not produced, they have not given any evidence in respect of B and C schedule product before the trial court, my lord. After hearing, then, after hearing sufficient time, the trial got dismissed or set up by order dated 22nd August 2023. There is considered order by the, I have produced that document to show. Their observation by the trial court. The commission has filed a detailed report in the respondent who is advantageous position, collect the rent in intending to drag on the proceeding. There is no merit in the matter to include the B and scheduled property. Hence, I answer the point raised to consider in the negative and proceed to pass the following. This is followed by my learned friend. He has filed WP 27/569 of 2023 and the file of this Honorable. The Honorable High Court has held the present petition as well as the application filed by the petitioner under order 6/17 CPC are disposed of as withdrawn, desiring liberty in favor of the petitioner to urge all contention in RFA is 3/30/2016, which is pending before this court in relation to B and C scheduled property. It is made clear that the present petitioner as well as the respondent would be entitled to put forth all their contents in relation to B and C scheduled properties in pending RFA 330 without prejudice to the observations findings ordered by the academic court. In all rival contention between the parties in B and scheduled properties are kept open, no opinion expressed on the merits. It is needless to state that FDP 197 is still pending in relation to scheduled property. The trial court shall dispose of said a final degree proceeding without being influenced by the findings and as well as recorded by the impugned order. So, with great respect, in spite of the orders in WP 33, 609 of petition, there was extension of time. As the time is over 21/12/2020, the further extension of time granted for 6 months. In spite of that, the appellant here, therein, they are not come forward to give evidence, producing this document to show a title for the scheduled property. Now, at this stage, they come forward here to file the false and frivolous application regarding B scheduled property. They are not all belong to my father. In fact, B scheduled property belong to nothing to do with the schedule rate in the suit 80-30. ಅದ್ರಲ್ಲಿ ಇರುವುದೇ ಶೆಡ್ಯೂಲ್ ಬೇರೆ, ಇವಾಗ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಶೆಡ್ಯೂಲ್ ಬೇರೆ. Can see. Compare the schedule in the sale deed produced by them and the schedule of B schedule in 80-30. It is in which case the seek amendment of the amendment of B schedule property. It is no way concerned with the 80-30 and 250. With respect.
That's all. Yes.
Tell me.
That's all.
You know this. Later on, after the orders of the trial court, there is public auction of the A schedule property. Once it was because of the wrong number, it was not to affect the public auction. But second time, because of declaration of Sri Ramanavami, public auction was cancelled. Then finally on 17/4/2024, public auction was conducted for 1,96 lakhs. In fact, that purchase highest bidder was the appellant's daughter. Thus, he was given one and a half time. So far, she has deposited the 1/4 amount also. So my submission is, regarding the B and C scheduled property, there was sufficient opportunity given to them in FDP 190 as per the orders of the honor court.
What is the stage of that case? What is the stage of FDP case?
FD 197, they have published, as per the orders of the,
No,
there is-
right, they have not deposited the amount. What happened thereafter?
it is posted to 59 for depositing the amount by the bidder. That is the stage. In the great section, B and C schedule, B schedule property is concerned, you can kindly see the schedule in B, schedule B in the OHN. It is different from the document produced by Mellon friend. Nothing to do with its property. I have produced the encumbrance certificate to show the property number.
But that was not the ground it says. Right, is it?
The great suspect,
Right.
there is no ground
Produced
to invoke order 7 to 11 CPC.
schedule B ground.
Another thing is, my lord, in the spite of litigation, mother died, one of her brother died, one sister died, only 2 are surviving of LR in spite of obtained decree in 1996. They could not able to enjoy the fruits of the decree, my lord. You have not compared the,
In your affidavit, files in support of this 11 application, where have you stated that the property, B schedule property and the documents produced, they do not match with each other?
I have,
You have said item number 2 and 3.
I
are
have filed
the
counter affidavit.
Father,
Today I have filed counter affidavit along with documents with great respect, which were produced in the,
produced documents.
which were produced in WP, 33. All those documents are there available because the second, the 6th and 7th, they have retired from the case.
What were the documents produced by you along with the plaint?
Along with the plaint, no documents were produced along with the
Sir,
plaint.
Along with the plaint, there should be some documents, no? We have not produced, I mean, in your paper book, you have not filed, what
Yes.
were the documents produced along with the plaint? Karnataka Land Revenue Authority.
Only the judgments and decree, my lord, in
ಅಲ್ಲ
the
ರೀ,
previous suit, that's all.
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದಾಗ
Yes.
what were the documents produced?
Yes. Only my lord, the judgment and decree in the earlier suit and appeal. Only 2 judgments.
How you can produce that? Whenever you come to the court,
No,
you
only
have to
2
produce
judgments
the
are produced, my lord.
documents relating to the suit schedule properties.
No, there is no argument regarding the suit schedule property.
They on provision. B and C schedule properties are the non-agricultural property.
No, my lord, they are not non-agriculture. Well, subsequently, they have been converted into plots and plots are standing in the names of different people.
Great respect.
Mr. R.O.K. Same and then subsequently.
ಇಲ್ಲಿ ನೋಡಿ, all that piece and parcel of house and agricultural property situated in survey number 48
Yes.
with sub number so and so. ಅಂತ
At the
ಹೇಳಿದೆ.
time when it was purchased,
Schedule C ಅಲ್ಲಿ all piece and parcel of the house and agricultural property bearing house number
Yes.
4 etc. ಅಂತ ಹೇಳಿ.
yes. Now you lordship may kindly, these 80 of agricultural land subsequently.
Okay, just answer our question. What is the document you have produced along with the plaint?
Along with the plaint, only 2 documents. One is the judgment and decree in the other suit and
Give
the
us the copy of that list of documents you have produced.
list of documents I don't have, but in the affidavit, he says, my lord, A and B to the, are the
Plaint
copies.
ಜೊತೆಗೆ ಏನ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ಇರುತ್ತಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಪ್ಲೇಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ ಹೇಗಿತ್ತು ಪ್ಲೇಂಟ್ ಅದ್ರ ಜೊತೆ ಗುಡ್ ಸೆಲ್ಫ್ ಅದನ್ನು
Here, a lot is.
Section 130. The plaintiff and applicant in this suit and application non-security duty which this and next to the plaintiff any entry in the record of the application for notice. If the plaintiff or the applicant in this suit for any cause which the court deems sufficient, we shall produce the certificate listed within a reasonable time to be fixed by the court, and if the certificate copy is not so alleged, or produce the plaint or application shall be rejected. But rejection thereof shall not affect so force to prove the presentation of the fresh plaint. Within the Yes, Bill, now we are seeing from the records, what is that you have produced?
No, what is,
can-
judgment of,
I
just a minute, let me complete. Judgment of the
while observing
trial court
the
Lord,
rejection,
in the other suit
You
and
said you have
RFA,
produced.
only two.
Yeah, the coverage
Or hearing.
no documents are produced by letter friend. I conducted case in their trial court. The honor court held in final order 80 to 30 and 15 at page 193. I have produced today. I have produced. There is. It is. I have filed the counter along with the list of documents at page 193, my lord. Page 193.
And according to the exception is taken into but even if it is the same property that has produced money, can be rejected. Section 132. Yes, but why did you include this A schedule property also in the suit? Because
Yes.
that had attained finality.
No,
That's
no,
it.
the reason is this, my lord. I am seeking a declaration, a prayer A may kindly be seen. Prayer A of the plaint for a declaration that the judgment and decree dated 9/11/2005, notice number 7258 of 1996, before the honorable being a partial decree for partition as being null and void.
How it becomes null and void?
Because
You can file any number of partition suits if there is any property are left out,
Yes.
but you have to satisfy that there was no intentional omission. Even as a defendant, you could have filed,
Yes.
you
No,
could
you-
have included those properties in your
the
written
reason
statement.
why this declaration is sought for, not is by virtue of this judgment of this honorable court, which I have produced, my lord. Lord, you may kindly see, my lord, the judgment in 1994, 4 ACC. 1994, 4 ACC, page 294,
Page?
page 294.
ಇದಕ್ಕೆ page number ಹಾಕಿಲ್ವಾ ನೀವು?
No, the internal page 2, the
ಇದಕ್ಕೆ page
fourth judgment. I have not given number, my lord. Fourth judgment, my lord.
ಅದಕ್ಕೆ ಹೇಳಿದ್ವಿ ನಾವು ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ನಲ್ಲಿ ಕೊಡೋದಕ್ಕಿಂತ ಕೆಟ್ಟದಾಗ ಕೊಡ್ತೀರಾ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತ ಹೇಳಿ. You should give the
Judgment,
proper
page numbers are not going.
index ಕೊಡ್ಬೇಕು, page number ಕೊಡ್ಬೇಕು, other side
Page
serve
numbers are not.
ಮಾಡ್ಬೇಕು.
That is the fourth judgment, my lord. Third judgment, fourth judgment, 1994, 4
Third or fourth ಅದು ನಿಮಗೆ ಗ್ಯಾರಂಟಿ ಇಲ್ಲ.
Fourth judgment, 1994, 4 ACC 294.
Fourth ಅಂತ ಹೇಳ್ತಾರೆ. 2020, 2008. What is said here?
Yes, ma'am. Head note B, ma'am. Partition, suit for partial partition when all the joint family property is not made the subject matter of the suit, nor the co-sharers.
Right, suit is not maintainable.
Not, suit is not, therefore, my lord, therefore, my
If once one decree attains finality, again you can seek declaration about that.
Declaration that the judgment and decree is void on the ground that the suit was for partial, this thing, partition. On the ground that the earlier suit was for partial partition, therefore I am seeking a declaration that a scheduled property judgment and decree be set aside, and all three properties should be brought to partition again.
What were the facts of that case?
Yeah.
What were the facts of that case?
No, here not a suit for a declaration was filed, which was later on converted into a suit for partition, and that has been set aside by the Supreme Court. Para 16.
Amendment application.
To hold that the relief of declaration and injunction are rather reliefs and smaller relief for partition could be granted is incorrect. Even otherwise, a suit for partial partition in the absence of inclusion of other joint family properties and the impediment of other co-sharers was not warranted in law. Thus, we find no difficulty in allowing these appeals and are accordingly allowed. This is followed by another judgment of Roan High Court, not where your lordship may take the fifth judgment, Lord. That was RFA number 1410 of 2017. Of this honorable court, it has remanded the matter for reconsideration by the trial court. Head note B, the next judgment, Lord, that is in the case of RFA 1410 of 2017.
Declaration, injunction, partition and verify ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ultimately that is incorrect. In addition to that, the other parts, other family members, other properties, this has no application at all. This property is
Even para 10 may kindly be seen, my lord. Para 10 of the judgment. Your lordship may also see para 10 of that judgment. It is, then my lord, the next judgment of this honorable court in RFA 1410. RFA 1410 2017.
Yes.
Next judgment, my lord. Head note C, my lord.
Yes.
Head note C. In a suit for partition, when the trial court comes to the conclusion that the court, the plaintiff has omitted certain properties which could have been specifically mentioned in the written statement, it ought to have.
Marital barodil.
Alla,
First thing,
it
now
has
you
to
are
be-
saying you have not produced any record before the trial court except this judgment and decree.
Yes.
Now, you have mentioned the properties as agricultural lands.
Yes.
Section 132 of the Land Revenue Act, 132(2) says if you have not produced any record, then the plaint has to be rejected.
No, that is not
Not know why
correct.
the trial court has not done that.
No, that is not correct, my lord. The reason is this, my lord.
Right, why did, see, whenever you file a suit, you have to produce the records relating to the
no,
property.
see, how
Now
did-
you only are admitting that you have not
Yes,
produced.
my lord, the documents were mentioned and they have said it is concocted document. How did they?
We are not asking about that at all. Section 132 of the Karnataka Land Revenue Act
No,
makes
la-
it mandatory to produce the
No,
suit
it is not.
documents records.
132 does not come into play at all because it is not a land revenue matter.
You have not
It is-
land revenue, in a suit, read the law.
Yes,
and
no,
then
no,
only
that is,
submit.
no, section, no, that land revenue act does not come into, I will point out, no, the land revenue act does not come into.
For plaint, you have said it is an agricultural land, B and C schedule properties.
No.
Read your plaint schedule.
No, your lordship may
And
kindly
read section 132, it says that whenever
Your
the
lordship may kindly
plaintiff or
see,
the
no,
applicant
this, no, the.
how ಓದೋದನ್ನ ಕಲಿಬೇಕು ಮೊದಲು.
No, that is, no, that is,
Read
no,
132.
some other provision of law cannot be imported in civil
Read-
suit. No, madam. That is it, what I am trying to point out is, no, land revenue act provisions cannot be brought in here because what was.
ಯಾವ್ದಾದ್ರು ಓದಿದ್ದೀರಾ 132 ಏನಿದೆ
Yes,
ಅಂತ?
ma'am.
ಓದಿ ಹಾಗಾದ್ರೆ ಹೇಳಿ.
I want to point out something differently. Your lordship may kindly-
ಓದಿ ಪ್ಲೀಸ್ read first 132.
Yes, ma'am. I will point out not that.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಆ
No,
ಪುಸ್ತಕ
no.
ಇರ್ಲಿಲ್ಲ
When
ಅಂದ್ರೆ
the
ನಮ್ಗೆ
land
ಏನ್ರ
was purchased in 1980, it was agriculture. Later on, it was converted into sites.
But then why did
That
you
is-
mention it agricultural land in your
No,
plaint?
that was mentioned because of the sale deed. Sale deed said it is agricultural land.
ಗೊತ್ತಿಲ್ಲ
But
ನನಗೆ.
later on, you lordship may kindly see the.
You are also officer of the court. We
No,
are
I understand
we
that.
are asking you to read that provision.
I'll read that provision.
Without reading, you say that it is not applicable.
No, at the time when the sale deed was executed, it was agricultural land. Subsequently, it was converted into sites.
Heard further reserved. Yes.
No, your lordship, I'm not, my reply is not complete, Lord. I will complete my reply. My reply is not complete.
Yes, how much time you take?
Another 15-20 minutes at least.
15, already. We don't grant you 15-20 minutes. You have to complete within 5 minutes.
No, within 5 minutes, not possible.
We have argued at length. ಅವ್ರಿಗೆ ನಾವು ಅಷ್ಟು time ಕೊಡ್ಲಿಲ್ಲ actually.
I was
We had-
not permitted to argue the full, Lord, in full, Lord.
We, for him also we said, you cannot argue or we cannot sit here and try.
Yes.
We have to see whether the rejection of the plaint, exercising power under section 11 was correct.
Yes. Your lordship may
We have to
kindly.
see.
Yes,
Now,
ma'am.
in addition to that, we found one more thing.
Your lordship, I have pointed out the
And
provision
time
of
and
law.
again, Supreme Court has said you are showing only some judgments.
Yes.
We are also aware. Time and again, the Supreme Court has said that if the suit is on the reading of the plaint is found apparently vexatious, the litigation has to be nipped at the bud. Now.
That
you
does
still
not apply here because of the partition, my lord. My lord, there are many other suits which.
Cannot counsel.
those-
Now it is 456. We'll hear you up to 5. That's
Yes.
all.
Your lordship may kindly take, my lord, the annexure, my lord, which I have produced, which is the sale deed.
Which annexure you have produced?
B schedule property, IA number 2 of 24, my lord.
A number 2 of 24 here before this court.
Yes.
Yes. Yes. Page number?
Yes.
Page number?
Page number 13.
ಇದು both ತೋರಿಸಿದ್ರಲ್ಲ, why are you showing?
No, that is the reason, my lord, your lordship may, no, your lordship may kindly see the schedule.
You have not argued. ನಾವು ನಿಮ್ಮನ್ನ ಅವಾಗ ಕೇಳಿದ್ವಿ 50 ಕುಳಿ ಅಂದ್ರೆ ಏನು ಅಂತ ಕೇಳಿದ್ವಿ ಅವಾಗ. We did not
Yes,
ask.
no, what it says is, not agricultural land situated in survey number, re-survey number 17, measuring 50 kui about cents. It is about cents. Now this is shown as agricultural land, re-survey number 17. Therefore, I have mentioned it as agricultural land. Next document may kindly be seen. Survey settlement document number 2. You may kindly see document number 2. Subsequently, the survey settlement, all these have been converted into sites. The agricultural land which was there at that time has been converted into sites. And name of adjudication, second page, page 16.
Yes.
Page 16, top name, Adokyam Swami, son of Rayappa. And then 3275, and 3275. Adokyam Swami, son of Rayappa. These are all sites created out of in survey number 17. Revision survey number 17. Therefore, Lord, when it was initially purchased, it was agricultural land. Subsequently, it has been converted into sites. And that is why I have produced this certified copy of the survey settlement register. No, this is a register of survey settlement. And it shows not that the land which was agricultural was converted into sites. All those subsequently shows not Advocate Swami, son of Rayappa. Therefore, when the suit schedule initially showed that as agricultural land, that is because the sale deed was showed that it was agricultural land. Subsequently, it has been converted into sites, and this is what I have produced in document number 2. Settlement register for lands in towns. Heading itself.
All right.
Settlement register for lands in
How
towns.
many times you will read
Yes,
that?
yes. Now, therefore, Lord, when the land was earlier agricultural land, I have shown it as agricultural land, is in schedule, B schedule. Subsequently, it has been converted into sites. Therefore, Lord, there is nothing wrong with, the B schedule being mentioned as agricultural land. It was, as per the sale deed, this is agricultural land subsequently converted into sites. Therefore, B schedule is as it is. And therefore, and also C schedule. C schedule in the plain I said. C schedule may kindly be seen.
Yes, we have seen.
Yes. On that piece and parcel of house and agriculture property number 4 in survey number, because the sale deed gives the survey number situated at Kamrachale, measuring about 3,000 square feet. It's a plot of land allotted by a society. And when the document shows that it was agricultural land at that time of purchase. page 23 may kindly be seen.
Yes.
Page number 23 towards the bottom. In 223.26 square meters in extent within survey number 1698, 1/3, 3/3, 1697, 1/2, 1698. All these are shown as agricultural land. Plots in agricultural lands. And even the top, the schedule refer to plot number 4 in the site purchased by the society at so and so. In survey number 1698, 1/3, 3/3, 697, 1/2, 1698, BS 1/2, 1/3, 2/3, 1698, 2/2, 1698, 1/3. They're all shown as plots in agricultural lands. Therefore, the B and C scheduled properties are shown as agricultural land, plots in agricultural lands because of the title document. And before I complete, let me kindly take the judgment of this honorable court, RFA number 946. RFA number 946. Para 6, page 21, internal page 21. In other words, it is open to the co-owner to ask for separate enjoyment of his share of the property at any time he likes, and the right to partition the land cannot be refused so long as his interest in the land is not extinguished. The property is too well settled. And then further, it was pointed out that the right to bring a suit for partition, unlike other suits, not this is important, unlike other suits, is a continuing right incidental to the ownership of joint property, and a second suit is therefore not bad. Another second suit is not bad. Decision of the coordinate bench of this honorable court, para 6.
Yes.
In this case, not a suit was filed, which was dismissed for non-prosecution. Second suit was filed. It was held that way. Even if the first suit is decreed, the second suit in respect of other properties is maintainable. That's what I want to submit. You have to make any key para 6. It was pointed out that the right to bring a suit for partition, unlike other suits, is a continuing right incidental to the ownership of joint property, and a second suit is therefore not bad.
With respect, only one. It's a great suspect. In respect of the suit filed by him, 2015, he has not produced any document of title to prove that B and C scheduled property.
He asked, no. Kedidvailo now.
See,
clear. See, it is very clear. Earlier, property is included in the case only to bring it to the jurisdiction of this court. So that had attained finality. Adirlilla andre inned properties, they were from Tamil Nadu, adal bartirlilla jurisdiction.
I will take only 5 minutes. Sir. The plaintiff has produced uncorrected document being B scheduled property, and it is not certified copy, and it is without date.
Already we have heard is sufficient.
Ravishankar,
serial number
42.
Okay. Yes. Ravishankar
my lordship.
Call out agirlilva. Not possible today.
My lordship, not possible, my lordship. Today, my lordship, this honorable court directed the respondent to find out whether they have they have challenged the
Where are you submitting? Which case you are submitting?
6863, my lordship. MFA.
We are now in 42.
42, my lordship. Serial profile. List one for
do
Cell
you
number
represent here?
42.
Whom do you represent?
Appellant, my lordship, appellant. The insurance company, Disam Court has directed the insurance company to find out whether they have filed the challenged the order in MEC 178, my lordship. In connected matter,
We are
7.
beyond time, we will adjourn to the next, adjourn to date.
Any date,
11/9.
11.
12th of 12th May.
Yes.
Please, my lordship.
Cell number 43, 44 adjourned, cell number 45. Subramanya Hegde.
ಅವತ್ತಂತ ಆಗೋದಿಲ್ಲ. Case
13/9.
13/9. Tomorrow not possible. Yes.
46, 47 adjourned, cell number 48.
I'm for the.
Vasant Kumar HT, Akash VT, 18/9.
List on 18.
Lordship, I have one submission regarding serial number 39, Lordship.
Serial number?
39. It may be posted tomorrow.
ಹೋಗಿದೆ ಅಲ್ಲ ಅದು 39.
10/9.
No, Lordship, it is posted for 10/9. Morning, my colleague had submitted that it may be kept for tomorrow.
ಆಗೋದಿಲ್ಲ. Tomorrow not possible.
Lordship, it may be added for last.
No, sorry. Next case. Next case.
48, 18/9. 49 adjourned, cell number 50, Srinivas IIA,
Short date, short
In
date.
the list on date here.
28, 29.
29. Yes.
Cell number 51 adjourned, cell number 52.
My lords, in serial number 52 appear on behalf of the appellant, my lords.
List on same.
23/9.
Please, my lords.
53.
My lord, I'm appearing for respond number 1.
24/9.
24.
54, M. Shivaprakash, Anu Prabhakar Kulkarni, Hindu Shekhar.
Date here. List on
24/9.
ಯಾರೋ ಒಬ್ರು ಬೇರೆಯವ್ರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ.
25/9 ಅಂತ.
25.
55, Chetan B, Girish B Baldare. ಯಾರು ಇಲ್ಲ.
This is respondent file. ಅಯ್ಯೋ 1/2024 ಯಾಕೆ ಹಾಕಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಏನು ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ವಿ ಅಷ್ಟೇ. ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್
28.
20.
28 ಅಲ್ಲ 30. 39.
58 ಆಗಿದೆ
ಎಲ್ಲ ಆಗಿದೆ.
ಸರಿ.
I think this is serial number 17 and 18.
ಅದೆಲ್ಲ 2 weeks ಮಾರ್ನಿಂಗ್ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಸರ್.
Madam, ಮೇಡಮ್ ಐದನೇ ಸರಿ ಆಯ್ತು ಫೈನಲ್ ಹಿಯರಿಂಗ್. ಏಜ್ಗೋಸ್ಕರ ಬೇಗ ಇದ್ ಮಾಡಿದ್ರು.
ಯಾವುದು?
ಒಂದು 53
serial number 53. ಸರ್ ಡೇಟ್ ಅದು 24/9.
ನನಗೆ ಪ್ಲೀಸ್
ದಿನ ಹಿಂಗೆ ಆಗತ್ತೆ ಅಷ್ಟೇ, ನೀವು ಕಾಯ್ಬೇಕು, ಡೇಟ್ ಕೊಡ್ತೀವಿ.
ಅಲ್ಲ 23ಕ್ಕೂ ಮತ್ತೆ ಮುಂದೆ ಈಗ ಐದನೇ ಸರಿ ಆಯ್ತು ಮೇಡಮ್. ಅದು
ನಾನು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್.
ಸ್ವಲ್ಪ ಬೇಗ ಇದನ್ನ ಹಿಯರಿಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದ? ಅದು ಅವತ್ತಾದ್ರೂ ಬೇಗ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದ?
ಗೊತ್ತಿಲ್ಲ ಸರ್. ವಿಶ್ವ
ವಿಶ್ವ ಬಂದ್ರು ಅವರು ಪಾಪ. ನೀವು ಒಬ್ರು ಹೆಲ್ಪ್ ಮಾಡ್ತೀರಿ, ಬಟ್
ಹೌದು ಲಿಸ್ಟ್ ಆಗಿರ್ತಲ್ಲ ಮೇಡಮ್. ಮೊನ್ನೆ ಯಾರೋ ಅಂತ
ಅದಕ್ಕೆ PMC ಮೂಲಕ ಡಿಸೇಬಲ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಹಣ ಲಿಸ್ಟ್ ಮಾಡ್ಸಕ್ ಬರಲ್ಲ ಡಿಸೇಬಲ್ ಇದೆ ಅಂತ ಮತ್ತೆ ಇವತ್ತು 2 ಫೈಲ್ ತಗೊಂಡು ಇವು ಲಿಸ್ಟ್ ಯಾಕೆ
ನಮ್ದೆಲ್ಲ ಒಂದು ಮೆಮೋ
ಅದೇ ಇದು ಯಾಕೆ ಅಂತಂದ್ರೆ
ಯಾವ ನಿಮಿಷ
ಕೊಡ್ಸಿದ್ರು
ಆಮೇಲೆ
ನೋಡಿ ಲಿಸ್ಟ್
65 ಫೈಲ್ ಹಾಕಿದ್ದೀನಿ ಅವೇ ಇವೆ ಅದು ಇನ್ನ 20
ಲಿಸ್ಟ್
ನನ್ನ ಹತ್ರ ಇದಾವೆ
ಲಿಸ್ಟ್ ಆಗಿತ್ತಾರ ನೋಡು ಅಂದ್ರು ಇಲ್ಲ ಮೇಡಮ್ ಯಾವ್ದು ಮಾಡ್ಸಿಲ್ಲ ಮೇಡಮ್ ನಾನು ಏನ್
30 ಫೈಲ್ ಲಿಸ್ಟ್ ಆಗಿರ್ತದಲ್ಲ ಮೇಡಮ್ ಇದನ್ನ ಆಡ್ ಮಾಡಿದಾಗ ಇದು ತೆಗೆಯೋದು ಇದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂದಾಗ ಹಾಕ್ತಿರ ಅಂದಾಗ ಇಲ್ಲಿ ಇದಾಗ ಕೊಡಲ್ಲ 4 ಅಂತ ಅಂದಾಗ ಇದು ಹಾಕಿ ಇಲ್ಲ ಆಲ್ರೆಡಿ ಲಿಸ್ಟ್ ಪರೀಕ್ಷೆ ಮಾಡಿ ಮತ್ ಬಿಟ್ರೆ ಏನು ಮಾತಾಡಲ್ಲ ನಿಮ್ಮ ಮೊದಲನೇ ಬಂದಿದೆ 5 ನಿಮಿಷ ಸುಮ್ಮನೆ ಕೊಡ್ತೀನಿ ಫೈಲ್ ಅಂತ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ
ಲಿಸ್ಟ್ ಬಂದ್ ಜೊತೆ ಕೊಟ್ಬಿಡು ಲಿಸ್ಟ್ ಟು
ಒಂಥರ ಆಗೋಯ್ತು ನೋಡು ನನಗೆ ಏನಪ್ಪ ಇದು ಅಲ್ಲಿ ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಒಂದು 20 ಜನ ನಿಂತಿರ್ತಾರೆ ಮೇಡಮ್
ಕೇಳಿಸ್ಬಿಡಿ ನಾನು ಹೇಳೋದನ್ನ ಲಿಸ್ಟ್ ಬಂದು ನೀನ್ ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಡು ಪಬ್ಲಿಷ್ ಮಾಡ್ಕೋಬೇಕು ಅರ್ಜೆಂಟ್ ಲಿಸ್ಟ್ ಟು ನೀನ್ ಕಳ್ಸು ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೋಬೇಡ ಯಾವ್ದಾದ್ರು ರಿಪೀಟ್ ಇದ್ರೆ ಇದಕ್ಕೆ ಸೇರಿಸ್ಕೋಬಹುದು ನಮ್ಗೆ ಚೆಕ್ ಮಾಡ್ಕೊಳಕ್ಕೆ ನಿನ್ನೆ 6:15 ಇದನ್ನ ಮಾಡ್ದಾಗ
ಹೇಳಿ ಮೇಡಮ್ ನನಗೆ ಅದಕ್ಕೆ ನನಗೆ ಬಂದ್ಬಿಟ್ಟೆ ಅದಕ್ಕೆ ನಾನೇ ಬೈಕೊಂತ ಇಲ್ಲ ಮೇಡಮ್ ನಿಜವಲ್ಲೂ ಬೈಕೊಂತ ಇಲ್ಲ
ನಾನ್ ಬೈಕೊಂತೀನಿ
ಅಯ್ಯೋ ಬೈಕೊಳ್ಳಿ ಮೇಡಮ್ ಪರವಾಗಿಲ್ಲ ಬೈಕೊಳ್ಳಿ ಏನು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ನನಗೆ ಹೆಂಗ್ ಅನ್ಸ್ಬಿಡ್ತೇನೆ
ಮೇಡಮ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ತಂದಿಲ್ಲ ನಾವು ವಿಶ್ವಣ್ಣ ಇನ್ನೂ ಒಂದು ಪೋರ್ಟಲ್ ಮಾಡ್ತಾರೆ 5:15 ಕೊಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ನಾನೇನಾದ್ರು
ಈಗ 4668 ಇದೊಂದು 9th ಈಗ ಅದು ಹೋಯ್ತು 24ನೇ ತಾರೀಕು ಹೋಯ್ತು ಈಗ ಅದೇ ತಾತ ಗಲಾಟೆ ಇನ್ನು ಮುಂಚೆಗೆ ಹಾಕೊಡಿ ಅಂತ ಇವಾಗ್ಲೂ ಅಳ್ತಾ ಇದೆ ತಾತ ನಾವ್ ಏನ್ ಮಾಡೋಣ ಬರ್ಲಿ ಬಿಡಿ ಮೆಮೋ ಮೂವ್ ಮಾಡಿದ್ರೆ ಪರವಾಗಿಲ್ಲ ಯಾರಾದ್ರೂ ಬಂದ್ ಕೇಳಿದ್ರು ಮೆಮೋ ಇಲ್ದೆ ಯಾವ್ದು ಹಾಕಕ್ ಹೋಗ್ಬಿಡಿ ಈಗ ಯಾಕಂದ್ರೆ ಇವಾಗ ಅಂತವೆಲ್ಲ ಹಾಕಿ ಪರವಾಗಿಲ್ಲ ನಾನು ಹೇಳೋದ್ ಈ ತರ ಇವ್ರು ಹೇಳಿದ್ರು ಅವ್ರು ಹೇಳಿದ್ರು ನಾಟ್ ಮೆಮೋ
ಮೇಡಮ್ ಯಾವ್ದು ಹಾಕಿಲ್ಲ ಮೇಡಮ್ ನಾನು ಅವರು ಲಾಯರ್ ಹತ್ರ ಒಂದು ಕೊಡ್ಸಿದ್ರಂತೆ ಬಂದಿತ್ತಾನ ನೋಡಿ ಅಂದ್ರು ಡಿಸೇಬಲ್ ಅಂತ ಅಂದ್ರು ಇವ್ರು ಬರಲ್ಲ ಅಂದ್ರು ವಿಶ್ವಣ್ಣ ಮೇಡಮ್ ಸರಿ ನಾನು
ಅನಿತಾ ಹಂಗೆ ಎಲ್ಲ ಈ ತರ ಎಲ್ಲ ಮಾಡಕ್
ನೋಡು ಅಂದ್ರು ಮೇಡಮ್ ಬರಲ್ಲ ಅಂತ ಮೇಡಮ್ ಹೇಳ್ದೆ ವಿಶ್ವಣ್ಣ ಯಾಕೆ ಹಾಕಲ್ಲ ಅಂತ ಕೇಳ್ದೆ ವಿಶ್ವಣ್ಣ ಅದಕ್ಕೆ ಯಾವ್ದು ಇಲ್ಲ ಮೇಡಮ್ ಕೊಡ್ತೀವಿ
ಹೋಗ್ ತಂದ್ಬಿಡೋಗಿ ಇವಾಗ ಲಿಸ್ಟೇ ತಂದ್ಕೊಟ್ಬಿಟ್ರಲ್ಲ ಅವರು ನಾನು ಹೋಗಿ ಕೇಳ್ಕೊಂಡ್ ಬರೋಷ್ಟೊತ್ತಿಗೆ ತಗೊಂಡ್ಬಂದಿರಿ ನೀವೇನ್ ಗೊತ್ತಾ ಈ ಫೈಲ್ ಹಾಕಿ ಬಾಕ್ಸ್ ತರಕತ್ತಿದೆ ನಾನು ನಾಳೆಯಿಂದ ಹೇಳಿದೀನಿ ಲಿಸ್ಟ್ ಇತ್ತು ಜೊತೆಗೆ ಬರುತ್ತೆ ಬ್ರಾಂಚ್ ಅವ್ರಿಗೂ ಹೇಳಿದ್ದೀನಿ ನಾಳೆಯಿಂದ ಕೊಡ್ತಾರೆ ಅದು ಡೇಟ್ಸ್ ಕರೆಕ್ಟ್ ಆಗಿ ಟ್ಯಾಲಿ ಆಯ್ತಪ್ಪ AKCಗೆ ನಮ್ದು
ಇಯರಿಂಗ್ ಫೈಲ್ ನೋಡಕ್ ಬಂದೆ ಮೇಡಮ್ ಅಗರ್ಬಿಲ್ ಹಂಗೆ ಇಯರಿಂಗ್ ಫೈಲ್ ಅಲ್ಲಿ
TCR ಗಳನ್ನ ಒಂಚೂರು ನೋಡ್ಬಿಟ್ಟು ಹಾಕ್ರಪ್ಪ ಆಮೇಲೆ ನಾವು ಸರಿ ಮಾಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ ನೀನ್ ಇವತ್ತು ಅಷ್ಟೇ ಎರಡರಲ್ಲಿ TCR ಕೆಬಿಲೋ TCR ಕೆಬಿಲೋ ಅಂತಿದ್ದೀರಾ ಕಾಮನ್ TCR TCR ಇಂದ ಹುಡ್ಕೊಂಡ್ ಬರೋಣ. ಅವ್ರಿಗೂ ನಾನು ಫೋನ್ ಮಾಡಿ ಹೇಳಿದೀನಿ. ಯಾರ್ಗೆ? ಪೆಂಡಿಂಗ್ ಅವ್ರಿಗೆ ಫಸ್ಟ್ ಫೈಲ್ಸ್ ನ ಬೇಗ ಕಳ್ಸಿ ಅಂತ. ಬಂದಿದೆ, ಲಿಸ್ಟ್ ಆಗಿದೆ. ಇದು ರಿಸರ್ವ್ದು ಅಲ್ಲಿ ಇಟ್ಟಿರ್ತೀನಪ್ಪ, ಆಮೇಲಿಂದ ಬರೀವಂತೆ. ಇದು ಖುಷಿ, ಇದು ಏಕೆಸ್, ಇದು ಇದು ಪೇಪರ್ ಬುಕ್ಕು.
ಮಾತ್ರ ಕೃಷ್ಣಮೂರ್ತಿ ಇದೆಯಲ್ಲ, ಫಸ್ಟ್ ಹಾಕಿಲ್ಲ ಬರ್ಕೊಡಿಲ್ಲ ಅಂದ್ರೆ ಬೇಡ ಅಂತ
ಅವಳು ಹೇಳಿದ್ದೇನ್ ಗೊತ್ತಾ, ಅದಕ್ಕೆ ಈ ನೇಮ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಇದಕ್ಕೆ ಆ ನೇಮ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅಂದಿದ್ದು ಅಮ್ರಾಮ. ವಿಶ್ವ, ಆಮೇಲೆ ಇನ್ನೊಂದು ಹೇಳ್ಬೇಕು ನೋಡಿಲಿ, ಇವಾಗ ಅಡ್ಮಿಷನ್ ಇವತ್ ಲಿಸ್ಟ್ ಇಂದ ನೋಡ್ತಗೋ ಇಲ್ಲಿ ಬಾಯ್. ಇವತ್ತೇನ್ ಹೇಳ್ಬೇಕು ನೋಡಿಲಿ ವಿಶ್ವ, ಅಡ್ಮಿಷನ್ ಹೆಂಗ್ ಬರುತ್ತಿದೆ ಅಂತ ಆರ್ಡರ್ಸ್ ಹಾಕ್ಬೇಕು ತಾನೆ ಅಂತ ನಾನು RFP ಅವ್ರಿಗೆ ಹೇಳಿದ್ರೆ ಅವ್ರು ಅದೇ ಅವ್ರೇನ್ ಹೇಳದೆ ಫಸ್ಟ್ ಫೈಲ್ ಯಾವ್ದಿದೆ ಅದನ್ನ ಬೇಡ ಅಂತ ಬಂದು ಹೇಳಿ.
ಅಲ್ಲ ಮೇಡಮ್, ಯಾವಾಗ ಕನೆಕ್ಟೆಡ್ ಇನ್ ಕೇಸ್ ಮೇಡಮ್ ಆತರ ಇದ್ದಾಗ, ಇವಾಗ ನೋಡಿ ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಒಂದು ಅಡ್ಮಿಷನ್ ಒಂದು ಆರ್ಡರ್ಸ್ ಇದಲ್ಲ ಮೇಡಮ್, ಆರ್ಡರ್ಸ್ ಹಾಕಿದ್ರೆ ಒಂದು ಫೈಲ್ ಅಡ್ಮಿಷನ್ ಇರುತ್ತೆ ಅವಾಗ. ಇವಾಗ ಯಜ್ಞ ಹಾಕಿಲ್ಲ ಅಂತ ಕೇಳ್ಬಿಡ್ತಾರೆ.
ಹೆಂಗ್ ಮಾಡೋದು ಗೊತ್ತಿಲ್ಲ.
ಮೇಡಮ್ ಆರ್ಜೆ ಮತ್ತೆ ಅಡಿಷನಲ್ ಆರ್ಜೆ ಬರ್ತಾರೆ.
ಯಾರು ಅಡಿಷನಲ್ ಆರ್ಜೆ? ಯಾರು? ಗಣಪತಿ ಭಟ್ಟ. ಅಲ್ಲ, ನೀವು ಲಿಸ್ಟ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಹಾಕ್ಬಿಡಿ, ಲಿಸ್ಟ್ ಟು ಫೈನಲ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಆಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ. ನನಗೆ ಫೈಲ್ ಕಳಿಸ್ಬಿಡಿ, ನಾನು ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇದಿಷ್ಟು ಏಕೆ ಸಿತ್ತು ಖುಷಿ, ಇದು ಬೇಡ. ಇಲ್ಲ, ಇನ್ನೊಂದು ಡಿಜಿಟಲ್ ಇದರಲ್ಲಿ ಎಷ್ಟೋ ಹೋಗ್ತಿದ್ದಾರೆ. ಇನ್ನೊಂದು
ಯಾವ್ದೋ ಒಂದು ಏರಿ ಮೇಲೆ
ಇವ್ರು ಹೋಗಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ ನೋಡಪ್ಪ ಯಾರಾದ್ರು ಅವರು.
ದೊಡ್ಡೇಗೌಡ್ರ
ಇದು 54 ಅಲ್ಲಿ ಯಾವ ಕೊಟ್ಟಲ್ಲಿ ಟೋಟಲ್ 5 ಪೇಪರ್ಸ್ ಕೊಟ್ಟು ಹೋಗಿದ್ರು ಅವರು ಅದನ್ನ ತಗೊಂಡು ಹೋಗ್ತೀವಿ. ಆರ್ತಿ ಇವ್ರು ಟೋಟಲ್ 5 ಅಂದ್ರೆ ಲೋಕೇಶ್ ಬಂದ್ರೆ ಇದು ಲೋಕೇಶ್ ಬಂದ್ರೆ ಇದು ಕೊಡ್ಬೇಕು. ಇದು ಎಷ್ಟು ತೆಗ್ದಿರೋದು ಈ 525 ಅದ್ರ ಜೊತೆ ನೀಟಾಗಿ ಕಟ್ಬೇಕು ಅದನ್ನ. ಇದು ಹುಷಾರಪ್ಪ ಇದು ಹಿಂಗೆ ಇರ್ಲಿ ಅದಷ್ಟೇ ಕಟ್ಬಿಟ್ಟು ಅದ್ರ ಮೇಲೆ ಇಲ್ಲಿ ಮುಂದೆ ಇಟ್ಟಿದೆ ಅಥವಾ ಒಳಗಿಟ್ರು ಆಯ್ತದೆ. 9th ಬಾಕ್ಸ್ ಕಟ್ಬೇಕು ಒಳಗಿಟ್ಬಿಟ್ಟಿದ್ದೇನೆ ಅದನ್ನ ಮಾತ್ರ ಅದನ್ನ ಅಷ್ಟು ಹೊರಗಡೆ ಇಟ್ಬಿಡಿ. ಬೆಳಿಗ್ಗೆ
ಕೊಟ್ಟಿಲ್ಲ ನಾನು ಫೈಲ್ ಕೊಟ್ಟು ರೌಂಡ್
ಭಾಗ್ಯ ಮಾಡಂಗ್ ಕೊಡ್ಲಾ ಇಲ್ಲ ನೀವೇ ಮಾತಾಡ್ಕೊಡ್ತೀರಿ. ಏನು ತಪ್ಪಾಗಿಲ್ಲ ಅದ್ರಲ್ಲಿ. ಸರಿ ಇದ್ರಲ್ಲಿ ಅವ್ರು ತೋರ್ಸಿದ ಅಂತ ನನಗೆ ಕೇಳಿಸಿದ್ರೆ ಈಗ ಕಾಲೇಜ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ಅಷ್ಟೇ ಅಲ್ಲ ಬರಿಬೇಕು
ಇದು ಮೆಸನ್ ತೆಗಿಲ್ಲಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ಬೇಕು. ಇದೇ ತರ ನಾವು ಕೇಳ್ತಿದ್ದೀವಿ. ಅದಾದ್ಮೇಲೆ ಇದು
Connected ಇದೆ, TCR ಇದೆ.
ಟೇಬಲ್ ಒಂಚೂರು ಎತ್ತರ ಇದೆ, ಎತ್ತಿ ಹೋಗ್ತಾ ಇದೆ. ಯಾರು 8651 ಅಲ್ಲಿ
ಸರಿ ಅದನ್ನೇ ಫಸ್ಟ್ ಮಾಡ್ಬೇಕಲ್ಲ. 417
ದುಡ್ಡು ಕೊಟ್ರೆ ಅದು
1515 ಏನು ಆರ್ಡರ್ ಆಗಿಲ್ಲ
along with synopsis ಅಂತಾರೆ ಪೇಪರ್ ಮುಟ್ಟಿದೆ. ಪ್ಲಾನ್
ಇದೆಲ್ಲಿದೆ ಎಲ್ಲ ಬಾಕ್ಸ್
ಸೀರಿಯಲ್ ಗೊತ್ತು ಫರ್ದರ್ ಏನು ಹಾಕಿದ್ರು ಸಿಗ್ಲಿಲ್ಲ ಕರೆಕ್ಟ್ ಫರ್ದರ್ ಏನು ಕ್ರಿಯೇಟ್ ಅಕೌಂಟ್ ಅಂದ್ರೆ 468 ಅಲ್ವಾ ಇಲ್ಲ 668 ಪೇಮೆಂಟ್ ಅದೇ
ಬಿಡು ಆಮೇಲೆ ಕ್ಲಾಸ್ ಎತ್ಕೊಂಡು ಟ್ರೈನ್ ಕೊಡ್ತಾರೆ ಅಲ್ಲೇ
ನಿಮ್ಗೆ ವೈಟ್ ಆಗ್ತಿರಲ್ಲ ಅದನ್ನ ಹೆಂಗ್ ದೊಡ್ಡ
ಹೂನಪ್ಪ
ನೈನ್ ಜೊತೆಗೆ
ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲ ತಂದು ಯಾವ್ದಾನ ಅದು ಬಂದಿದ್ದೀನಿ SR ತಂದಿದ್ದೀನಿ ಯಾವ್ದು ಬಂದಿಲ್ಲ ಸಾಮಾನ್ಯ ಹೋದ್ರೆ
TCR ಎರಡು ಇದೆಯಪ್ಪ 4668 2879 TCR ತಗೊಂಡೋಗ್ತಾರಲ್ಲ ಇಟ್ಕೊಂಡಲ್ಲ
ಗುಸಾಮಿ ಬರ್ಲಿಲ್ಲ ನಾನೇ ಬರ್ತೀನಿ ಈಗ ಬಂದ್ರೆ ಕಾಂಟ್ರಾಕ್ಟಿಂಗ್ ರಾತ್ರಿ ಕೇಳ್ಕೊಂಡು ಒಂದು 10:30 ಒಳಗೆ ಫೋನ್ ಮಾಡಿ ಸ್ವಾಮಿ ನಂಬರ್ ಐತೆ ಅಂತ ನಾನು ಕೇಳಕ್ಕಾಗಲ್ಲ ಬುಕ್ಕೆ ಬರಲ್ಲ
ಇದೆಲ್ಲ ಹಾಕ್ಬೇಕಾ ಇದೊಂದು ಹಾಕ್ಬೇಕಾ ಗೊತ್ತಿಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ ಇಲ್ಲೇ ಕಟ್ಟಿಕ್ ಬಿಡೋದು. ಒಬ್ಬರ್ಲಿ ಇರಿ, ಹಿಂಗೆ ಇರ್ಲಿ ಸರ್, ಹಿಂಗೆ ಇಟ್ಟಿರ್ತೀನಿ.
ಇಲ್ಲೊಂದಿದೆ
ಬೇಡ ಅಲ್ಲೇ ಕಟ್ತೀನಿ. ಇದು ಫಸ್ಟ್ ಸೆಟ್, ಇದು ಸೆಕೆಂಡ್ ಸೆಟ್. ಫಸ್ಟ್ ಫೈಲ್ ಮಾತ್ರ ಕನೆಕ್ಟೆಡ್ 2 ಹಂಗೆ ಇಟ್ಟಿದ್ದೀನಿ. ನಾನು ಇಲ್ಲೇ ಇರ್ತೀನಿ, ಅದು ಎಂಟ್ರಿ ಮಾಡ್ತಾ ಇರ್ತೀನಿ, ಬರ್ತೀನಿ ಪಕ್ಕದಲ್ಲಿ ಇರಿ. ಅಂದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಬೇಕಾ
ಹಂಗೆ ಇದೆ ಅನ್ಸುತ್ತಲ್ವಾ?
ಕನೆಕ್ಟೆಡ್ ಇಲ್ಲ ಇಲ್ಲ ಕನೆಕ್ಟೆಡ್
ಸೆಪರೇಟ್ ಮಾಡಿ ಇತ್ತಲ್ಲ ನಾನು ಬಾಕ್ಸ್ ತೆಗ್ದಾಗ. ಎಲ್ಲ ಹೋದ್ರಲ್ಲ ಕೇಳ್ಬಿಟ್ವಾ ಏನೋ ಈ ತರ ಹೇಳ್ತಾರೆ ಮೇಡಮ್ ಅವರೆಲ್ಲ ಬಂದಿದ್ದಾರೆ, ಅವರು ಅವತ್ತು ಬಂದಿದ್ದಾರೆ. ಏನ್ ಗೊತ್ತಾ, ಇಷ್ಟು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂದ್ರೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ ಹಂಗೆ
ಅದಕ್ಕೇನಂದ್ರು ಏನಂದ್ರು
ಅದಕ್ಕೆ ಅವರು ಕೇಳಿದ್ರೆ ಇದು ತಪ್ಪು ಅಂತ ಅನ್ಸುತ್ತೆ ಅವ್ರಿಗೆ. ಇದು ಇಷ್ಟಿಂದ ಯಾಕೆ ಇಟ್ಬಿಟ್ರು? 19 ಇಂದ ಇದೆ, ಯಾಕೆ ಇಟ್ಬಿಟ್ರು?
ಕ್ರೌನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ 19 ಇಂದ.
ಅದಕ್ಕೆ ಇವಾಗ ಏನ್ ಮಾಡ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ. ಅವರು ಯಾರು
822
ಅವರೆಲ್ಲ ಬಂದು ಇದು ರೀಕಲ್ ಆಗಿದೆ ಬಂದಿದ್ಯಾ ಅಬ್ಜೆಕ್ಷನ್? ಹಲೋ ಬಾಕಿ ಇದಾರಪ್ಪ ಅದನ್ನೇ ಮೇಡಮ್ ಇದ್ರೊಳಗಡೆ ಕಾಪಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ 1000 ಜಾಸ್ತಿ ಇಚ್ಚಿದ್ರೆ ಕೊಡೋದು ಅಂತದನ್ನೆಲ್ಲ ಕೊಡ್ಬೇಕಲ್ವಾ ಇವರು? ಯಾಕೆ
ಕೊಡ್ಬೇಕು, ಅಲ್ಲೇನು ಪ್ರಾಬ್ಲಮ್?
further.
ಯಾವುದು ಸಪರೇಟ್ ಮಾಡಿದ್ದೀರಲ್ಲಿ ಲಾಸ್ಟ್ 4th to 6th ಅಷ್ಟೇ ಇರುತ್ತೆ. 3rd 4th
ಅಷ್ಟೇ. ಎರಡು ಲಾಸ್ಟ್ ಅಲ್ಲಿ
ಬಟ್ ಅದು 14 ಮಾಡ್ತೀನಿ ಅಲ್ಲೇ ಇದ್ರು ಅವರು ನಮ್ಗೆ ಚೇರ್ ಬೇಕಪ್ಪ ಅಂತ ನಾನು ಎಲ್ಲೂ ತರಕಾಲಕ್ಕ ನಮ್ ಕೊಟ್ಟಲ್ಲ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬೋದು ನಾನು ಒಂದ್ ದಿವ್ಸಕ್ಕೆ ಬರೋದು ಎಲ್ಲಿ ತರೋದು ಬೇರೆ ಹುಡುಗ ಕೇಳೋದೇ ಇಲ್ಲ ಚೇರ್ ಹಂಗಿರ್ಬೇಕು ಕೂತ್ಕೊಳಕ್ ಹಿಂಗಿರ್ಬೇಕು ಸಣ್ಣ ಬದೈತೆ ನಾನು ಎಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ ಗೊತ್ತಿತ್ತು ಹೇಳಿ ಮನೇಲಿ ಹಂಗಿದ್ದರು ಅವ್ರ ಮನೆಯಿಂದನೇ ಒಂದ್ ಚೇರ್ ತಂದಾಕಿ
ಅಲ್ಲಿ ಟೋಟಲ್ ಅಟೆಂಡರ್ಲೆ ಎಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ DNP ಮಾಡೋದು ಮೇಡಮ್, ಅದನ್ನ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಸಿದ್ಮೇಲೆ ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಆಗಿದೆ. ಅಲ್ಲೇ DNP ಆಗ್ಬಿಟ್ಟಿದೆ. 450.
ನಂಗೂ ಹೋಗಿದ್ದಲ್ಲ ಕ್ಲಾಸ್ ಎತ್ಕೊಂಡು ಹೋಗ್ಬೇಕು. ಯೂನಿಫಾರ್ಮ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬಿಡ್ಲಾ? ಮಾಡ್ಕೊಂಡು ಬ್ಯಾಗ್ ತಂದ್ಬಿಡ್ತೀನಿ. ಹೀಗೆ ಆಗ್ಬೇಕು. ಅಲ್ಲ
last year ಅಂದ್ರೆ fast but 9 minutes. ಬುಕ್ ಕೆಳಗಡೆ ಹಾಕಿದೀನಿ ಪರ್ದರಿ ಬರೀ ಫಸ್ಟ್
ಅದ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು. ರಿಸರ್ವ್ ಸಿಂಗಲ್ಲ. ಇದು ಹಂಗೆ ಕೊಟ್ಬಿಡಿ, ಟ್ರೈನಿಂಗ್ ಬಂದು ಇದು ಹಿಂಗೆ ಅಂತ ವಾರ್ನಿಂಗ್.
ಭಾಗ್ಯ ಮೇಡಮ್ ಏನು ಕೇಳ್ಬೇಕು ಡೌಟ್ ಇದೆ
ಅಷ್ಟೇ, ಅಲ್ಲೇ ನೋಡ್ಬಿಟ್ಟಿದ್ರೆ ಆಗೋಗಿರೋದು.
ನನ್ಗ ಅವ್ಳು ಆತರ ಹೇಳಿಲ್ಲ, ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ. ಅದು ಮಿಷನ್ ಚೇಂಬರ್ ಇಂದ ಪ್ರಸಾದ್ ಸರ್ ಬಂದು ಕೇಳಿದಕ್ಕೆ ಅದು ಹಾಕಿದ್ದು, ಇಲ್ಲ ಅದು ಆಗ್ತಿರ್ಲಿಲ್ಲ.
ಅಭಿನಪ್ಪ ಸಾಹೇಬ್ ಇದ್ರಲ್ಲ, ಅವಾಗೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟಿದೆ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಒಂದು ಹಾಕೊಂಡು ಮಾಡಿದ್ರು.
1453 15 ಹಂಗೆ ಇದೆ connected file ಬೇರೆ G5 ಏನಿಲ್ಲ ಹಾಗೆ textual ಆಯ್ತು.
ಇಲ್ಲ ಮೇಡಮ್ ಇನ್ನು ಹೊರಟಿಲ್ಲ, ಇವಾಗ ರೆಡಿ ಮಾಡ್ತಾ ಇದ್ದೀವಿ, ಬಾಕ್ಸ್ ರೆಡಿ ಮಾಡ್ತಾ ಇದ್ದೀವಿ.
2 ನಿಮಿಷ ಆಗುತ್ತೆ ಅಂತ ಇನ್ನೊಂದು 10 ನಿಮಿಷ ಆಗುತ್ತೆ.
ಮೇಡಮ್ ಹೊರಡ್ತಾ
ಇನ್ನೊಂದು 10
ರೆಡಿ
ನಿಮಿಷ
ಮಾಡ್ತಾ
ಆಗುತ್ತೆ,
10 ನಿಮಿಷ ಆಗೋಣ. ಇನ್ನು ರೆಡಿ ಆಗಿಲ್ಲ ಅಂತ ಮೇಡಮ್, 10 ನಿಮಿಷ. ಸರಿ ಮೇಡಮ್,
ಇದಾದ್ಮೇಲೆ further hearing file the first second set
ಕೆಳಗಡೆ.
10 ಟೋಟಲ್ ನಂಬರ್ ಹೇಳಿ ಹೇಳ್ಬಿಡ್ತೀನಿ ಮಾಡ್ಕೊಂಡು ಲಾಸ್ಟಿಂದ 4668 5548 ಇಲ್ಲ 4668 ಫರ್ದರ್ ಏನಿಲ್ಲ ಅಷ್ಟೇ ಫರ್ದರ್ ಏನಿಲ್ಲ ಇದಕ್ಕೆ ಪ್ಲಾನ್ ಅದಾದ್ಮೇಲೆ 554 ಬೆಂಗಳೂರಲ್ಲಿ ಇಲ್ಲ ಟಿಪೇಶಿ ಫೋನ್ ಹೋಗ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ. ಇನ್ನು ಈರಿಡೋದನ್ನ ಅಲ್ಲಿ ಕೆಳಗಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈ ಮಧ್ಯಕ್ಕೆಲ್ಲ ಬೆಳಗ್ಗೆ ಈ ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಸೇರಿಸ್ಕೋಬೇಕು, ಲಾಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಸೇರಿಸ್ಕೋಬೇಕು. ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ 3 ಫೈಲ್ ಹಾಕಿದೀವಿ. ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ 3 ಫೈಲ್ ಹಾಕಿದೀವಿ. ಎರಡು ಫೈಲ್ಗೆ ಆಗ್ತದೆ ಅಷ್ಟೇ. ಟೋಟಲ್ ನಂಬರ್ ಆಫ್ ಫೈಲ್ಸ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಅಲ್ವಾ, ಹೇಳ್ಬೇಕಾದ್ರೆ ಯಾಕೆ ಅಲ್ಲ ನಂಬರ್ ಆಫ್ ಫೈಲ್ಸ್ ಎಷ್ಟು ಹಾಕಿದೀವಿ ಅಂತ. 1 2 3 19 ಫೈಲ್ ಇರ್ಬೇಕು ಅನ್ಸುತ್ತೆ. 19 ಅದೇ ಫರ್ದರ್ ಹಿಯರಿಂಗು ಸೇರಿಸ್ಕೊಂಡ್ಯಾ? ಸುಶ್ಮಿತಾ ಜಿ, ರವೀಂದ್ರ ಪಿ, ಅವನು ಪರ್ಸನಲ್ ಆಗಿ ಒಂದು ಲೆಟರ್ ಬರ್ದಿದ್ದಾರೆ. ಹಲೋ, ಒಂದು ಕೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅವ್ರ ಹೌದಾ? ಹಾ ಮೇಡಮ್ ಓದ್ತೀವಿ ಫೈಲ್ ಆಯ್ತು. ಅವ್ರನ್ನ ಡೌಟ್ಸ್ ಕೇಳಿದ್ರೆ ಮೆಡಿಟ್ ಮಾಡಿದೆ ಬಂದ್ರೆ ಮಾಡಕ್ ಕೇಳಪ್ಪ. ಅದೇನೋ ಲೆಟ್ರು ಬರ್ದ್ಬಿಟ್ಟಿದ್ದಾನೆ. ಅದಕ್ಕೆ ಅದನ್ನ ಅದೇನೋ ಮಾಡ್ತೀನಿ ಅಂದ್ರಪ್ಪ, ಅವಾಗ ಜ್ಞಾಪಿಸಿದೆ ಆಮೇಲೆ 27/9 ಇದೆ. ಆ 27/9 ಬರ್ಕೋ ಅದನ್ನ. ಯಾವ ತಲೆಯಲ್ಲಿ ಇಟ್ಕೊಳ್ಳೋದು, ಯಾವ್ದು ಓದಿಸ್ಕೊಳ್ಳೋದು ತಲೆಯಲ್ಲಿ. ಟು ರಿಮೈಂಡ್ ರೆಡ್ ಪೆನಲ್ಲಿ ಬರ್ದ್ಬಿಡಿ. ರಿಮೈಂಡ್ ಕೇಸ್ MJ ಆನ್ ಆ ಕೇಸ್ ನಂಬರು. ಅಂದ್ರೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಅದು ಆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು. ಆಯ್ತಾ? ಅದನ್ನ ಅವಾಗ ಮಾಮೂಲಿ ನೋಟಿಸ್ ಮಾಡಿದ್ರೇನೆ ಆಗತ್ತೆ. ಅದನ್ನ ಮೇಡಮ್ ಅದನ್ನ ಸೈನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದನ್ನ ಬರೀ ನೋಟಿಸ್ ಅಂತ ಹೇಳಕ್ಕೆ. ಬ್ರಾಂಚ್ ಅವರು ಹಂಗ್ ಬಂದು ಕೇಳಿದ್ರು, ಹಿಂಗ್ ಬಂದು ಕೇಳಿದ್ರು, ಇಷ್ಟು ಫೈಲು ಇದೆ. ಏನ ಮೇಡಮ್ ಅದನ್ನ ಸಪೋರ್ಟ್ ಮಾಡಿಲ್ಲ ಚೆನ್ನಾಗಿ ಬೈತಾರೆ ಕಲಿಸ್ತಾರೆ. ಒಂದೇ ಸಮ ನನ್ನ ಮುಖ ನೋಡ್ತಾರೆ ಬೈತಾರೆ, ಮುಖ ನೋಡ್ತಾರೆ ಬೈತಾರೆ. ಮತ್ತೆ ನಾನೇನೋ ಕರ್ಕೊಂಡ್ಬಂದೆಲ್ಲ ಹೇಳಿದ್ದಂಗೆ. ಹಾ ಅದೇ ಇವಾಗ ಹೇಳಿದ್ರೆ ನಮ್ಗೆ ಕರ್ಕೊಳ್ಳೋಷ್ಟು ಟೈಮ್ ಆಗ್ತಿಲ್ಲ. ಚೆಕ್ ಮಾಡ್ತೀನಿ.
ರವೀಂದ್ರ ಪಿ ಅಂತ ಜ್ಞಾಪಕ ಇರ್ಲಿ. ಅವನೇನೆ ರವೀಂದ್ರ ಪಿ. ಸುಷ್ಮಿತಾ ಅವಳು ಗೋಪಾಲಕೃಷ್ಣನ್ ಮಗಳು. ಯಾರ ಆಫೀಸು ಅಂತ ಕೇಳಿದ್ರು. ಸುಷ್ಮಿತಾಜಿ ಗೋಪಾಲಕೃಷ್ಣನ್ ಮಗಳು ಅನ್ನೋದು ಅಷ್ಟೇ ಗೊತ್ತು ನನಗೆ. ಅವ್ರ ಆಫೀಸಿಗೆ MV ಕೇಸಿಗೆ ಆ ಹುಡುಗಿ ಗೋಪಾಲ್ ಕೃಷ್ಣ ಅಂತ ಬರುತ್ತಲ್ಲ. ಹಲೋ ಹಲೋ ಅಯ್ಯೋ ಇಲ್ಲೇ ಬಿದ್ದಿದ್ದೀನಿ. ಎಲ್ಲ ಸೈಲೆಂಟ್ ಅಲ್ಲಿ ಇರುತ್ತಲ್ಲ. ಹೋಟೆಲ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ. ಅವಾಗ ನೀನ್ ಬರಿತಾ ಇದ್ರೆ ಜ್ಞಾಪಕನೂ ಇರುತ್ತೆ. ಸೈಟೇಷನ್ಸ್ ಬೈ ಎ ಅಂತ ಹಾಕಿರೋದು ಅಪಲೆಂಟ್. ಇವತ್ತು ಬಟ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ ವೆಂಕಟರೆಡ್ಡಿ. ಅವ್ನ್ ಬಯ್ಯಾರೆಡ್ಡಿ ನಂದು ಅಂತ ತೋರಿಸ್ತಾ ಇದ್ದ. ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಹೆಂಗ್ ಹೇಳೋದು? ವೆಂಕಟರೆಡ್ಡಿ ಹೆಸರಾಗ್ತದೆ. ಅದ್ರ ಸೀನಿಯರ್ ಅದೇ ಅನ್ಸುತ್ತೆ. ಇಬ್ರು ಬಾಯ್ ತೆಗಿತೀನಿ. ಅಲಾಂಗ್ ವಿತ್, ಯಾಕಂದ್ರೆ ಮೇಡಮ್ ಇದು ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂತಿರೋದು. ಇಬ್ಬಿಬ್ರು ಇದ್ ಮಾಡಕ್ ಆಗಲ್ಲ ನಾವು. ವೆಂಕಟರೆಡ್ಡಿ ಯಾಕ ಅವ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ವು ನಮ್ಮ ಬಾಯ್. ವೆಂಕಟರೆಡ್ಡಿ ಪಾಪ ಹೆಂಗೋ ಇದು ಇವ್ರಿಗೂ ಇವಾಗ ಬರ್ಕೊಂಡು ನೀಟಾಗಿ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಿದೆ ಅಲ್ವಾ. ಇಷ್ಟ ಮಾಡಿದ್ರಿ ನೀನ್ ಹತ್ಕೊಂಡಾದ್ರು ಹತ್ಕೋಬೇಕು. ಇಲ್ಲಾಂದ್ರೆ ನಾವು ಬಡ್ಕೋಬೇಕಿತ್ತು. ನಿಜವಾಗ್ಲೂ ಆಗ್ತಾ ಇರ್ಲಿಲ್ಲ ಇದು. ಇದು ಲಿಸ್ಟ್ ಟು ಬೇರೆ. ಇವಾಗ ಎಷ್ಟು ಬರ್ದಿದ್ಯಾ ನೀವ? ಇದು ಇನ್ನ ಅಯ್ಯೋ ಯೂಟ್ಯೂಬ್ ಲೈವ್ ಆಗಿದೆಯಲ್ಲ, ಇದು ಆಫ್ ಆಗಿಲ್ಲ.